Hey, happy Wednesday. Can you believe it's Wednesday? Hey, everybody. Hey, welcome. Let me go up into the chat real quick and see who we got. Lee's here. First up. Ooh, he's brought in the eggs, toast, bacon, waffles, all of it. Plenty of coffee. Thank you. I just filled my cup up with some coffee. Coffee. Hey, Lauren. Good to see you back, ma'am. Hey, Miss Spins. Sweet Lee. Gail. Hey, Gail. Henny. Every time I see Henny's name, I want to say, the sky is falling. I know wasn't that Henny Penny? Or something like that. The sky is falling. Let me see. I know, right, Gail? Gail says, I can't believe March is almost over. I know it. March is almost over. Do not be surprised if one day I add the snack table to the breakfast buffet. No worries, Lee. No worries. Lee's like, I'm going to one and done it. Like, I'm just going to do it like one time and then, yeah. I got things to do, people to see. I just appreciate it. I just appreciate that you come in at all and throw us even a bone, you know? Thank you for just even throwing a bone. But yeah, Lord knows I have to have my coffee. You guys, I don't know what is up with my French vanilla creamer. I don't know. I'm just not feeling it the last few days. I'm like, I always buy the French vanilla. Hey, Steph. I always buy the French vanilla, like 0 sugar, right? I know a lot of you guys out there are like, bleh. But, you know, sometimes a girl's got to do what a girl's got to do when a girl's gaining too much weight. You know what I'm saying? So, wait, what? Hold on a second. Oh, you guys, we got to hurry up because the jury is already deliberating on the Blake Scanlon trial. Wow, you guys. We're only on day 2. Okay, we're a day behind. But I told you guys this was going to be a super quick trial, did I not? We are live, Margaret. This thing is on. Here, let me see. Don't let me bust your eardrums, but look. Could you guys hear that? Is this thing on? I know, right? They already are in. I just got news just like 1 minute ago. Breaking. Jury began deliberating at 11:11 a.m. Eastern Time in the Blake Scanlon trial.
Holy cow. Yeah, I know. What was that super duper loud? The thump, 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 Margaret? I'm sorry if I scared everybody. Could you guys hear the thumping on the microphone? Pop, pop, pop. Hold on. I got to get a drink of coffee. We got to roll. We got to roll. We got to roll. Good morning, Kel. I love you, dear. Miss Kel, Miss Kel, Miss Kel, Miss Kel. Nonsense of a no nonsense trial for sure, right? Steph says, Gail, hey Gail, I'm all right. I'm annoyed not knowing what the game plan is. What's wrong with me? When can I head home? I just want this over with and to focus on my business. So, Steph, I know that you have been patient. And your patience is wearing thin, but just keep up what you're doing. You got to get better. Got to get things figured out. And then just keep in mind when you are at home working the business and things are back to normal, it's going to seem like it wasn't that long ago. You know what I'm saying? Like, wow, that was the longest month of my life, but then or a month and a half, 2 months, but now it's over. All right. So, are we ready to get this ball rolling on day 2? Let's get through this. Okay? Let's get through this. Yeah, we'll get through it. And I will I'm assuming that their verdict is going to be reached. I mean, if the trial was that quick, I'm sure that the deliberations are not going to take that long. Absolutely, Kel. Kel says, Steph, you got this. This will be something you got through. It's hard stuff, right? Hard stuff, but you're going to get through it and you are going to be on the other side. Oh, going to break the rules a bit, but just so everyone knows, I posted a quick health update for Lenore and my brother. Okay, good to know, Lee. Thank you. Thank you. Thank you, thank you, thank you. I'll be sure to check that out. Thank you, Lee. Steph says, we just saw what happened with Craftably because of delays. I'm stressing. I get it. I know. Thank you, Lauren. I appreciate that. Yeah, don't forget to give us a thumbs up over here. Don't forget to give us a thumbs up. We love the thumbs ups. All right, let's get started. We're already 9 minutes and 11 seconds in. So I'm going to mute my mic, share the screen, and then we'll get started. Oh, Kel says, what is it? Jenny, maybe you should put up a poll now, just in case the jury comes back while we're still watching. Okay. Hold on just a second. Let me do that. Thank you, Kel, for that. My brain is like, let me run over here and do this real quick. Okay. Poll. Start a poll. I hate to ask about the will he be found guilty or innocent, because I think we all know the answer to that one. But I will put. Hold on, let me ask this one. Let me see. Hold on, let me put the options in here. Mm, okay. There's a poll up about how long you guys think deliberations will last. Um, let me exit out of there. Hold on, let me go back up here. My brain is still in sleep mode for surely. Ooh, Steph says for now I have a vanilla custard Danish, blueberry scone, strawberry, I can never pronounce that word, acai, lemonade refresher, and white chocolate mocha from Starbucks, and an old AWS budget kit from Amazon and you all. So I'm counting. That does sound good. That does sound yummy. Oh, what I was talking about earlier though, my coffee. I had some of that like Ghirardelli chocolate syrup, and I did put a little bit of that in it. No, it's not low cal or zero sugar or nothing like that, but I only needed a little bitty dab, just enough to liven up my French vanilla a little bit. So, okay. Now, now that we're 14 minutes in, the poll is up. Thank you, Kel, again for that. I'm glad that you said that. I always forget about the daggone polls. Okay, so I'm going to hit the start button on this and we'll get started.
Regarding the DNA, I just want to make sure that those stipulations have been reviewed and signed by Mr. Scanlon.
I don't know did you have a chance to review them? They hadn't changed since I last emailed them to you.
Yes, I have reviewed them. I do need to go over, I do need to review them with Mr. Scanlon. I've reviewed him.
Okay.
Principal them, but he does need to sign them.
Right.
But we can get that in.
Okay.
They're also, I sent to, and I didn't get a reply back, and it was kind of late. So, but I did send a proposed stipulation regarding those videos to 88 Green last night. So we don't need to deal with that now, but at lunch or at some point we need to, I guess, review that.
Okay.
I would just want to address that with the court briefly before we bring in the jurors. And again, I told the court counsel yesterday I would agree to the foundational elements that Mazza went to this place and got video. That's nothing has changed there. However, I didn't seek to admit these videos because I can't authenticate them. And it might help if the court saw the video, but I will say that it's a grainy video of a sedan passing by the road. Detective Mazza would not have been able to testify that that was Alexis Avery's car. You can't see a license plate. You can't see how many people are in the car. And in fact, I will also say, as far as the timestamp goes, in every case, typically in order for the Commonwealth to admit evidence that the timestamps are accurate, that has to be verified somehow. And Detective Mazza's here. We could do a voir dire. He never went down to the soup kitchen where he got these videos from, looked at it, and looked at his phone and said, yeah, this timestamp's accurate. I just don't want the jurors to be in a position where they're having to guess about evidence in this case.
I thought I asked you, though, at sidebar, whether or not we needed Mazza for authentication, and you said no. So I said, so I thought I asked you if authentication was stipulated to, and you said yes, because that was the reason I asked the question.
I'm, again, my recollection is that I stipulated to the foundation of Mazza went there and got these.
Well, foundation to me is authentication. I mean, that's the foundation that you need to have it, that he would need as the person who retrieved it to have them admissible.
And I'm not trying to be obstinate here. When I looked at the videos again after our conversation yesterday, I can't stipulate to something that he can't testify to.
The stipulation that I proposed was simply that, that as he testified to yesterday, that he recovered surveillance video from these two locations, what he testified to, from that showed depicted the street scene at these two locations between, and I believe I put in the stipulation, 1:18 a.m. and 1:22 a.m. The timestamps are on there. There's no evidence. I'd also, and I'm not asking Commonwealth to stipulate that it is definitely the car, that it is definitely, who was in there. I will say that it was provided to me in discovery with, we believe this is the car, and there you can see in one of the images a pink sweater, somebody wearing a pink sweater in the passenger seat.
My suggestion is that you work on the stipulation, because that you can stipulate that it is or images of a car at this particular time, essentially. I mean, or it is an image of a car retrieved by Detective Mazza.
And that is
for
in
the
line
question, and just leave, and that's it. And the jury can credit it or not credit it, however you want to work it. But I think the language of the stipulation, we may be quarreling over.
No,
words.
I don't even mean to be quarreling about this. I just didn't want to be in a position
That's
where.
the wrong word. Quibbling.
Yeah, I just didn't want to be in a position where the jurors left to have to speculate about who's in the car or what time it is. I mean, even though there's a timestamp attached to that video, again, and I do note in the stipulation, Attorney Elkins wrote approximately between these time periods, which, again, Detective Mazza wouldn't be able to say that I verified that timestamp is accurate. Is it probably around that time? Yeah. So.
I would be arguing the same inference that Detective Mazza himself made very early in the investigation. That's the reason why he pulled these surveillance videos, the reason why he included them in the DNA. In the discovery provided.
That's my thought, Mr. Green. This is what Attorney Elkins just said. I mean, no one's stipulating that it's the car.
Right.
Either one of those videos.
And that was my concern. If we're, again, this is what I understood yesterday. I am stipulating that Detective Mazza, when.
Okay, you guys, I'm going to skip through this whole argument thing because it's irrelevant to me. So.
To a location, requested video from that location between the hours of midnight and 2 a.m. And he was
Back to the Hamilton County Superior Court Courtroom 2 for the resumption of our trial. Again, thank you all for your service in this case. Thank you all for paying close attention to the witnesses and to me and to the lawyers. I've noted that as the process has gone forward, and it's greatly appreciated by me and the parties very much. Has any member of the jury had any difficulty whatsoever strictly adhering to all my instructions that I gave you before we left for the day yesterday? Or do you know of anybody on the jury who has failed to adhere to those instructions strictly? I see no affirmative response. Has any member of the jury seen, heard, overheard, come across in any way or fashion whatsoever anything related to this case or pertaining to the subject matter of this case since we were last together yesterday afternoon? I see no affirmative response. Finally, does any member of our jury have any private matter or concern regarding your continued service as a trial juror in this case that you want to bring to my attention privately at this time? I see no affirmative response. The jury stands indifferent. We'll now resume with our trial. Attorney Green.
Thank you. Your Honor, the Commonwealth will call Mr. Scott Burns at this time.
Ooh, Scott Burns, y'all. Scott Burns is the one that Blake caught Alexis in the back of the truck with. This is going to be interesting testimony. And I think I might speed it up to 1.25 if that's okay with you guys as well. I would do 1.5, but that can get a little bit too quick. So 1.25 is usually pretty easy.
Do you solemnly swear that the evidence you will give this court and jury in the case now my trial shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please take the witness stand.
May I?
Yes. Go ahead, Mr. Green.
Good morning, sir. If you want to scoot a little bit closer, that microphone will help everybody hear you. In a loud and clear voice, would you just introduce yourself to the jurors and by name and spell your last name?
Scott Burns, B-U-R-N-S.
And how old are you, sir?
33.
What town do you live in?
Southwick.
All right. And do you work, sir?
Yes.
Where do you work?
Jarvis Surgical.
And how long have you worked there?
10 years.
I want to ask you some questions now, going back a few years to 2019. Did you know somebody by the name of Alexis Avery?
Yes.
And how did you know her initially?
She worked at Jarvis.
Okay. Do you know how long she had worked there?
I'd say about a year.
All right. And what was your relationship like with her during that year leading up to January of 2019?
We had spoke here and there, but that was kind of it. Just normal work stuff.
Okay. And on January 11th of 2019, it's a Friday night, did you end up going out to a couple of bars in Westfield?
Yes.
And prior to going out to those bars, had you communicated with Alexis Avery at all?
Yes.
And how did you do that? Like, what form of communication?
Snapchat.
Okay. And do you remember if that you made plans through Snapchat to meet at a certain time?
Yes. We made plans to go to the Maple Leaf.
And at that point in time, did you know anything about Alexis Avery's relationship status, or what you believe to be her relationship status?
I believe that I knew she was single.
And how did you know that? Or what made you believe that?
Through Facebook.
All right. And when you say Facebook, just describe what you mean.
I looked her up and saw that she was single on Facebook.
Okay. Under like the status or whatever?
Yes.
All right. And who contacted who first? Did she contact, who contacted who?
I'm not sure.
Okay. But in any event, you did have some communication that night through Snapchat.
Yes.
All right. And as a result of those conversations, did you go to a place in Westfield?
Yes.
Where did you go?
We went to the Maple Leaf.
All right. And are you familiar with that place?
Yes.
And did you go with anybody?
Yes, we went with people from work.
Okay. And was Alexis there?
Yes.
All right. Was she with anybody that you knew or met that night?
She was with her cousin.
All right. Do you remember her name by any chance?
I think it's Caitlin.
All right. And had you met Caitlin before that night?
No.
All right. So just describe what you and Alexis were doing, just kind of in general, what were you doing at the bar?
We were just hanging out.
Talking, hanging out with work friends.
Okay. Do you know approximately, again, it's a long time ago, what time you got to the Maple Leaf?
I would say 9:30.
Okay. And while you were there, you mentioned that you were talking to Alexis. Did you call her? You called her Lexi?
Lexi.
And how did she seem while you were having these talks and conversations with her?
She seemed, okay. I know she was kind of on the lookout for her ex-boyfriend.
How did you know that?
Just through talking to her.
It's sustained. Next question.
Is there something that led you to believe she was on the lookout for her ex?
Just through talking to her.
That's sustained.
Motion strike.
Stricken.
At some point while you were at the Maple Leaf, did things progress a little bit between you and Lexi?
Yes.
And just describe what you mean by that.
We just started flirting and we ended up kissing.
Okay. And where were you in the bar, if you remember?
I believe we were at the bar.
Okay. So you weren't like in the bathroom or in the hallway? In the open?
Yes.
And did somebody else arrive at the bar that night, if you remember?
Just my work friends.
Did you know who Blake Scanlon was back then?
No.
Had you ever met him before?
No.
Do you know if he showed up at that bar, that first bar?
I don't believe he was at the Maple Leaf, no.
You don't recall seeing him there?
No.
At some point, did you go to another establishment that night?
Yes.
Where else did you go?
The whip.
And whose idea was it to go over to the whip?
I think it was a collective group decision.
Yourself and Lexi and Caitlin?
Yes.
So you kind of all knew where you were going next.
Yes.
And did you go over to the whip?
Yes.
And again, approximately what time you might have gotten there?
I'm not sure.
Okay, that's fine. When you got to the whip, did you see Lexi again?
Yes.
And just describe again how the night was progressing between you and Lexi.
We just kind of, kept flirting and kissing and hanging out at the bar.
So, if you know, who initiated like the flirting, or was it kind of more mutual?
I would say it's mutual.
All right. And was her cousin there at the second bar, if you know?
Yes.
Did anybody else arrive at the second bar that you know of?
Just the same work group that we were with.
Okay. And again, do you recall seeing Mr. Scanlon at that bar?
I believe he was there at some point, yes.
All right. But again, you don't really know him, right?
Correct.
At some point in the evening, did you and Lexi go outside of the bar?
Yes.
And where did you go?
To my truck.
All right. Just briefly, what kind of truck was it? Just so we have an idea.
F-150.
All right. 2 doors, 4 doors?
4-door. Crew cab, I believe.
Okay. And when you went out into the truck, what happened?
We were continuing flirting and we ended up having sex.
Okay. Where were you in the truck? Just so I have front, back?
Back seat.
All right. And what happened as this was occurring?
The front driver's side door, or the front passenger side door opened.
And tell me what you saw.
There was a guy standing there. We kind of separated ourselves and.
You and Lexi?
Correct.
And did that guy say anything?
Just to grab her stuff and to go.
Did he say anything to you specifically?
No, I do not think so.
All right. That person that opened the door to your truck, do you see him in the courtroom here today?
Objection, Your Honor.
Yes. Sorry.
Could you describe the demeanor of the person that opened the door? Like, just how was he acting?
Very calm.
Was his voice raised?
No.
And after that person said something like, "Get your stuff, let's go," what did Lexi do?
We kind of separated ourselves, and she started getting her stuff. She had said that, I didn't want to be with you. I wanted to be with him, which was me.
Who'd she say that to?
To Blake.
The person that was at the
Yes.
door? And did you see where they went after she got out of your truck?
I did not.
Okay. Was there any sort of screaming or struggle between the two of them that you recall?
No.
What did you do after she left your truck?
I called for an Uber.
Okay. And why did you do that?
Just we had been drinking.
Do you recall approximately what time you called for that Uber?
I would say 1:15, 1:20ish.
Did you actually take a screenshot of your Uber receipt?
Yes.
All right. That first witness? Yes. Right now. I'm going to show you this image. Don't describe it yet, just take a look at it and let me know if you recognize it.
Yes.
What do you recognize that image to be?
My Uber ride.
All right, a screenshot that you took of your phone with the Uber call on it.
Yes.
So is it fair to say you called for an Uber at 1:19?
Yes.
Thank you. I moved off this. I think you did it.
Objection.
No, without objection, maybe Mark is the next exhibit.
45.
More of that, Mr. Green.
Not this time, Robert. Without getting into specifics, did you try and contact Leslie the next day?
Yes.
And how did you do that? Do you remember what social media or how you did that?
Snapchat.
And did you get a response from her?
No.
At some point, did you learn that something had happened that night?
Eventually, yes.
Eventually, yes. Thank you, Mr. Burns. I don't have any other questions, Your Honor.
Good morning. I'm not going to ask you to repeat very much of what AA Green asked you about, but I do have a few questions for you. So just to be clear, you and Alexis had not been out any kind of dating or relationship or anything like that prior to that night. That was the first night that you.
That was the first night that we hung out.
And I just want to hone right into the most probably for you difficult and uncomfortable part, and I'm sorry about that, but just to go over a couple of things. So your truck that you and Alexis went to at the whip, and you were having sex in, that was a Ford F-150 crew cab, is that correct?
I believe it was crew cab, yes.
And so you had been together and being intimate for a few minutes by that point, about 10 minutes, I think?
About 10 minutes.
Okay. And so you were in the act and the front passenger side door open, correct?
Yes.
And at that point in time, Mr. Scanlon immediately said, "Get your things, let's go." Is that fair to say? So in that moment, it's fair to say that you and Alexis immediately reacted and stopped doing what you're doing, correct?
Yes.
And I presume immediately you started getting yourself together, and you got out of the truck.
I don't believe I got out of the truck.
Okay, so you stayed in the passengers in the backseat, correct?
Yes.
And Alexis also had to get herself together. Is that fair to say?
Yes.
And so she had to gather up her personal belongings, correct?
Yes.
And get herself somewhat dressed, correct?
Yep. And
you guys weren't all the way undressed. You were just undressed enough to do what you were doing, correct? So when Blake opened the door and he said, "Let's go," you're getting yourself together, and Alexis immediately gathers her things. Did she immediately get out of the truck?
I believe so, yes.
Okay. And in that moment, as she's getting out of the truck, is she out of the truck when she says to Blake, "I don't want to be with you, I want to be with him," meaning you?
I don't remember.
But you definitely heard her say that.
Yes.
And she definitely said it to Blake, correct? Okay. Now, in that moment, once she was out of the car, and Blake was already out of the car, of course, you couldn't, you heard them speaking aggressively to each other. That's what you told police. Do you recall that?
I don't recall.
Okay. But it's fair to say they were continuing to talk and you could hear them, correct?
I'm not sure that I heard their conversation.
Well, let me ask you this. I'm not asking you couldn't hear what they were saying except for that you just testified to, but you could hear that they were speaking to each other. Is that fair to say?
I would say that's fair to say.
Okay. And you couldn't hear exactly what they were saying. It wasn't screaming and yelling, but it was aggressive and argumentative. Is that fair to say?
I really don't. I'm not sure that it was aggressive.
Argumentative?
Maybe that's fair to say.
That's fair to say. Okay. Now, just to go back to that moment, so you stayed in the back seat. At some point, obviously, you got out of the truck, correct?
At some point. probably,
And
yes.
they were already gone
Yes.
by that point? And it's fair to say you didn't stay in the back seat of your truck very long at all.
I just waited for my Uber.
Okay. You waited in the back seat of your car for the Uber?
I'm not sure exactly where I was waiting for the Uber.
Okay. And you ordered that Uber at 1:19 a.m. Is that fair to say?
Yes.
And at the point that you ordered the Uber, that was Blake and Alexis had already left.
Correct.
Okay, so they weren't standing outside your truck still talking.
No.
So the period of time that you had to hear and observe anything, well, to observe Blake directly was the moment he opened the door, and for a few seconds after Alexis got out of the truck, fair to say?
Yes.
Okay, and then at that point, you really couldn't hear and you didn't see where they went.
Correct.
Okay. And fair to say that was an upsetting situation for you as well?
Yeah.
Okay, and so in the moment, you're making the decision to go home. You don't make plans to go back in the bar to check in with the friend that you came with, correct?
Correct.
Okay, you just immediately order up that Uber, correct?
Yes.
Okay, and now you testified just a bit ago that you were under the impression that Alexis was single. Is that
Yes.
fair to say? Now, and that, do you remember speaking to police in this case?
Yes.
Okay. Now, when you spoke to police, you sorry, just one second.
As you may have gathered, our rules provide that before a witness is shown something, the lawyers have to show it to each other so that they're all on the same page. So that's what's happening. That's our rules.
So you testified, you testified that you were under the impression that Alexis was single, based on what you saw of her Facebook.
Yes.
Okay. Do you recognize this picture?
Yes.
Okay, and what is that?
That is one of Alexis's Facebook profiles.
Okay, and is this the one that you looked at and led you to believe that she was single?
There was two of them. I'm not sure exactly based on these pictures which one it was.
Actually. But this is one of the Facebook pages, correct?
Yes.
And you took a screenshot of that and you gave that to police when you spoke to them to
Yes.
explain your part of what happened that night.
Mhm.
Okay. And this is, and the name on this is Alexis Avery. That's the Facebook profile name, correct?
Yes.
I offer this as an exhibit.
No objection. Objection.
46. 46.
Yeah.
46.
Thank you.
Now, when you were talking to the police, you also mentioned that you later learned that Alexis had a second Facebook page
Yeah.
under a different name. Is that correct?
Yes.
And that name was Alexis Vasquez, correct?
Yes.
Do you recognize this?
Yes.
And what is that?
That is another Facebook profile.
Okay.
Alexis.
And is that a screenshot from your phone that you provided to police?
I don't. don't know that that is my phone.
Do you remember talking to police about looking at Alexis's Facebook pages
Yes.
and learning that she had a second Facebook page?
Mhm.
And do you remember that you, in that interview,
We need a yes or no answer, sir.
Yes.
and do you remember providing screenshots of those Facebook profiles in your interview with police, correct?
Yes.
And that last picture was from your phone, correct?
The previous one, yes.
Yes, okay. And this was taken also from your phone. Is that the same phone?
I'm not, that doesn't look like my phone.
So these were both provided in your interview with police. They're not the same phone?
That's tough for me to tell. I can see the top up here. It doesn't look like my phone.
Okay, well, let me ask you this. Is this a fair and accurate depiction of the Facebook profile that the second Facebook profile that you found?
Yes.
Okay. And in this profile, in that Facebook photo in that profile, that says that she was in a relationship with Blake Scanlon. Is that correct?
Yes.
And that's how you learned that she was in a relationship with Blake Scanlon at the time.
Yes.
Or that,
You can just keep your voice up a little bit, please. You're trailing off.
or that her Facebook profile still said that she was in a relationship with Blake Scanlon. And that led you to, let me do this. You recognize that picture?
Yes.
Okay, and what is that?
It's a picture of Alexis, her boyfriend, and her child.
Okay, and that picture is from the second Facebook page, is that correct?
I would say so, yes.
Okay. That looked like a very accurate depiction of a picture from Miss Avery's Facebook profile.
Yes.
Okay. That's the just the image.
No,
That was already in it.
no, that wasn't offered. Do you want to offer that one?
Okay. Right. That I did, but I'm offering this to the as well.
Yes. Our objection would be 47, 47, 48.
And and when you learned what had happened to Alexis and before you came in to speak with police, you found that Facebook profile that said she was in a relationship with Blake Scanlon, and that led you to also see if Mr. Scanlon had a Facebook page. Is that correct?
I believe so, yes.
And in that process, you also found that Mr. Scanlon had a Facebook page.
Yes.
You recognize that?
Yes.
And what is that?
That is Blake Scanlon's Facebook profile.
Is that a fair and accurate depiction of the profile that you saw at the time of the incident?
Yes.
Offer this.
You right?
I'm sorry, Your Honor. Just 1 second. There's no.
Can I see you guys on this for a second, though?
I'm just going to skip through the little pauses here.
Without objection.
Just to close out, you had to come back the next morning to get your truck.
Yes.
Okay, and what time did you come get your truck?
I want to say it was around 9:30 break that we have at work.
Okay. And do you recognize this?
Yes.
And what is that?
That is a message that I sent to her Snapchat.
Okay. And what time, when is that dated?
1:49 a.m.
Okay. And on January 12th, the morning, January 12th?
Yes, that would be.
Okay. And is this a fair and accurate depiction of the message that you sent?
Yes.
Okay.
So let's flesh out the conversation we had about this cooling off period. What do you want to use this document for to show that there was a lack of a cooling off period between what we now have evidence from a couple, we have this witness who has testified.
So apparently they had a little bit of an argument, so like a between the lawyers, and it looks like they asked the jury to leave for a little bit. So I'm just skipping through all that. Hey, QB, yeah, been live, and we're trying to hurry and speed through this because yeah, they're already deliberating, ma'am.
All right, we're ready to resume with the examination of Mr. Burns.
Can I have you look at that while I ask you a couple more questions? So after you Ubered home that early morning on January 12th, you sent Alexis a Snapchat. Is that correct?
Correct.
And in that Snapchat, you said that you didn't want to get involved in her family drama and anything in between her and her boyfriend. Is that fair to say?
Correct.
So you said that under the impression that what had just happened was that you had been caught with somebody else's girlfriend.
Objection, Your Honor. Sustain. That's a statute, not that.
But at any rate, by the time you sent this Snapchat, you believed Alexis had a boyfriend.
At that point, I wasn't sure.
And the word you used in here, that was boyfriend, correct? Okay. No further questions.
All right, Mr. Green?
I know nothing about Snapchats. Can you tell if somebody opens a Snapchat from your end?
Yes.
Do you know if that Snapchat was opened?
At some point, yes.
Do you know when?
I believe it was Sunday.
Okay, but not that night?
No.
Thank you.
Thank you very much, Mr. Burns. Your excuse.
Your Honor, may we just approach with the document?
Yes.
Thank you.
technically my job, but I make it my job. Okay, I have this. Parties are offering a stipulation which will be marked as the next exhibit. I need to provide you with an instruction on that. The Commonwealth and the defendant have agreed to or stipulated to certain facts in this case, which Mr. Green will in a few moments read to you. This stipulation is signed by Mr. Green and Attorney Elkins for the defendant, and also by the defendant, and marked as an exhibit. A stipulation of fact leaves those facts no longer at issue and must be accepted by you, the jury, as true. Okay? It's now been marked. Mr. Green, if you would please read that for us into the record.
So Mark, 50.
50, 50.
Your Honor, reading from Exhibit 50 at this time. The following are stipulations of fact. 1, an autopsy was performed on Alexis Avery, date of birth, April 20, 1998, by Dr. Robert Welton of the Massachusetts Office of Chief Medical Examiner on January 15, 2019. A sample of the victim's blood was obtained during the autopsy to be used in later DNA testing. That known blood sample of Alexis Avery was released to Detective Rick Mazza of the Westfield Police Department on that same day, January 15, 2019. He then transported that sample to the Massachusetts State Police Crime Laboratory located on Corondo Drive in Springfield, Massachusetts, where it was taken into secure storage and added to laboratory case number 19-01217 and assigned a specific designation number, item 7-1. Stipulation 2. On October 30, 2019, Trooper Jason Cristofori collected a voluntary saliva sample from Blake Scanlon, date of birth 2/9/1995, to be used for later DNA testing, comparison, and analysis. Trooper Cristofori is trained in the proper procedures and handling of DNA saliva collection methods. Stipulation 3. Later that same day, on October 30th, 2019, Trooper Cristofori hand-delivered the known saliva sample of Blake Scanlon to the Massachusetts State Police Crime Laboratory, again located on Corondo Drive in Springfield, where it was taken into secure storage and added to laboratory case number 19-01217 and assigned specific designation number 9-1. Stipulation 4. G.L. Yoon is a properly trained and certified forensic scientist with the Massachusetts State Police Crime Lab, assigned to the DNA analysis section. On August 29th of 2019, forensic scientist Yoon was able to obtain a DNA profile from the known blood sample of Alexis Avery, which is item 7-1. And on November 25, 2019, forensic scientist Yoon was able to obtain a DNA profile from the known saliva sample of Blake Scanlon, item 9-1. Stipulation 5, and this is the last one. On September 28th of 2020, the Massachusetts State Police Crime Laboratory delivered additional items to Bodie Technology in Lorton, Virginia, which is a certified and licensed outside vendor DNA lab. Nicholas Bradford is a senior DNA analyst employed by Bodie Technology. Mr. Bradford is properly trained and certified to analyze DNA samples, profiles, and draw conclusions. Specifically, DNA analyst Bradford was able to compare Mass State Police item 7-1-09, which are fingernail scrapings from Alexis Avery's left hand, to the known DNA profiles of Alexis Avery and Blake Scanlon. DNA analyst Bradford authored a report on December 2, 2020, in which he concluded that, quote, the DNA profile obtained from MSP item 7-1-09 is consistent with a mixture of two individuals, including Alexis Avery and one male contributor. The foreign DNA profile matches the DNA profile received for Blake Scanlon. Thank you, Your Honor. I'll hand this back to you. And with that, I call Imams down to yours.
Do you solemnly swear that the evidence you will give this court and jury in the case now on trial shall be the truth, the whole truth, and nothing but the truth to help you God? Yes. Thank you. Please take a witness stand.
Good morning, sir.
Good morning. Good morning, Your Honor.
Could you please, just speak into the microphone and introduce yourself to the jurors by telling them your first and last name and spelling your last name, please.
My name is Iman Sadouri, Sadoughi.
Thank you, sir. And are you employed?
Yes, I am.
By whom?
I am employed by the Massachusetts State Police Crime Lab under the Department of State Police. I work in the criminalistics unit, and I'm also a member of our crime scene response unit.
How long have you worked in that capacity, sir?
I have been employed since January of 2015.
All right. And just could you briefly describe your educational background for the jurors?
I have a bachelor's degree in biology and a master's degree in forensic science, both of which I obtained from Towson, Maryland.
Thank you. And could you just describe your general responsibilities in the criminalistics and crime scene response unit?
With regards to the criminalistics unit, I examine physical evidence to determine the presence or absence of biological fluids, such as blood, semen, or saliva, and perform the initial classification of trace materials, such as hairs or fibers. Based on the requirements set by our protocols to establish forensic links and or positive testing results, I will then prepare samples for other units within the lab, such as our DNA unit or our arson and trace analysis unit.
Thank you.
Based on
Go ahead.
Then, based on my findings and my collections, I will prepare a report, and when requested of me, I will testify in court. With regards to the crime scene response unit responsibilities, I respond to mostly the western region of Massachusetts. When I arrive, I obtain basic information from investigators as to what they believe may have transpired, if they have any requests, and then I will begin my examination of the crime scene. This could be a residence, it could be a vehicle, motorcycle, or it could be a subject. I will then document my notes and my observations using diagrams and on pages. I will perform testing as necessary, perform collection as necessary, and then I will transport the evidence back to our crime lab, where I will submit it into our laboratory management system. Finally, I will author a report for my scene response, and when requested of me, I will testify in court.
Thank you, sir. And have you testified before in Massachusetts?
Yes, I have.
Could you estimate perhaps how many times?
Approximately 15 times.
Okay. And are there certain, before you can perform field work, do you have to pass certain tests, company tests and proficiency tests?
Yes, there are.
Could you explain those to the jurors, please?
Competency test is administered at the end of training. I received an extensive on-the-job training for approximately 1 year. The competency was it had a written portion and a lab portion. It was to determine that I can follow the protocols and obtain expected results on mock evidence. It also has a written portion to understand the theoretical testing behind what I was performing. Did you also mention proficiency tests?
I did. Just explain those as well.
And proficiency tests are administered periodically. Those are to test my ability for continued competency over the years as I'm employed. And I have successfully done all of those tests.
Thank you. Have you in fact responded to crime scenes in your role as a forensic scientist?
Yes, I have.
Could you estimate perhaps how many?
Approximately 250 crime scenes or responses. Out of those 250, approximately 50 where I responded as a training analyst.
Thank you. And have you worked in the criminalistic section on preparing samples for DNA testing?
Yes, I have.
And could you estimate perhaps how many times you've worked on samples for that?
Samples or items are in the thousands. I wouldn't have an exact number.
Okay, thank you. I want to direct your attention now specifically to your work in this particular case. Were you assigned to be a crime scene response person in this matter?
Yes.
And were you also responsible for some criminalistics testing in this matter?
Yes.
All right. And well, I think we mentioned this, but are all investigations within your laboratory assigned a specific laboratory designation number?
Yes, there are.
All right. And I know it's been a long time. Do you happen to recall that lab number offhand?
The lab number for the case that we are here today is 19-01217.
All right. And then could you just describe for the jurors, so that's the overriding number?
That is the number that we use internally. All the testing, any crime scene responses by me or any other analyst, including our sworn members assigned to the crime lab, is done under this case number.
All right. And as items are submitted in this particular investigation, are they given a further distinctive identifying number?
Yes, they are. At the time of submission, each item will be assigned a specific item number. Those item numbers will follow our sub-designation of the submission. So each time someone submits evidence for this case, that will be, let's say, submission, for example, 4. every item under that submission 4 will be a 4-1, 4-2, 4-3. So those sub numbers will be assigned after that 4 until all the items that are being submitted are entered into the system. And then our electronic system, computer management system will then track custody and any other testing results and reports along for those items.
Thank you, sir. And did you in fact respond to 92 White Street in Westfield on January 13th of 2019?
Yes, I did.
And do you recall approximately what time you may have gotten there?
It was in the afternoon.
All right. And what was your role when you arrived at the location?
I was briefed on the investigation that was taking place. I was informed which apartment within this residence I would be processing, and then along with working with our crime scene services section, we determined the plan, placed the plan in place, and we went in and processed the residence in apartment 2 for various testing and collection of physical evidence.
Thank you. Before you enter into a crime scene, are there certain measures you do to protect the scene or limit contamination?
It does vary slightly based on scenes, but we would, put booties on we would wear gloves and be mindful of where we are stepping, where we are moving things from to minimize any contamination or alteration of the scene until it is processed and completed.
So specifically at 92 White Street, did you go up to the second floor apartment?
Yes.
Did you make observations in the kitchen area?
Yes, I did.
And just generally, what were your initial observations in the kitchen?
In the kitchen area, I observed various items along with a deceased individual identified to me as Alexis Avery. I observed to the left side of her blankets, pillows, a knife, a glass cup. There were other additional items in the kitchen, including cigarette butts, plastic trash cans, or trash bags, excuse me. Additionally, I made documentation of Alexis Avery and noticed that she had several injuries to her stomach area, back, neck, and face. In addition to that, I documented that she was wearing a pink hooded sweatshirt that was partially pulled up, black leggings, and a pair of mismatched socks.
Thank you. And as far as evidence that you often describe as red-brown stains, can you tell me what you're looking for when you observe these red-brown stains in a location?
There were red-brown stains throughout the apartment based on the number of bleeders, and then looking at the stains themselves to separate them by size, shape, distribution, and also location. I would then proceed with designating them with a letter and proceeding with our screening test for blood. All of these stains would be documented in my notes or diagrams as I'm processing them, and the testing results would then be performed and documented as well. Once the tests are complete, and I believe that if the test is positive for the screening test for the presence of blood, I will then use swabs, which are Q-tips essentially, and I will moisten them with water and collect those red-brown stains for further testing back at the lab.
Thank you. And I just want to ask you, go back a little bit. You mentioned a screening test for the presence of blood. Is that correct?
Yes.
And just describe for the jurors what you mean by screening test.
Screening tests are tests that we perform initially on evidence where we suspect biological materials. We have them for blood and semen. For blood specifically, at the time we were using the orthotolidine test. This test is used, it was done by taking a filter paper, and rubbing a portion of it against a suspected blood stain, which we call red-brown stains, and then adding 2 chemicals. If an immediate blue color developed, then that would be a positive result for a screening test for blood. As I have been saying, screening tests, these tests are not confirmatory. They are known to have false positives, but they are a preliminary result that we can use in order to then collect them and perform, if not limited, additional testing back at the lab.
Thank you. And in this particular investigation at 92 White Street, is it fair to say there were many, many red-brown stains?
Yes.
And you performed screening tests on a large number of those items?
I performed screening tests on approximately 33 stains.
All right. And did you take some of those stains back to your laboratory?
Based on positive results, I did then perform collection on those stains.
And back at the laboratory, do you perform a confirmatory test for blood?
I will, once this is assigned in the criminalistics unit, I will then reevaluate the case, as there could be hundreds of pieces of evidence to look at. I will then determine the most forensically relevant items, and I will go through and examine those. Out of the many swabs I did collect and transport back, or even other items, I selected some of those stains, or the swabs from those stains, for further testing, which is the confirmatory testing for blood.
All right. And so just a couple of specific items. There was a suitcase in the kitchen, is that correct? Suitcase tag?
The suitcase was in the storage area within the apartment, not in the kitchen.
Did you perform confirmatory testing on the red brown stains on that item?
I did.
And what was the result, if you recall?
Testing for the presence of blood was positive, indicating the presence of human blood.
Did you perform or did you collect a red brown stain from the kitchen floor between the legs of Miss Avery?
Yes, I did.
Did you perform confirmatory testing on that swab?
Yes, I did.
And what was the result?
Testing for the presence of blood was positive on the mentioned stain between Alexis Avery's legs on the ground, on the floor, indicating the presence of human blood.
Did you perform or did you collect a swab from a knife on the kitchen floor next to a blanket, which was labeled as placard 8?
I did. There were several stains that I did further testing. I would need to refer to my notes my report for all of that.
May he refer to his report?
Yes. Thank you. Can you repeat your question, please?
Certainly, and I'm referring to item 2-49. Did you perform any testing on a kitchen knife or a knife that was recovered from that residence?
Yes, I did.
Could you describe the testing you performed on that item?
I documented any visible staining on the knife. I then designated stains A through E. I performed testing on those items, on those areas. A screening test for the presence of stain E was positive. However, human blood was not detected. A testing for the presence of blood on stains A through D was positive, indicating the presence of human blood.
Thank you. And item 2-50. This was another knife that was located on scene. Did you perform testing on that particular item?
Yes, I did.
Could you describe the results of the testing on that particular item?
Testing for the presence of blood was positive on stains A to C, indicating the presence of human blood.
Thank you. Now, how do you prepare those samples for further DNA testing?
For non-porous items such as a knife, I would then use additional sterile swabs, moistening them with water, and collecting that stain for further testing. I would snippet a portion of the swabs, so a portion gets retained indefinitely at our lab for additional testing, and a portion that will be sent to our DNA unit if those items are requested by me for DNA testing.
At some point, did you have an opportunity to take swabs from Blake Scanlon?
Yes, I did.
And did you take swabs from Mr. Scanlon's hands?
I did.
All right. And both left and right?
Yes.
And did you perform screening or confirmatory testing for blood on those items?
When I responded initially to the crime scene at 92 White Street, I was then redirected to the Westville Police Department, where I met with Mr. Scanlon and I processed him for the presence of biological fluids. At that time, I performed screening tests for areas that had visible red-brown staining. I then collected swabs from those areas and I transported them back to the crime lab, where they will then further test it in our lab for confirmatory tests for blood. Those areas were his right-hand fingernails, left-hand fingernails. I had swabs of red-brown stains from top and palm sides of his left hand, top and palm side of his right hand, and also red-brown stains from the bottom of each of his feet.
Thank you. I want to ask you just a few more questions about the two knives that you processed. So item 2-49. You mentioned that you swabbed different areas of that knife?
Correct.
Could you describe in as much detail as you can where you swabbed that knife and how you did that?
I collected from the various stains, and if I also additionally collected from handles, if I was able to also separate the stains from the unstained areas. In some instances, it is practically not possible to separate the unstained areas from stained areas, so those were collected together.
Were you able to swab that particular item, both the blade and the handle portion?
Yes.
All right. And as far as item 2-50, again, this was another knife with red-brown stains. Were you able to swab the blade and the handle of that item as well?
Correct. Yes, I did.
Did you prepare those samples for further DNA testing and analysis?
Yes, I did.
And did you prepare the samples that you collected from Mr. Scanlon's fingernails for further DNA testing and analysis?
I did.
And it's not your job to do the comparative analysis, correct?
No, it is not.
All right. Thank you, sir. I have no further questions.
All right, thank you very much, sir. You're excused.
Thank you, Your Honor.
Saman Salam at this time. Good morning.
Good morning.
If you could just speak into the microphone and introduce yourself to the jurors by telling them your name and spelling your last name, please.
My name is Saman Salim, Saleen.
Thank you. And are you employed?
Yes, I am.
By whom?
I'm employed by the Massachusetts State Police Crime Lab in their DNA unit as a forensic scientist 3, which is a supervisory position.
How long have you been employed in total in the state lab?
I've been there about 8.5 years.
Okay. And can you just briefly describe what you mean by scientist 3 versus 1 or 2?
Yeah, so scientist 3 is a supervisory position within the DNA unit, which means that I conduct DNA testing on evidence items that are submitted to the crime lab. I also supervise and train other analysts that are hired newly within the DNA unit at the crime lab.
Thank you. Can you just briefly tell the jurors what your educational background is?
Sure. I have a bachelor's of science in biochemistry from Boston College and a master's of science in forensic science from Boston University.
Thank you. In order to perform the work that you do you have to receive any sort of specialized training?
Yes, when I was first hired at the State Police Crime Lab in their DNA unit, for the first 8 months, I went through a training program. During this time, I received instruction on the theoretical knowledge of DNA testing. I also tested samples, mock samples in the laboratory to learn how to test them practically for future casework.
Thank you. And are you familiar with the term competency test?
Yes.
Could you describe what that means for the jurors, please?
A competency test is a 2-part exam that is given at the end of your training. The first part is a written or an oral exam that tests your theoretical knowledge of the testing you're about to perform. And the second part is a practical exam where you test mock samples in the laboratory and you're graded on if you're able to follow the protocols and procedures appropriately.
Thank you. Did you pass those competency tests?
Yes, I have.
And could you describe and distinguish what a proficiency test is, please?
A proficiency test is an exam we're given twice a year as DNA analysts, as required by the FBI quality assurance standards. This ensures that we continue to perform the work that we're doing on casework with proficiency. These tests are given to us by an external agency where we process samples in the laboratory as we would for real casework. We do not know the answers to these samples that we are given. We are then graded by the external agency whether or not we received the correct DNA profile on the samples.
Have you taken those exams as well?
Yes, I have.
Have you passed those?
Yes, I have.
And could you estimate how many times you've been assigned to work as a DNA analyst on particular investigations or items?
I've tested over 3,000 samples. I can't remember the exact number of cases that I've worked on, though.
And have you testified before regarding your conclusions in your DNA role testing?
Yes, I have testified all over Massachusetts in different counties, which include Suffolk, Essex, Middlesex, Hampden, Berkshire, Plymouth, Worcester.
Thank you. And so this is the million-dollar question. Everybody's heard the term DNA, but can you just give a kind of high-level explanation for all of us to understand what is DNA?
Sure. DNA is an acronym that stands for deoxyribonucleic acids. It is the genetic blueprint of all living things. We inherit half our DNA from our mother and half our DNA from our father. Each person has a unique DNA profile, and no two people will have the same DNA profile except for identical twins that have the same DNA.
Thank you. And could you just generally explain the process you use to interpret DNA results and analysis?
Sure. In our laboratory, we process all our evidence through a 4-step process. The first step is known as extraction. During extraction, we break open the cells in which the DNA is found. So these could be blood cells, skin cells, saliva cells that are present on the evidence item. We break them open using heat and chemicals to extract the DNA from these cells. Think of it as similar to breaking open an egg and extracting or separating the yolk from it. The second step is known as quantitation. During this step, we just determine how much DNA is present in the sample, and we need to know this to be able to move on to the third step. The third step is known as amplification or polymerase chain reaction, PCR for short. During this step, we make millions and millions of copies of the DNA just so that the instrumentation we use, we can actually use it to visualize the DNA profile. During this step, we particularly target 27 different locations on your DNA that are known to be found in all human beings, but they're also known to be different in all human beings, so we can generate a profile that's unique to an individual. And the last step is the analysis and interpretation, where we use instrumentation to visualize the DNA profile or characteristics at these 27 locations, and then do an interpretation to determine if they're suitable for comparison.
Thank you. Does the DNA unit in your laboratory follow any sort of standardized protocols and procedures?
Yes, we have standard protocols and procedures that we follow to do these 4 steps in the laboratory for all samples.
Does your work undergo any sort of review process?
All the work within the DNA unit goes through a 2-step review process. The first step is a technical review. During this review process, another qualified analyst who has the same or higher qualification than me will review the work to make sure that all the protocols and procedures were followed properly and the interpretation that I have made on the DNA profile is accurate based on our protocols. And the second step is an administrative review, where another analyst will review the case file for administrative errors such as pagination, spelling mistakes, as such.
Thank you. Is the State Police Crime Laboratory in which you work accredited?
Yes, we are accredited by NC National Accreditation Board.
Thank you. Now I'm going to ask you some questions specifically about what you did in this case, directing your attention to laboratory number 19-01217. Is that the correct designation for this investigation?
Yes, that is correct.
All right. And in this particular investigation, there were a large number of items submitted. Is that correct?
Yes.
Can you just briefly describe for the jurors what the difference between a known item is and a questioned item?
Sure. A question item, or also referred to an evidence item, is an item that has been that has a DNA profile from which we don't know the source of. So we are trying to determine who this DNA profile belongs to. A known standard or known item is where we know the where that DNA profile came from. So it is collected from an individual. So, for example, I can collect my own saliva, and then when I develop that profile from that sample, I will know that that DNA profile belongs to me because I've collected the sample for myself.
And in this particular case, did you have known DNA profiles to use in your further interpretations?
Yes, I did.
And what were those known profiles?
I had known profiles for Blake Scanlon and Alexis Avery.
Thank you. And are you able then to compare those known profiles to questioned or evidentiary items?
Yes.
And do you use the statistics to assist you in making that determination?
Yes, so once we can after we've done a comparison to those 2 different DNA profiles to determine if they're consistent with each other, we can do a statistical analysis to add weight to that piece of evidence, to that comparison that we have just done to show how rare that profile is in comparison to the world population.
Thank you. Now I'm going to ask you specifically, did you do a DNA analysis comparison work on item 2-15.1?
Yes, I did.
And do you recall what that item was?
May I refer to my notes?
Your Honor? Fresh recollection, yes. Thank you.
That was the swab of a red stain on the tag of a suitcase.
And were you able to obtain a DNA profile from that item?
Yes, I was able to obtain a male DNA profile from that item.
And what conclusions were you able to draw from that profile you developed?
That profile, Blake Scanlon, matches this profile. The expected frequency of occurrence of this profile is approximately 1 in 127.7 decillion unrelated individuals, and Alexis Avery does not match this profile.
And for those of us who don't know what a decillion is, can you just try and explain what that statistic means, please?
Sure. A decillion is a 1 followed by 33 zeros. As a comparison, if you know of a million is 1 followed by just 6 zeros.
And do you know the approximate overall population of people on Earth?
It's approximately 8 billion, or 8 followed by 9 zeros.
Thank you. Did you perform testing on item 2-19.1?
Yes, I did.
And what item was that, if you know?
That was the swab of a red-brown stain, also from the kitchen floor between the legs of Alexis Avery.
Were you able to draw any conclusions from that testing?
That profile was also a male DNA profile. Blake Scanlon matches this profile, and the expected frequency of occurrence of this profile is also 1 in 127.7 decillion, and Alexis Avery does not match this profile.
Thank you. Now I'm going to turn your attention to item 2-49, I guess specifically 0.11. Did you perform testing on that item?
Yes, I did.
And did you recall what that item was?
That was the swab of purple stains on the blade of a knife.
All right. Would you recall what color knife that was?
It was a knife that was found on the kitchen floor on top of the blanket by the sink.
All right. And what, if anything, were you able to tell from your testing on that item?
I was able to tell that it is a mixture of at least 2 individuals, including at least 1 male person. A major contributor was observed in this profile, and the additional low-level DNA was not suitable for comparison.
Can you explain what you mean by major profile?
Sure. So sometimes when we do DNA testing, we don't obtain the DNA profile that we obtain from evidence items is not just from one individual. We end up getting a profile that is a mixture or combination of different individuals in the same DNA profile. We're not able to separate the DNA out when we're doing the testing in the laboratory based on individual people. So what we do instead is then look at those DNA profiles and see if we're able to actually separate the DNA profiles of the different individuals during that interpretation step. A major DNA profile just means that this particular DNA profile in the entire mixture contributes the majority of the DNA or the most amount of DNA in that mixture DNA profile.
Thank you. And what were your conclusions regarding this major DNA profile?
So for this, Blake Scanlon is consistent with the major DNA profile, and the expected frequency of occurrence is approximately 1 in 7.9 nonillion unrelated individuals, and Alexis Avery is excluded or not consistent with the major profile.
And could you explain nonillion?
Sure. So nonillion is just 1 followed by 30 zeros. Decillion was 33 zeros. This is a little less at 30 zeros.
Thank you. Did you perform testing on item 2-49.4.1?
Yes, I did.
And what was that item?
So that was the handle of that same knife that was obtained by the kitchen floor on top of the blanket.
And what, if any, conclusions were you able to draw from your testing on that item?
So this profile was also a mixture of at least 2 contributors. Again, a major male contributor was observed. The additional low-level DNA was not suitable for comparison due to the quality of the profile. And Blake Scanlon is consistent with the major profile again. The expected frequency of this profile is approximately 1 in 522.5 octillion unrelated individuals. And Alexis Avery is not consistent with the major profile.
And how many zeros are in an octillion?
An octillion is 1 followed by 27 zeros.
Thank you. Did you perform testing on item 2-50.1.1?
Yes, I did.
And what was that item?
So that was the handle of the knife that had purple and red-brown stains on it that was found on the left side of the kitchen sink.
And were you able to obtain a DNA profile from that item?
Yes.
And what conclusions, if any, were you able to draw from your testing?
The DNA profile is a mixture consistent with 2 contributors. This time I was able to obtain a major male DNA profile and a minor profile as well that was suitable for comparison.
And describe the major profile and what results you were able to obtain from that.
Sure. The major profile is consistent with Blake Scanlon. The expected frequency of occurrence of this profile is approximately 983 nonillion unrelated individuals.
Thank you. And you mentioned there was a minor profile.
Yes.
And what is that?
So a minor profile, kind of the opposite of a major profile. It's a mixture of 2 individuals. The minor is just what's the lesser amount of DNA, and there's a major contributes the majority. The minor is the other side, which is the smaller amount of DNA that's present in that mixture profile.
Were you able to draw any conclusions based upon the minor DNA profile you obtained?
Yes, even though the minor was less DNA quantity, it was still sufficient for us to do a comparison to it, and we were able to draw a conclusion.
And what were your conclusions?
We were able to say that Alexis Avery is included as a potential contributor to this minor profile, and the expected frequency of occurrence of the DNA profiles is approximately 1 in 237.9 quadrillion unrelated individuals.
But you can guess my next question.
Quadrillion.
How many zeros in a quadrillion?
A quadrillion has 1 followed by 15 zeros.
Thank you. Were you able to perform testing on item 2-5.3.1?
Yes.
And what was that item?
So that was the blade of the same knife that was found on the left side of the kitchen sink.
Were you able to develop DNA profiles from that particular item?
Yes, it was.
And could you tell us what your conclusions were regarding your testing of that particular item, portion of that item?
So this DNA profile was a mixture consistent with 2 contributors, including at least 1 male DNA. So again, we had 2 contributors, but this time I was not able to separate those 2 contributors into a major or minor profile, meaning that they contributed about equal amounts of DNA to that DNA profile.
And what conclusions were you able to draw from your testing of that item?
So both Blake Scanlon and Alexis Avery are included as potential contributors to this mixture. The expected frequency of occurrence of the DNA profiles comprising of this mixture is approximately 1 in 86.24 sextillion unrelated individuals.
And how many zeros are we talking about there?
Sextillion is 1 followed by 21 zeros.
Thank you. Did you perform testing on item 2-69.1?
Yes, I did.
And what was that item?
These were swabs of red-brown stains underneath Blake's right-hand fingernails.
Were you able to identify a DNA profile?
Yes, I was.
And what conclusions were you able to draw from that?
The DNA profile was a mixture of at least 2 contributors. Again, there was a major male contributor present in the profile. The additional low-level DNA or the minor DNA was not suitable for comparison for this profile. And Blake Scanlon is consistent with the major profile, and the expected frequency of occurrence of this profile is approximately 1 in 56.34 nonillion unrelated individuals.
Thank you. And item 2-70.1, did you perform testing on that item?
Yes, I did.
And what was that item?
These were red-brown stains underneath the left hand of Blake Scanlon.
Were you able to obtain a DNA profile?
Yes, this was a male DNA profile, so single source, no mixture. And the male DNA profile was consistent with Blake Scanlon, and the expected frequency of occurrence is 1 in 127.7 decillion, and Alexis Avery does not match this profile.
Thank you very much. I have no further questions.
No questions for this witness.
Thank you very much. Thank you.
Any reasons I
Yes.
So I kind of feel like it's just a matter of, if they didn't do that, then people, the court would be like, okay, where's your proof? They have to put on a case, right? So, the DNA and physical evidence is part of that case, I guess. I will say they're being very good about getting through these witnesses pretty quick, fast, and in a hurry. So if it was a case of who done it, then they would go way more into the physical evidence. So I think they're just kind of like surface level. These are like surface level. Yeah, we went through these expert witnesses. Pretty much that's it. So I'm going to fast forward, but it definitely does seem like a waste of time. I agree. Let's scooch forward here. His ear holes look massive. Is it just me, or does he look like he has massive ear holes? Sorry, that was just a random notice, like a random, I just randomly noticed that. Okay, I'm going to mute myself and then move on a little bit further. Hey, Morgana. Morgy Porgy is not a choice. I don't blame you. Not the ear holes, says QB. He does have big ear holes.
We're gonna have you step out for 5 minutes and have you right back in here, okay? So leave it open, sir, we'll get you right back in. I'm not gonna leave you in the courtroom, I just need to take care of it in the courtroom, okay?
Okay, some kind of random, I don't know what's going on here with this, but let's scooch on by and see. I don't know if they just ran the jury out or what.
I think it's just getting what we marked for ID. This is the ME.
Yes.
I think I. The next individual, oh, you can take the stand. Sorry, Don.
Thank you, Your Honor.
I'm jumping ahead to the next witness
Thank you.
while we're lining them up. The next witness is the ME.
Yes.
I think I gave you the numbers of the, if someone, maybe Mr. Calaforris can help out, because we had, last time we had photographs or some that were a little different than what we marked for ID.
Yes, I think, well, first of all, he's here,
Okay.
which is good.
No, I'm just trying to get ahead of the photograph issue before we,
I believe I've narrowed down or taken out all
okay.
the ones I did want to ask the court to reconsider two particular
What numbers?
photographs.
What numbers? I'll look at them in the meantime. I'll hand you the ID documents and you can tell me.
Now, you also performed another role in this investigation, is that true?
Yes, it is.
Did you have an opportunity? For the record, I am going to show Sergeant Canal Exhibit 36. If you could just take a look inside of that envelope, let me know if you recognize that item.
Yes, I do.
What do you recognize that item to be?
Alexis Avery's, I believe the color is called rose gold colored iPhone. It has some sparkly rose gold colored case on it.
Thank you. And did you examine this phone?
I did, yes.
Now, let me ask you, let me back to my spot. What sort of training did you have at that time, specifically regarding forensic cellular extractions? Is that a thing?
It is a thing, and it's a big thing now. It was not a big thing when I first came into the detective unit in 2014, but that has increased exponentially the importance of digital evidence and forensically analyzing that digital evidence. So at the time, I was a Cellbrite certified physical analyst, which trains you ultimately to extract data from the cellular phone. And I would liken that, my general age group recalls when we would have to bring our phone into our phone service provider, such as Verizon or whoever it might have been. They would take your phone in the back when you're getting a new one, they would plug it into a system and bring all of your contacts onto your new phone. So that's essentially what Cellbrite is. However, it is more forensically sound in that it will provide you with a document that cannot be edited, but the report from the phone will indicate mapping data, GPS data, cell phone data, phone calls, text messages, internet searches from that same platform. So Cellbrite is a company that has really cornered the marketplace for law enforcement purposes, and I was a Cellbrite certified physical analyst at the time.
And did you have to be trained on how to use that program?
Yes.
And just briefly describe what that training entailed.
The training entails, as I described with that Verizon store analogy, it is a plug-and-play system, but there's many intricacies to this plug-and-play system. It is ultimately determining the type of phone, the type of extraction cord that can be plugged into that phone, and then it could potentially be complicated if the phone is damaged or there is a locking device, passcode on the phone. So there are ways to get around that. Cellbrite, that training would entail selecting the correct device, selecting the correct antenna or cord that you could then plug it into the computer and download it, and potential ways to bypass our security locks on our phones.
Have you performed these sorts of cellular extractions in the past?
Yes, I have.
Could you estimate perhaps how many times?
I would say hundreds.
And did you perform an extraction on that particular phone?
I did, yes.
I'm going to show you a disc, and just let me know if you recognize that item.
I do, yes.
And how do you recognize specifically that item?
So it is labeled as a Lexus Avery report, and our report number 2019-108, our office code, my office code at the time, -13 is the report number. And then my initials are on the back of this. As I was preparing for this trial, I did review this item, and these are my initials on the back, the date and time that I reviewed it, and that was March 11th, 2024 at 14:54 hours, so that's 2:54 p.m.
Thank you. May I have this marked for identification, please?
Okay.
Thank you. And Sergeant, when you perform an extraction on a phone, is there some sort of report or printout that can be generated?
Yes,
Did that happen in this particular case?
yes, it did.
Do you know approximately how big that report would be in total?
Total pages, I believe it was 11,000 plus pages, if I'm not mistaken. I know they can be huge. I've seen 26,000 reports. I believe this specific one was 11,000.
So that's just everything from the phone.
It is. And just to clarify, everything from that type of download for that phone, not necessarily everything from the phone, but for this specific report, that was everything from that report, because there are different capabilities with different phones. So just to clarify, everything from that type of download, and there's at least three different types of downloads that you can get. Some are more voluminous than others.
All right, Trooper, Sergeant, I'm going to show you the first 2 pages of that lengthy document.
Yes.
Can you just take a minute to review those? You recognize what's depicted in those first 2 pages of that report?
I do, yes.
What is that?
So this gives the date and time that I did the report, which was January 25th, 2019. At the time that I did it, 10:23 a.m., it appears in UTC time. It lists my name at the time, Trooper Michael T. McNally, the location that I did it, our office in Springfield, the report number, my department, the type of phone, and that's all on the first page. And then the second page is a table of contents of sorts, and it will tell you specifically, it lists call logs, chats, contacts, device notifications, text messages, MMS messages, phone history, and so forth on the second page, table of contents, if you will.
And is it fair to say that this document, this huge document,
Yes.
is searchable?
Yes, it is.
So you could, if you wanted to go to call log, for instance, you could navigate to that.
Yes, sir.
And that's just a summary of the report and what you did and whose phone it was.
Yes, sir.
I would offer these 2 pages as the house message.
Page number 30.
Okay.
So next, I want to go to call log. And it seems silly, but can you tell us what a call log is?
Yes, it would be a ordered number of the calls that were completed, made from the device, incoming and outgoing, and or missed from the device. So it will provide them in a list format of which direction the call is coming from or to, and when it was missed. A date and time is also associated with that, so it helps us order them. Cellbrite does that in the report for you automatically. It will list them in chronological order or reverse chronological order.
And in this particular case, you already mentioned this, I think briefly, but the date and times on this particular call log are in a unique format. Is that correct?
I would say if you're not familiar with the types of reports, it could appear to be unique, but it is in UTC, Universal Coordinated Time. I also understand that acronym does not seem to make sense, Universal Coordinated Time, UTC, but that is, if you'd like me to explain what that is.
No, just if you could explain, if you could explain what, not the acronym is, but what is UTC time and how does that correlate to our general understanding?
So it is a universal time that all other time zones are determined from. So we will always have a UTC time as opposed to where we are now, Eastern Standard Time versus Central Time versus a West Coast time in our country. There is a universal time that then an equation is applied to that, and we can subtract or add hours to it, and that will determine our local time zone.
And in this case, do you recall what the specific UTC designation was?
Yes, it was -5 hours at this point. So that is in standard, that is in the time zone that it was. It was -5 on that report.
So whatever UTC time we are looking at,
Correct.
we would have to subtract 5 hours from to get our local time affiliated.
Local time, January of 2019, that would be a -5. Yes.
And could you explain, again, some may or may not be familiar with this, but all these times are in military time, correct?
Correct, yes.
So, for instance, just so we can be on the same page here, if there was a call to 911 on 1/13/2019 at 16:02 UTC +0, what does that mean? How do we understand that as a local time frame?
So 16:02 is 4:02 p.m. Military time is that 24-hour time cycle where you would add 12 to your current time, and that will give you your military time, add 12 hours to it. And in this situation, 16:02 would be 4:02 p.m.
And then you subtract 5 to get to the local time.
Correct.
So fair to say it would be 11:02 a.m.
Yes, and 16 minus 5, 11:02. Yes.
Sergeant, I'm going to show you now 3 documents. And again, just take a look at them and let me know if you recognize them.
Yes, sir, I do.
What do you recognize those to generally depict?
This is the call log, pages 3, 4, and 5. So in subsequent order, these would be right behind that initial report document with my information when I did the extraction, and then the table of contents, if you will, on the second page, and then it gets right into a call log, which is page 3, 4, and 5. So this is pages 3, 4, and 5 of that call log.
And is there, what is the last call on the call log?
The last call on the call log, and this is in reverse chronological order, is January 13th, 2019 at 16:33 hours. And I can convert that to local time.
If you could, please.
Yes, so that would be 11:33 a.m. on January 13th, 2019.
And what is, if we go back to the earliest in time, chronologically backward, call log, I believe it's 42 on page 5. What do we have there?
Yes, so that is January 10th, 2019 at 19:30 in military time, 19:30 minus 5. That would be, 19:30 hours, 2:30 p.m. on January 10th, 2019.
And so is it fair to say that the call log that you're holding, those 3 pages, that includes all of the incoming and outgoing phone calls from that device during that time period?
That's correct.
Can I go off of these 3 pages as the next exhibit?
64.
Think about display this so it'll be a little bit easier for people to understand. All right, so now displaying exhibit 64. It's not great. Do we make that focus? Yeah, okay, that's too much. A little out. Yeah. Okay, so for instance, we already discussed number 2, right here. Just describe and just tell us what outgoing means. It seems kind of obvious, but you're the expert. What does outgoing mean?
Outgoing call, a phone call from that phone to that number, 911 in this situation. So that phone made an outgoing call, dialed 911, and hit send to that number.
At this time.
Correct.
Which we know is 11:02 a.m.
Listed as 16:02 minus 5, 11:02 a.m.
And what about missed? What does missed mean?
Missed means a phone call was placed to that hand device and the call was not answered.
What about outgoing?
And an outgoing call would be someone taking action with that phone, dialing a number or going to the contacts and pressing send on that phone, an outgoing phone call from that phone.
And speaking of contacts, you see that at some points in red here, there's actually names associated with those. Is that fair to say they're from a contact list?
In my experience, that would be the contact list within the phone, yes.
I'm going to show you 3 more pages. And just tell me if you recognize what those 3 pages are. And I'm going to hand you back Exhibit 64 as well.
I do believe these are the same documents.
And is there any difference between Exhibit 64 and the 3 pages that you're currently holding?
I don't see a difference. I'm seeing the same. Okay, I do see, yes, okay, yes.
And what is the difference?
Yes, so it is the same call log, and this also depicts whether the call was deleted or not. And it provides another column on this second sheet that you gave me, aside from the first one that I looked at, with whether it was deleted or not. And in blue, it tells you the date and time that it was deleted.
And so actually, so the blue, do these times correlate to these times, but just converted?
That's exactly what they are, yes.
All right. So that's an edited document with the times, the math is essentially done, so that the math is done on that.
And it's done for you, correct. And it's in Eastern Standard Time, the deleted time and date.
Yes, and I just want to be clear that this is, let me strike that. I'll come back to that. I'm going to show you one page document. So you can navigate to search history through this program, is that correct?
Correct, yes.
All right, and I'm going to show you what's, it's page 2632. Just tell me if you recognize what that is.
I do, yes.
And what is that?
It lists a number of searched items from the phone. So these would be internet search items, and it'll even tell you how they were searched, the source of the search. And in this situation, it was Chrome or Gmail were the search, and then the value that it gives you in a column right next to where you're searching for this item online is what is typed into the phone to be searched.
And is that a fair copy of that page of this overall cellular extraction?
Yes, it is.
I would offer this as the columns next exhibit, please. Hold on.
All right, so this is the exhibit 35.
Attorney Elkins, please. Oh, yeah. You copied it.
Exhibit 65. Sorry, I'm going to show you exhibit 65.
Just a heads up, a quick heads up here in a moment. I'm not sure when they're going to bring it up because I kind of scrolled through a little bit a while ago because they were getting a little bit sideways with the photos on the screen, right? But they show pictures of his arm, his forearms, coming up like soon. So just trigger warning, because he did like self injure. So yeah, I just wanted you guys to be on alert for that. Just an FYI, just a trigger warning. Trigger warning.
And if you could just tell us what information is contained in this document.
We see it is numbered, and of these search items, 1,560 of them, we see that on the top title bar there. And then in the first column, what number search that is, and that is correlated with the timestamp, associated with the timestamp. So that would be January 13th, 2019 at 15:52 a.m., 15:52 hours, which is 10:52 a.m., that -5 there. And then Chrome is how this item was searched, Google Chrome, and then the value of what was searched. And in that first column, it's listed as how to mimic a VO. And then we see some clarification in the search, the next search after that, search number 2, how to mimic a voice.
So what we can tell from this is that that value was entered onto this device.
Correct.
Yes, I'll take 64 back as well. Thank you. And I'm going to show you 4 more pages for the record out of this document. They're pages 2667 through 2670.
Yeah. Believe it or not, it's just to make sure that the process moves forward as efficiently and fairly as it can. And I know you know that. And so thank you all for your indulgence. I'll see you in just a few minutes. 70 on 2667. The top of the page will be redacted. Now we're into the, look like they're numbered 1 through 66. So let me hear you on that.
Look at these, let me know if you recognize what they are.
Yes.
And what you recognize those 4 pages.
Text messages from January 13th, 2019 at the latest, and then the earliest, January 10th, 2019, from Alexis Avery's phone, text messages.
Can I have this marked up for identification, please, Your Honor?
ID. Oh, righty. Righty.
And just for the record, with the court's permission, I'm going to display page 2670 of O for IDO. Just so we get an understanding of what we're looking at. And you can see here, there's a lot of information contained in this printout. Is that correct, Sergeant?
I'm sorry, that question again was?
Just walk me through what these columns mean, if you know.
Yes, so the number of message in what I just referred to, I'm not sure how many thousands there were for text messages, that would be on the far left-hand side. Whether it was sent or received, sent or into the inbox would be received. And then 2, which number we can see, number 58 there, the top one that I can see on my screen, 58 from that phone number associated with that contact, that's saved as Blake. The next column is the date and time, 1/11/2019 at 14:28 hours. So that is -5 hours, and that would be 2:28 p.m. -5 hours for that Eastern Standard Time, whether the message was read or not, and then the status is read, we see in the next column. And then for that top line, number 58 here, did you take the weed stuff is the message that was in the inbox, in the inbox for Alexis Avery's phone.
All right, and let's do it again with this last message here, 66.
Number 66, the inbox. So that was a message received from Blake at that phone number at that date and time, 1/10/2019. It was read 1/10/2019. Approximately 14 minutes later, because we can see the column just prior to that is 21:46. When it was read, 2200. That's 10 p.m. -5 hours again, if we're looking for the accurate time. The status is read, and then it reads, even though we're breaking up, why can't we still love each other and this smoothly and nicely, babe?
Thank you. May I have one moment, please, Your Honor?
Is that less formally offered?
No, it hasn't been, it has not.
Okay, I just wanted to make sure I hadn't missed the.
Right, no, it'll be, as soon as we redact parts of it, it'll be admitted into evidence. All right, so here you go, Bill. When I use the word redacted, it simply means that certain portions of a document or exhibit will be whited out, or you're not to spec. Okay, all right.
Good afternoon, Mr. Burke.
Good afternoon, ma'am.
Just a couple of questions for you. You, after,
Okay, another heads up, another trigger warning. This is where I believe it was when the defense starts her cross-examination. So just heads up, trigger warning. Images are pretty gross.
police responded to the scene on White Street. You went,
I'm sorry to interrupt. Can you just set the microphone over? Thank you.
sorry, you went to the hospital where Mr. Scanlon was taken after he was taken from the apartment, correct?
That's correct. It was a Noble Hospital in West Virginia.
And while you were there, you took some photographs of Mr. Scanlon in the hospital room, is that correct?
I don't recall taking photographs.
Let me, just one second. Do you recognize these?
I do, yes.
What do these pictures depict?
That is Blake Scanlon in his hospital bed at Noble Hospital, and I very well could have taken these photos. I don't recall taking them.
Okay. Is this a fair and accurate depiction of Mr. Scanlon's appearance in hospital that day?
That is how I remember him in the hospital that day. Yes, it is.
I offer these as a single exhibit, these three.
No.
Without objection. Let's do I like them separate, so let's do separate.
66, 67, and 68.
And just briefly, Mr. Scanlon was taken directly to the hospital before he was booked. Is that correct?
He was, I'm sorry, he was taken, could you say that question again, please?
So from the apartment, he was taken by ambulance to the hospital, correct?
I believe he was taken directly there. Yes, I'm not sure of anything in the intervening time, but I met up with him at the hospital. I went directly to the hospital. That's where I first saw Blake Scanlon.
And he was taken to the hospital because he needed care for wounds. Is that correct?
Yes, that's correct.
And is it fair? These are a depiction. This is a photograph of the wounds he was treated for.
That is some of them. Yes, ma'am. That's the right hand, right arm.
Okay. And this is another shot.
I'm sorry, that was his left, I believe. Yes, correct.
Left, yes.
Left arm, yes.
I think this is not the one I showed previously. And this is just another shot of it.
Yes.
Correct?
Left arm, yes, ma'am.
Okay. And he was treated for these wounds and he was released. Is that correct?
That's correct.
So the bandages in the other photos that you identified earlier, those are from these wounds. Is that correct?
Yes.
No further questions.
No, thank you.
All right. Thank you.
Thank you, Your Honor. Thank you.
Your Honor, the Commonwealth will call Dr. Welton.
Dr. Will.
Do you solemnly swear that the evidence you will give this court and jury in the case now on for trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please take the witness stand.
May I, Your Honor?
Yes.
Thank you. Good afternoon, sir.
Good afternoon.
Would you please introduce yourself to the jurors by telling us your name and spell your last name?
Yes, my name is Robert Welton, Welton.
And are you employed, sir?
I am.
By whom?
The Commonwealth of Massachusetts Office of the Chief Medical Examiner.
How long have you worked there?
It'll be 10 years in July.
What's your current role at the OCME?
I'm the Deputy Chief Medical Examiner.
All right. And could you describe your educational background, please, for everybody?
Sure, I have a bachelor's and master's degree in biology from the University of Massachusetts at Lowell. I have a Master of Public Health and Epidemiology and Biostatistics from Boston University. I have a PhD in biology from Boston College, and I have my medical degree from the University of Illinois in Chicago.
Thank you. Can you describe some of your academic appointments that you've held in the past?
Sure, as a resident in pathology, I had held a instructor and a clinical associate position through Tufts University School of Medicine.
And any prior military service?
Yes, I had spent approximately 11 years in the Massachusetts Air National Guard and 3 years on active duty with the U.S. Navy.
And in what capacity were you with the military?
I was a transportation officer with the Air National Guard, and I was a biochemist with the Navy.
And do you hold any professional certifications and licenses?
I do. I have a full active medical license in the Commonwealth of Massachusetts, and I am certified in public health.
And do you still belong to professional organizations?
Yes, I do.
And which ones?
I belong as a member of the National Association of Medical Examiners, the American Medical Association, the Massachusetts Medical Society, and the Society of Forensic Toxicology, amongst others.
Thank you. Aside from your academic background, is there certain specialized training that one has to undergo or go through in order to be certified to do the work that you do?
Yes. So I had done a clinical year, intern year in anesthesiology, followed by 4 years of training at Bay State Medical Center in pathology. And then I did a year's fellowship in forensic pathology at the Commonwealth of Massachusetts OCME medical examiner.
Thank you. Just so we're all clear, pathology is a specialized field?
Correct.
Which studies what?
Human disease.
Thank you. And could you just describe the overall nature of your work as a medical examiner?
Yes. So my job as a medical examiner here in Western Massachusetts is to examine the cases that are assigned to our office and to ultimately determine cause and manner of death.
And this is, you can answer this, but how many autopsies do you think you've performed over the course of the years? And again, roughly.
In the 4,000 or so cases that I've done in the past 10 years, probably about half of those have been autopsies.
Okay. And have you testified before in this capacity as a medical examiner regarding your findings and conclusions of autopsies?
Yes.
And again, do you know, could you estimate perhaps how many times?
30 to 50 at this point.
All right, thank you. Now I want to turn your attention specifically to the reason we're here today. Did you have an occasion to perform an autopsy on January 15th of 2019?
I did.
And where did you perform that autopsy?
The autopsy that you're referring to was performed at our Holyoke facility.
Okay. And who was that autopsy performed on?
Alexis Avery.
All right. And are autopsies assigned a specific laboratory or case number in your office?
They are.
And was this assigned a specific case number?
It was.
Do you recall what that was, or do you have a note that would help you?
Yes, it's 2019-583.
All right. And before we get into specifics, just walk us through the general process. Where do you begin with an autopsy, and kind of what are you looking for in general?
Sure. So all of our cases begin with a review of whatever preliminary information is called into our office. It may be medical information, maybe police information, scene information. Once that is reviewed, the next step is to determine a plan of action for the autopsy. Once down in the autopsy room, there's an overall review of the individual that I'll be examining, which will include photographs and an external head-to-toe examination. Once that is done, we move to the internal examination, which is the bulk of the autopsy. Again, that is a head-to-toe examination where all organ systems are examined. It may also include ancillary testing such as tissue for microscopy, toxicology, and radiology. And all of that leads up to ultimately determine the cause and manner of death for that specific case.
That's your ultimate goal in performing an autopsy, correct?
That's correct.
All right. And so in this case, can you just tell us a brief, did you perform an external examination of Alexis Avery?
I did.
And what were your initial observations of Ms. Avery?
Initially, what had appeared were several what I thought at the time were sharp force injuries. There were also what I had called blunt force injuries as well, scattered on the body.
How did the body present to you?
The body presented after coming into our office. I can't recall at this time if she was clothed or not. At some point, that would have been removed prior to me doing my examination.
And when you examine when you examine a body, do you make note of whether or not it's well preserved or refrigerated, embalmed, things like that?
I do.
And did you make note in this case?
I did.
And what do you recall?
She was refrigerated because she had been in our office and she was not embalmed.
All right. And was the body in sufficient condition that you could perform an examination?
Yes.
All right. And did you note things like livor mortis and rigor mortis, those sorts of things?
I did.
First of all, can you just tell us what those terms mean?
Sure. So we'll start with rigor mortis. Once an individual has passed away, there are some physiologic changes that happen in the body, and the ultimate result of that is your muscles will stiffen up and you won't be able to move them. So that's rigor mortis. Livor mortis is another physiologic response from the heart stopping and the blood not pumping through the body. And what then happens is the blood will pool based on gravity. So, for example, if you die on your back, the blood will pool towards your back. That's livor mortis.
Okay. And I just want to ask you generally about time of death. On TV, you get a specific time of death in 5 minutes.
Yeah.
Tell us
Sure.
tell us why that's not necessarily true.
So the time of death is a multifactorial determination, and it requires a lot of input from the scene. So what was the person's physiological state at the time of death? What was the temperature in the environment at the person's time of death? Were they refrigerated or subject to a different temperature prior to us receiving the body? So there's a lot of external factors that can play into it. There are some general changes that have time frames, but I generally use them as ranges versus the person died at 4:30 a.m. or whatever. I'll usually give more of a range because of that.
In this particular case, are you able to tell us specifically what time Alexis Avery died?
I was not.
And I believe you already mentioned this, but as a part of your examination, are photographs taken of the individual that you're examining?
Yes.
And is that an important part of preserving and documenting what you observe?
Yes.
Okay. I'm going to show you 12 images. I just want you to look at them, not comment yet, but just tell me if you recognize the images depicted here.
Yes, I recognize them.
What do you recognize those images to be?
Photos from the autopsy of Alexis Avery.
Are they a fair and accurate depiction of the injuries that you observed and described in your report?
Yes.
You know, I would offer these as the comments next exhibits.
Just want to counsel first. Let me tell you, remember during your call yesterday, I gave you an instruction regarding photographs. I just want to remind you that you're about to see photographs that will be marked in evidence in the case. You must view those photographs calmly, coolly, and without emotion, even though some may be unpleasant or graphic. You must not allow now or during your deliberations sympathy or pity, which may be occasioned by these photographs, to interfere with your task of rationally considering all the evidence. Consider these exhibits only as they draw attention to clinical medical status, the nature of the injuries, and the positioning of any entry of any projectile in this case. So with that, Mr. Green, go ahead. They may be marked.
Subject
Subject to the previous infections, right?
It'll be 69 through 80.
69 through 80.
12 right here.
Should be called. Just receive sidebar.
Quick sidebar. They're taking a quick sidebar, but let me just say, I think it was Kel said yesterday that look, he wouldn't look at what he did, and I think that they should be forced to look at what they did. He hides his head the entire time. He hides his head the entire time when the medical examiner is talking through these photos.
Sorry. Yeah, it's 69 to 82.
Let me ask you this, Doctor. Did you, were you able to determine the number of wounds that Ms. Avery sustained?
Yes.
And what was the overall number?
As far as sharp force injuries, there were 28, I believe.
All right. And in your report, I think it makes sense to hear you kind of discussed them in groups, is that right?
Correct.
All right. So the first injuries you noted were sharp force injuries to the head and neck, is that correct?
That's correct.
I'm now showing exhibit number 69. I think you have a monitor there, Doctor. Can you tell me what's depicted in exhibit 69?
Yes, these are the wounds that I had described in the report on the right side of the Miss Avery's face and neck.
All right. And the indications, the letters that are also apparent, did you put those there?
I did.
And why is that?
To basically catalog each of the individual wounds.
Okay. And when you say a sharp force injury, what do you mean by that specifically?
So injuries are generally classified into two categories, blunt and sharp, and a blunt force injury is an injury not caused by something sharp. So sharp would include incisional type wounds, stab wounds, anything basically caused by a sharp object.
And were you able to measure the depth of these wounds?
I was.
And could you, I don't know, so let's start with A. Could you tell us the depth of injury A?
A was about 1/4 of an inch deep.
How about injury B?
3/8 of an inch deep.
How about C?
3/8 of an inch deep.
Injury D?
3/8 of an inch.
Injury E?
5/8 of an inch.
Injury F?
1 inch.
Okay. How about G?
G is a superficial wound, so it was not very deep.
Okay. And what about H?
Same thing, also a superficial wound, not very deep.
Okay. It's I'm going to show you a number 7 now. These depict other portions of injury, is that correct?
That's correct.
And what letter do we have here?
That is a J.
All right. And describe injury J if you can.
J is it's a sharp force injury that involves the corner of the right side of the mouth and damage to the internal structures of the mouth as well.
And this is exhibit 71. Make sure I'm pointing correctly. What is this injury here?
That is, I believe, that is wound H. It's either H or I. I can't tell with
Let
that.
me go back to, this is 69 again. And there's one here and one kind of under here. I guess they could both be an H or an I.
Correct. So the one on the neck next to G is H, and the one on the chin is I.
So now let's go to that. This is I. Right?
So that is I, correct.
And what can you tell from that injury?
So that is also a sharp force injury. Basically, sort of the skin folds underneath Miss Avery's chin, and it was about 1/2 inch deep.
Did you make any subsidiary findings regarding these wounds?
Yes.
What were those?
So there was damage to the soft tissue, including skin, fat, muscle in the neck and the face. More specifically, in the cluster of the wounds on the right side of the neck, there was damage to the muscle underneath the sternocleidomastoid muscle, as well as damage to the external jugular vein.
Okay, and one more time, this is 69. Can you tell which of those affected the jugular vein, or are you just talking about one of them?
So there are two possibilities. Wound E and wound F both have sufficient depth, and they're in the proximate area. So it would most likely be either of those that caused that deeper damage.
And could you describe for us what is the jugular?
Sure. So there are several vessels going into the brain and coming out of the brain. The carotid arteries going in the jugular veins, both the internal and external jugulars are the vessels that the blood leaves the head through. And the right external jugular vein, in this case, was the one that was injured.
Could any of those injuries in and of themselves been potentially fatal?
Yes.
And can you narrow that down, or just potentially any of those?
The two that were closest in proximity to the external jugular vein, the E and the F, are likely the ones that would have been more fatal.
Okay. Now I'm going to move on to injuries of the torso.
Sure.
Is that the next category that you discussed in your findings?
It is.
All right, so now this is 72. Here we go. All right, so this is exhibit 72. It's a little bit hard to see from the glare, but what injuries are depicted in this?
So there are multiple injuries here. The two top ones, L and M, are to the chest area, and N through Q are to the abdomen.
Okay. Did you make any findings about injury M?
Yes.
What can you tell us about injury M?
N is what I would call a stab wound. It's about 1/4 of an inch deep. It doesn't necessarily penetrate into the body cavities. It's more superficial.
Going to display 73, please, for you, doctor. And just orient your.
The fact that he went towards her face, that he put any injuries on her face, speaks volumes to me. Yeah. That was like rage and jealousy.
Yourself to that. What injury are we looking at here?
That's injury N.
Okay, and it seems common sense, but is this ruler just to help you understand the dimensions?
Yes.
And what can you tell me about injury N?
So injury N also would be a stab wound, and there's a bit of what I call a tail. So if you're looking at the screen, that side or my right side, there's a little bit of what's a superficial incisional type wound. This wound is deep enough that it actually penetrates into the abdominal cavity, and actually the wound track goes into some of the organs within the cavity.
And were you able to determine which organs it may have affected?
I was.
What were those?
The left lobe of the liver, the pancreas, the small intestine, the junction of the aorta and the artery feeding the kidney, one of the kidneys, and it also hit part of the left kidney as well.
In your opinion, is that wound in and of itself potentially fatal?
Yes.
Displaying for you further torso pictures. This is exhibit 75. Can you see that, doctor?
I can.
And are there injuries you noted in this picture, 75?
Yes.
And where are we looking here on the body?
So Miss Avery is lying in the prone position, which means on her stomach. So where you see Y, that would actually be her right shoulder. So the injuries that you're seeing labeled further down on the back are on the right side.
Okay. And that'd be Z, AA, and AD?
Correct.
This is exhibit 76, showing why. Did you make any determinations about injury Y?
Yes, injury Y is also a stab wound, but it is relatively superficial and it does not penetrate into the chest cavity.
And back to 75, what about these other injuries, Z, AA, and AB? Did you make determinations regarding those injuries?
I did.
What were those?
These also stab wounds, relatively superficial, only going into the soft tissue of the back, not into the cavity.
Did you examine Ms. Avery's extremities, meaning arms?
I did.
Did she have injuries on her extremities?
She did on the upper extremities.
I'm showing you Exhibit 79. Can you see what's depicted in that?
Yes.
All right. And all right. What letters are denoted in this particular image?
I am seeing R, S, T, U, and V.
Okay. And did you make subsidiary findings or conclusions about any of those injuries?
Yes, these are also stab wounds. S is probably a combination of a stab and an incisional wound because of the superficial nature of it. I determined that they all go into the soft tissue and they all have varying depths.
Okay. Were we able to determine the depths of some of these injuries?
Yes.
And how about R?
R, about a ½ inch in depth.
What about injury S?
So S, it looks deep, but it really only penetrates into the fat and the skin.
And what about T, U, and V?
T is superficial, again, only into the skin and soft tissue, as are both U and V.
Okay. This is Exhibit 74, injury K. What are we looking at there?
K, let's see. K is back on the torso. It's basically on the right side of the chest on the lateral aspect, or the aspect that would be closest to the armpit.
Okay. And so in general, these cluster of injuries on Exhibit 79, those injuries to the extremity.
Yes.
Are you familiar with the term defensive wound?
Yes.
And can you tell us, can you form an opinion as to whether or not these injuries may be consistent with defensive wounds?
They could be consistent with defensive wounds.
And how would that be?
So defensive wounds are basically injuries that are sustained when you're trying to defend yourself. And by looking at the position of where they are on the arm, they could in fact have been caused by that defensive type of movement on Miss Avery's part.
Did Miss Avery also suffer from some blunt force injuries?
Yes.
And again, just what is the distinction? What is a blunt force injury?
So as I had said earlier, sharp versus blunt. Blunt is an injury that isn't caused by something sharp. That would include bruises, scrapes, abrasions, lacerations, something that's either caused by a dragging motion or a blunt impact of the skin.
Okay. And did you observe blunt force injuries to Miss Avery?
I did.
And where did you observe those?
There was an abrasion on her head. There were bruises on her arms and her legs.
Okay. Are those blunt force injuries, in your opinion, contributory to her cause of death?
Objection, Your Honor.
Sustained.
I'm going to show you two other quick pictures. This is 81. And is that another, what area of the body are we looking at here?
That, I believe, is, so up on the corner where the ruler is, that is the palm side of one of the hands. Excuse me.
And so then this injury here would be slightly below the palm area.
That's correct.
And number 82, can you please tell me about where that injury is located?
So this is one of the hands, and the X is overlying what appears to be, from this photograph, a sharp force injury of the 5th digit, the pinky finger.
As part of your examination, do you take blood samples?
Yes.
And where do you normally take blood samples from in an autopsy?
So blood is generally taken, excuse me, if I can, I try to get it from the heart, one of the peripheral vessels like the femoral artery, subclavian artery, if I can. If I can't, depending upon the situation, and there's pooled blood in one of the body cavities, I will take it from there as well.
Were you able to take blood from the heart of Miss Avery?
I was not.
And why is that?
There was approximately 1,200 milliliters of blood in the chest cavity, and there wasn't any blood, residual blood left in the heart in sufficient quantity for me to take a sample.
So where did you take your sample from?
From the pooled cavity.
Did you send that out for toxicology testing?
Yes.
Do you recall what the results were, if there were any?
Yes, there was ethanol present and 2 metabolites of marijuana present.
And in your opinion, did either of those things contribute to her cause of death?
No.
Did you go on to perform a detailed internal examination?
Yes.
And what are you looking for when you do that? Anything else?
So basically, disease processes, any trauma that may have been transmitted externally to internally, or any other types of anomalies that I might see in the organ systems.
Did that detailed internal examination reveal anything of significance to your findings?
Yes.
And what was that?
So the injuries to the organs that I had mentioned previously, there was also injury to some of the soft tissue in the abdominal cavity that had caused bleeding. There was a sufficient amount of blood that I had mentioned, the 1,200 milliliters in the cavity, that was there as well.
And we've heard this phrase several times now, but cause of death. What do you mean by cause of death?
So cause of death, in the easiest sense of the definition, is what medical or reason that ultimately caused the person to die.
Were you able to determine that in this case?
I was.
And what is your opinion as to Ms. Avery's cause of death?
Her cause of death was signed out as complications of multiple sharp force injuries of the neck and torso.
And are you able to narrow that down to any one or two particular injuries, or is this just your overall opinion?
So the injuries, so it's an all-encompassing cause of death, but it was based on the injuries that I had mentioned impacted the external jugular vein, as well as the injuries that had impacted the liver and the organ systems that I talked about earlier.
So several injuries.
Correct.
Based upon your examination, if you can you offer an opinion as to how long it might have taken for somebody to succumb to these wounds?
Given the organs that were impacted, we're talking not an extended period of time. We're talking on the order of several minutes. It's not an instant death, but it's also likely not to be a prolonged death because of the amount of bleeding that I had seen.
But it would have taken at least several minutes.
Yes.
Thank you, doctor. I have no further questions.
Welcome.
All right, so we're going to take our lunch break now then. It's 5:01. We're going to break for lunch. Please leave your notebooks and pens in the chairs. Please, jurors, keep my instructions that I've given to you at the end of the day firmly in mind as you go to lunch. And we'll see you here at 2 o'clock to resume the evidence in this trial. Thank you all very much for your attention that you've given the witnesses and me and the lawyers. Greatly appreciated. All right. Jury Stefano.
Okay, so they're headed to lunch. This was yesterday's day 2. So for those of you that are coming in, hey, Mary Lou. I also just scarfed down a chicken roll up. It was delicious. And I used mustard instead of mayonnaise because, I really wanted some Duke's mayo. But anyway, okay. Get my mind off the food, Jenny. All right, so we are a day behind on the trial, on this trial. I started it a day late. And so anyway, the jury is already today in real time, they're on day 3. And the jury has already gone out to deliberate. So this was quick. Let me see. Oh, right, Gail. Gail says that must be lovely. Seeing those pictures and then going to lunch. Ugh. So yeah, I'm gonna skip through past the lunch break, and we will continue on. All right. And I agree that she would have fought for her life 100%. Chaloon said, I feel like he knew what he was going to do the moment he found out they were in that car together. He was way too calm because he knew he was ending it. So I haven't really noticed anything as far as like premeditation. But I know that his charges are, let me go back and see. His charges are first degree murder, and the other charge is assault and battery with a dangerous weapon. So, his lawyer is basically trying to, I don't know if concede is the right word, that she said in the opening statements, it's not a question of who done it, but it's a question of what he's actually, guilty of as far as the murder charge. She says that he is not guilty of first degree murder. Right, QB, because of the premeditation. Lauren, I agree. Lauren says, I hope he rots in prison if I may be so bold. Please be so bold. Please, and thank you. All right, so we're going to skip through, or we already skipped through. Time warp, right? Chaloon says, Lauren, I like you. Chaloon, I don't know if you know this, but Lauren is actually our very own Henny's daughter. Yes, Lauren is Henny's daughter. So exciting. So exciting. Hold on. We have to do a, hold on. Okay. Here's what we do when we're going to speed it up a little, right? Okay. You guys, just beware of the sound volume on this little voice clip here, but this is how we roll when we time warp.
Fine, you're doing splendidly. Speed it up a little.
Love it. All right. Now, let's get started back with it. Yes, Chaloon. Yes. Lauren is our very own Henny's daughter. Kel says, isn't it strange that he isn't being charged with second degree? I wouldn't find him guilty of first degree, but would second. If that's the case, he would only be guilty of assault in my book. Well, so I think, that's kind of, QB says, I think they overcharged given the brutality. Maybe. I don't know. I'm not sure. But I think that they're really going to have to play it by the letter when it comes to the questions on their verdict forms, on their jury instructions. So we will see. I'm going to go ahead and continue on here.
Welcome back, members of the jury. We're ready to resume with the examination of Dr. Welton.
Good afternoon, doctor.
Good afternoon.
I don't have too many questions for you, but I do have a few.
Sure.
You testified earlier, I'd say it's this morning, but I think it was afternoon, but that you were not able to determine the time of death in this case?
The exact time, yes.
Okay. And I think in your report, you also testified that that when you, so you reviewed photos from the crime scene, is that fair to say?
At some point, I probably did, yes.
Okay. And also, during your examination, also you noted that Miss Avery's body was in a state of fully developed rigor mortis.
That is correct.
Okay, and that's a process that occurs after death, correct?
Yes.
And it's fair to say that that process, depending on variables, well, let me ask you this: what do you mean by fully developed?
So. Fully developed, generally, it's kind of a loose concept in that if I try to move some of the larger muscle groups, they're not going to move.
Okay.
Okay, so I'm reading this from a website, right? I think it's massachusettslegislature.gov. But it says murder defined, and it says murder committed with deliberately premeditated malice aforethought or with extreme atrocity or cruelty or in the commission or attempted commission of a crime punishable with death or imprisonment for life is murder in the first degree. Murder which does not appear to be in the first degree is murder in the second degree. So according to here, it's saying he's in Massachusetts. That's where he's at. Murder committed with deliberately premeditated malice aforethought or with extreme atrocity or cruelty or in the commission or attempted commission of a crime. So, I don't know. Atrocious or cruelty, but so to me, it's not saying that it has to be premeditated. It could be premeditated, but if it's not premeditated, then it says or with extreme atrocity or cruelty. I don't know. I don't know. But let's continue on.
And that process can take anywhere from like 24 to 36 hours.
It starts within hours after death, but becomes full 12 to 24.
Okay. And so when you, so it's fair to say that the condition of her body at the time you examined it and at the time of the photos was consistent with the time of death being sometime in the early morning hours of Saturday, January 12th.
That's a possibility, yes.
Okay. And you testified that you examined and it was correct.
That is correct.
And it's true, however, that there's something about your examination that can tell you what order those wounds were incurred.
No.
And also that you can't, there's something about your examination that would allow you to opine about how quickly those wounds were incurred.
No.
I noted that you testified earlier that perhaps the most significant wound was the one labeled "N" on her torso.
Yes.
And it was your testimony that death would happen in that case in a matter of minutes.
Several minutes, yes.
Now, I just want to talk to you briefly about, you testified to some blunt force injuries?
Yes,
Those are essentially bruises in this case.
bruises and scrapes.
Okay, and there was like one abrasion, is that fair to say?
I believe that was on the forehead, yes.
Okay, now, it's also true that you can't necessarily tell in your examination how those wounds were incurred?
In this case, no.
Okay, and it's also possible that those wounds, even if they were incurred at the time of her death, were the result of falling after her injuries?
That is possible.
Okay, and it's also possible that those bruises were totally unrelated?
Yes.
Okay. And just one last question for you. The blunt force injuries, the bruises that you testified about, those were based in part on discoloration, is that fair to say?
For the most part, yes.
Okay, but the jury also saw some potential, or saw some photos, and maybe asked to look closer at some photos that showed some other discoloration of her body, is that correct?
I believe so, yes.
Okay, and so my only question for you is that's a product, that discoloration, if it's not the wounds that you noted, is a product of liver mortis, isn't that correct?
It could be, yes.
Okay, specifically discoloration on her back?
Yes.
And that's from the blood pooling while she's on her back?
That's correct.
Okay. No further questions.
Maybe direct, Mr. Green.
No, thank you.
All right, thank you very much, Doctor.
You're welcome.
John, I believe previous O for ID, would like to submit now as an exhibit. I don't know, but
83 if there's no redacted version of O for ID.
Yes.
Do you remember what I told you about redactions? Do not speculate about what's not in there. It's simply not evidence. It's out for evidentiary reasons that don't concern you.
And with that, the Commonwealth would rest.
Commonwealth rests.
May we
Take to be seen, please. Yeah.
Okay, at that point, the state rests. Now it's the defense's turn. No God's wonder this thing is going to deliberation so soon. So, okay, like I said, they sped through their witnesses. Boom, boom, bang, bang, boom, right? QB says many states require premeditation as an element of first degree. Well, and I'm not 100% sure that they don't, or if it's I know that they're mentioning the cruelty and atrocious atrocity, however they said that. But I know things like that vary from one state to the next, oddly. But I'm going to skip on through and see if we can find they take a little bit of a break maybe, or if they go straight into the defense's stuff. Okay.
Yes, I would recall at this time Detective Mazza.
Detective Mazza, recalled.
Jury's your answer one more time, sir. Do you solemnly swear that the evidence you will give this court and jury in the case of the San Juan trial shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please resume the stand.
Thank you, Detective Mazza. For sticking with us just a little bit longer. May I approach?
Yes, reapproach.
Do you recognize what that is?
Yes.
Okay, what can you tell the jury what you're looking at?
So the map quest, or some sort of picture of a map of North Elm Street, like pretty much down the bridges in Westfield.
Okay, and you're a Westfield police officer, so you're very familiar with Westfield, in that particular part of Westfield?
Yes.
I'm gonna give you a pen. If you could, just indicate on there, where the whip is. And, do you see, the address on White Street that we've been talking about? Let me ask you, does that look like, the accurate placement for, the address on White Street?
It does.
Okay, could you just circle that? All right, and now that, if you could just quickly, using that pen, if you could just mark the route that you testified to, when you testified yesterday?
Okay, another little quick break. This may be very beneficial. So I just found this on, I think the website is findlaw.com. I don't know, but anyway, it's Massachusetts first degree murder law. Let me go to where I was at. Where was I looking? Extreme atrocity or cruelty. Here we go. This says a jury gets to decide if this element of the crime was present during the homicide. Various factors that juries can weigh on this element include 1, the amount of conscious suffering the victim experienced and the defendant's disregard of the same. So that right there, remember how they were talking about how Kells said, was he just messing around with her whenever he was doing all these little superficial cuts? You know, was that like before he actually killed her? The degree of the victim's physical injuries, how many times the victim was struck with an instrument or weapon, the type of instrument or weapon used, including fists, and then any other relevant information. And then there's an asterisk, and the asterisk says the prosecution doesn't need to establish any, hold on. Okay, the prosecution doesn't need to establish any deliberate premeditation, just malice aforethought. And then up here it says malice aforethought can include any intent to inflict a serious bodily injury or death upon another person. Maximum life imprisonment without parole. Yeah. All right. Definitely fits that element, right? Okay. I thought that would be good to know. Very welcome. Very, very welcome. All right, let's continue.
It is a little hard to say. I can appreciate that. Now, you testified yesterday that you, as a part of the investigation, went to the Westfield Soup Kitchen to obtain, to see if they had any relevant videos. Is that correct?
Correct.
And do you see where the location of the Westfield Soup Kitchen is on there?
Yeah.
Can you circle that?
Can we mark the individual spots a little differently? Maybe W for whip or S for soup?
Sure,
Just
that'd
so
be
we can
great.
kind of put an H for house and S for soup kitchen. Okay.
Okay. And just to and I'll put this up in just a minute, but the WIP is actually written, is on the map to begin with.
Okay, thank you.
And so you marked the location of the soup kitchen, correct?
Correct.
Okay. May I display this here?
It's not an exhibit yet. Did we mark? We didn't mark it yet, did we?
No objection.
All right, so we'll mark it as an exhibit.
Okay.
Without objection. 84. 84.
And it would be okay with your honor if detective, if you might stand at that screen and just, it's hard to pen, but if you could just with your finger or the pen that's there, show the jury the route that you testified to yesterday.
We may have a pointer. We may have one. Old-fashioned pointer. No, not in this courtroom.
So actually, let me back up first. So now that you've circled those things, can you show the jury where the WIP is on that map? Okay. And
Sorry to interrupt. You need to keep your voice up if you're going to be standing over there. You are picked up.
That's 287 North Elm Street.
Yeah, that's the width.
and can you show the jury where on the map 92 White Street is?
92 White Street, here at the H.
Okay. And can you show the jury where you indicated the soup kitchen?
The kitchen was marked by S, but it's right at the corner of White Street.
Okay. So fair to say, when anybody reaches that point, they are just moments away from that address at 92 White
It's
Street.
very, very close to 92 White Street.
Okay. And now just with you've indicated it in pen, but can you now just trace the route that you testified is the most direct route?
Sure. So North Elm Street south onto North Elm Street towards the Great River Bridge south. You cross the Great River Bridge south here. Every street is this street here. There's a little turnaround heading north on Elm Street. And you're heading east on Meadow Street to White Street, and then you get south towards Elm Street.
Okay, thank you. You can see.
Just have my back door today.
Yesterday you testified a little bit about those videos that you said that you obtained, correct?
Correct.
And you had an opportunity, I believe, today or this morning to review those videos again with the district attorney a second ago.
Correct.
And you understand that these videos were preserved and given to the DA's office, correct?
Yes, correct.
And you had an opportunity to review.
I did.
Before we look at those videos, I just have a couple more questions for you. Showing you 3 pictures from Google Maps. Do you recognize what those are?
I do.
And what is that?
One is a picture directly in front of 101 Meadow Street. One is a picture on White Street, but of the same building, 101 Meadow Street, and one is of the driveway from 101 Meadow Street. I believe the camera's right here in that photograph.
Okay.
Oh, no, no, there it is.
Great. Can you circle it? Just maybe white camera. I offer these to exhibit.
No objection.
However you wish, Martin.
What is there? 3 of them there? 3, yeah.
3, yes.
You said
All right, so they'll be 85, 86, and 87.
oh, yes.
So I'm gonna have my colleague play. Actually, I'd offer at this time the videos that don't drive as an exhibit as well.
All right. Agreeing any objection?
No, Your Honor.
All right, they may be marked. The flash drive itself will be marked in total as the next exhibit.
That will be 88.
Members of the jury, when you get the case to deliberate, we will provide for you a laptop, if you will, to be able to look at any of the digital evidence that you choose to look at that time, okay?
Detective, do you recognize, this is just the beginning of one of those videos, do you recognize what this depicts?
We do.
And what is that?
The front camera at 101 Meadow Street, and it's on Meadow Street.
Okay, and that's the soup kitchen, correct? And I note on there that there is a timestamp.
Chris.
Okay, now, as part of your job, it's routine for you to look and see if area businesses or anything like that might have video that is relevant to a crime you're investigating. Is that fair to say?
Correct.
Okay, and as part of that job, you would make a note if the business owner who controlled that camera told you anything about the a timestamp being inaccurate, correct?
Correct.
Okay, and you specifically asked for video within the range of, I believe it was midnight and 2 o'clock?
Correct.
And you received more than just this 30 seconds of video, is that fair to say?
I believe I got a small handful of videos.
Okay, and you, from the videos that you received, clipped videos that you thought were relevant, is that fair to say?
Correct.
And what stood out to you as relevant in the video that we're about to see is that it shows a small dark colored car that you believe was consistent with the car that, with the Chevy Cobalt, is that fair to say?
I believe so.
Okay, and in fact, in one of the videos, you indicated in your report that you believed you saw a passenger with a pink colored top on. Is that fair to say?
Correct.
Okay. Is that fair and accurate?
Yes, it is.
Okay. And play the videos 25. Play, yeah. And video 27. Now, those are all sort of successive videos of that car that you believe was consistent with the Chevy Cobalt turning right from Meadow onto White. Is that correct?
Correct.
Okay. And if you can go to the timestamp we discussed. And when you wrote in your report that you believe you saw a passenger with pink video, is this the image that you were?
Correct.
Correct.
Yep.
Okay. And that's why you identified these as relevant.
Correct.
And preserved them for the investigation.
Correct.
I have no further questions.
Agreed.
To, at any point in time, confirm exactly who was in that car?
No, I didn't.
Were you able to see, very briefly, Detective, were you able to see a license plate in any of those videos for that vehicle?
No, sir, I was not.
Were you able to, at any point in time, confirm exactly who was in that car?
No, I did not.
And as far as the timestamp on the videos go, did you go down to the soup kitchen and look at your phone and the thing and say, aha, yes, they're exactly right?
I did not.
So you're just making a,
Objection, Your Honor.
Sustained.
so let me ask you this, how do you know that those timestamps are accurate?
Objection, Your Honor.
That's overruled. I don't. Anything further?
This camera these cameras were on private property, is that correct?
Correct.
So in order to get these, you have to go and talk to whoever controls the property and say, hey, we're looking for this video. Do you have anything? Is that fair to say?
Yes.
Okay. And it's very much the case that that in other cases, sometimes the timestamp is off. Is that fair to say?
It is.
And And if you discover that at the time, you would make a note of it in your report, correct?
Yes.
And it's often the case that whoever owns that property and runs that camera will let you know, hey, the timestamp is off. Is that fair to say?
Yes.
Okay. And you wrote a report in this case?
I did.
Right? And you didn't make any note whatsoever, correct?
I did not.
All right. So sitting here today, you don't have any information that that timestamp is incorrect.
I do not.
Thank you very much for taking on this. Anything further?
Nothing further, Your Honor.
Defense rests. The evidence is closed. All right, so if you put your notebooks down, we're going to send you home for the night because I have some matters to discuss with the lawyers. We're going to have the closing arguments and legal charge tomorrow morning. So the first instruction I'll remind you is easy. The evidence is closed, but the closing arguments in this case are going to be very.
I did.
Right? And you didn't make any note whatsoever, correct?
I did not.
All right. So sitting here today, you don't have any information that that timestamp is incorrect.
I do not.
Thank you very much for taking on this. Further.
Nothing further, Your Honor.
Defense rests. The evidence is closed. All right.
Okay, sorry, I had to rewind that back a quick second to make sure I understood. Yeah, they're done. The defense rests their case as well. All right, let's scooch on through, see what he says, and then we'll start today. Hold on a second, guys. Let's get through this.
So if you put your notebooks down, we're going to send you home for the night because I have some matters to discuss with the lawyers. We're going to have the closing arguments and legal charge tomorrow morning. So the first instruction I'll remind you is easy. The evidence is closed, but the closing arguments in this case are going to be very helpful to you, and you don't have the law yet. So keep an open mind until that occurs, and until I tell you to start your deliberations. As you well know, you're to decide this case based only on the evidence that we've all seen and heard in this courtroom during the course of these 2 days of trial, yesterday and today. That means that throughout the entire course of the trial until the verdict is reached, you must not search the internet, website, blogs, or help you to. You'll have plenty of time when you deliver. Of the voluntary manslaughter.
Yes, and
I just heard him say something about involuntary manslaughter. Is that what did I just hear him say that? I'm going to see what that was about.
Will consider the defendant to have filed the oral motion at the conclusion of all the evidence which to protect the record, which is also denied. Your rights are reserved, okay? So let's have a discussion. I don't have any requests for jury instructions, but I don't think there's going to be anything unusual with the exception of this issue of the voluntary manslaughter.
yes, and the Commonwealth would also request a consciousness of guilt.
I have that in there. I may have a pretty decent working draft that's out of format, but it will be formatted by the time I get it in your hands. So let's talk about the voluntary manslaughter instruction. You're asking for that, right?
Yes.
Okay. Tell me under these facts how you think it applies, or why you think it applies.
Yeah, and I have a memo that lays this out as well.
It would be helpful to have it.
Submit.
Yeah.
But I was working on it during lunch, so I can print that out for
Okay.
Your Honor. Thank you. I'm gonna go through here. So, first of all, just looking at the burden, defendant is entitled to a manslaughter instruction if any view of the evidence would permit a verdict of manslaughter, and the facts are to be taken in the light most favorable to Mr. Scanlon.
So tell me what facts we heard that you think in the light most favorable to Mr. Scanlon would entitle him to that instruction.
Right. So, first of all, he witnessed this contact between Ms. Avery and Mr. Burns. That is recognized in the law as something that can cause reasonable provocation. This is in my memo, but I would just point the court to a case called Commonwealth versus Valentin, which discusses discusses kind of the nature of the relationship between the parties that you would need to allow for this type of contact to be sufficiently provoking. And one of the pieces of that is,
Give me the set on that.
sure, it's 747 Mass 301. It's a 2016 case.
301, okay.
And in that case, it focuses in on the defendant's reasonable expectation if the person that he's dating, or that he's still dating, if he has a reasonable expectation that she would not become romantically involved with other people.
So tell me why. You got a couple things there. You have one, that they're dating. On what view of the evidence was the defendant and Alexis dating?
So we heard some
at the time, at that day,
yeah.
right?
I'm going to start earlier, but I'm going to get there. So we had evidence that their relationship was on and off, that they reconciled many times. We had some evidence that they had, I promise, we had some evidence that that Ms. Avery had expressed an intention to break up on January 1st. We also had evidence that they continued living together. They continued parenting their child together. That
there was no evidence on and off after January 1st. There was a history of the relationship being on and off, right?
That's right.
Okay.
That's right. We don't know what they talked about during that time. Ms. Avery had a Facebook account where she still listed that she was in a relationship with Mr. Scanlon.
No evidence that he knew about that.
No evidence that he knew about that.
Right.
But it could provide evidence as to how she was acting toward him. I think there's a reasonable inference from that.
Okay.
And in the light most favorable to Mr. Scanlon, I think you have to make that inference, actually. So these facts are taken in the light most favorable to Mr. Scanlon. And I would point out,
there was not even really any evidence as to when that separate Facebook was created, but
there was evidence that it existed, at least in the time shortly after she was.
how is it a reasonable inference that he would have seen her Facebook? There was no evidence that he was.
So I'm not making an inference that Mr. Scanlon saw her Facebook.
Okay.
I'm making an inference.
You're making the argument that because she left one of her Facebook accounts in a relationship that it suggests what she may have said and done with him between January 1st and.
Yeah, there was continued ambiguity. If you have people who are on and off, she may have made a statement on January 1st that she intended to break up with him, but they're still living together. They're still parenting their child.
There's the conversation on the 1st, right? And then there's the text, which I think was January 10th, right? That he wrote to her.
Right.
Right? So it would have to be after January, it would have to be something after January 10th that would lead him to have some reasonable expectation that the relationship was still ongoing, because that was not.
I don't think the state of the law is that there's an expectation that the relationship is ongoing. I think it's the reasonable expectation that this wouldn't be occurring yet. And
Is that the law?
I would point the court to Valentin.
The issue is.
On this point, I would point the court to Valentin, and it is far less clear than relationship versus no relationship.
And the question is not her conduct at all. The question is what would the effect be on him under the circumstances? And I would suggest here that they have a home together. It's clear they have a home together. If there was any discussion of him moving out, it was not happening yet. But there's evidence that they were still continuing to share a very small apartment and in fact a bedroom. And that was still the case.
There's no evidence in the case that they shared a bedroom. There was no testimony or evidence in the case that they shared a bedroom. In the light most favorable to your client, there's evidence that they lived together in that spot.
And a 2-bedroom apartment, only one of which had an adult bed. I think that's shown in the pictures and in the testimony. So the issue here is in the light most favorable. Is the provocation, is the emotional upset in the moment about whether or not that would have happened under those circumstances at that time, given their relationship? Not that
There's a lot of cases that talk about that this wasn't of course you caught them having sex in the back of the car, and that was a sudden event, right? we'll talk in a quick few moments about the fact that it was a private vehicle and he entered it without authority, which is, I'm not sure what the crime is, but I'm sure it's a crime. But so, and I'm not sure that matters to the analysis, but he knew, the evidence, the state of the evidence is that he knew he was not invited to go out based upon the testimony of Mr. Burns. You can argue that he did not show up at the Maple Leaf because he didn't remember being there. So I guess so he followed them at least to Whip, and the testimony was that he saw them being romantically involved at the time, and said, if he keeps doing that, I'm going to F him up, right? So it's not. There's cases that talk about the fact that a defendant who had knowledge of infidelity, and we'll kind of put that aside for the moment, infidelity, he's not entitled to the shock of seeing kind of the logical extension of that. There's some pretty good case law on that. So tell me about that. I mean, that's the state of the evidence, that he knew she was with somebody.
He saw that night, although that's part of, I would argue, under the circumstances and the current state of the relationship, part of the provocation, and then knowing that he was there and that him seeing that, and here's the thing. The question isn't whether or not this defense is.
No, I get it. There's any reasonable view of the evidence, but I struggle and I listen hard for any reasonable view of the evidence to support that. So that's why I'm having this conversation. Just try to figure out.
Right. I mean, I think the bottom line is that within. So the timeline is that there was the discovery. Mr. Burns ordered the Uber at 1:19 a.m. according to the Uber records. We have video of them being literally seconds away from home by 1:21.
He said he waited till they left, so it's minutes. I mean, under any scenario, it's minutes, but between Whip and there, okay.
And the question of cooling off is certainly a fact one for the jury. Under the circumstances, though, that in the light most favorable to Mr.
Yeah, there's some
Scanlon,
good law for you on cooling off. I think one of them was like 7 hours.
It is, Andrade.
So I'm not concerned about the cooling off piece.
right? In which case, then we're just left with whether or not this pretty, criminal law textbook aspect, version of this discovery is, he ought to have the benefit of this instruction. And I would suggest that it's a constitutional due process, proportions.
The SJC just got rid of it for oral disclosure, so it's not quite that. So let's talk about where we stand after this case. Rocky.
Can I talk about Rocky? Can I just point the court to one more case for your consideration, which is Escobar, the case that came out last week, is, I would say, very supportive of Mr. Scanlon's position in terms of the...
There was evidence in Escobar that the fight continued into the alley, right?
There was some evidence of that.
That's why the SJC said.
But very, very thin evidence of that.
Right, but what evidence do we have here of kind of some ongoing shock?
Well,
It's different. Escobar's.
It's different.
Yeah.
We do have some evidence from Mr. Burns of as they were leaving the car, some argumentative speech.
And
In the parking lot.
Yes.
And her statement that she didn't want to be with him, she wanted to be with this other guy. And I would argue that is, in the light most favorable to the Commonwealth, is, to us, to the defendant, to extend that period. And again, that's a question of fact. If I can address Rocky for just a moment.
Yeah, we're going to talk about that.
That of course is an interesting and relevant case. It is very clear that the court has, very firmly said that a oral disclosure or discovery of infidelity is not sufficient. It is, and I know Justice Cypher's concurrence in that case. However, until the SJC has clearly overruled this clear iteration of manslaughter, that it's a constitutional due process right to present a defense.
Well, you have a right to present a defense if it's a legally recognized defense. So if it was an oral disclosure here, you would have no right to present this defense.
I agree.
So, I mean, the case says the exception, which they are eliminating, rests on shaky misogynistic foundation that has no place in our modern jurisprudence. What's the difference between an oral disclosure and seeing somebody in the back of a car having sex?
That is.
Why wouldn't this SJC, because they didn't read, I'm sorry, I'm just talking out loud to try to think this through, okay? The SJC did not reach this issue that we have here in that case because they didn't have the facts. The facts weren't what we have here. So as you know, appellate courts don't reach farther than they have to. So they had an oral here and they left for some other day this particular issue. I'm sure that the Commonwealth's going to tell me this is the case, and I want to hear from you why it's not.
Right, and you're correct, they don't reach farther than they have to. And since they have not, it remains good law. And that's where you get into the constitutional right to present a defense. Until and unless it is struck down, it is available. And in the light most common to the defendant, it remains the standard. Even if, Your Honor, it is very much the case that even if Your Honor gives this, the SJC may reach this on the merits, depending on how this turns out anyway, even if you give it. But until and unless the SJC, and that concurrence is interesting because it very specifically says we don't reach this issue.
Because they don't do that when they don't have the facts. They don't. Appellate courts don't reach issues that aren't presented to them. They address the facts in the case that they have. So they just left it open to plop down here in the courtroom for me to make the call. I mean,
Well, and I would suggest to you that, I think, maybe it's a little bit of speculation on my part, but if the result, if you were to not give the instruction, that it still would be a constitutional deprivation. It is possible that the SJC were to find a constitutional violation, give them a new trial, and in the process then strike down explicitly this defense or this mitigation. But it is not for the trial court to take off the books an existing defense that's still within the law. Especially when the case that you're relying on looking at very clearly says
trial courts have to make the call every day, every courtroom, on what the SJC means in this case and how does it apply to this case. So I haven't decided yet, but I'm not. The facts of this case aren't. On this case, I'm not sure that the SJC wouldn't agree with me if I don't give the instruction. But tell me why. I want to fully air this out so that we all at least have a record.
I think because the standard is in the light most favorable to the defendant, and there is evidence, and it doesn't have to be much, but that there was, an ongoing relationship, they were co-parenting, they were sharing a home, and that there were expectations about how being confronted with that activity in that circumstance would affect Mr. Scanlon in that circumstance, and that's the standard. Is in the light most favorable. Is there the provocation reasonable in the circumstances? Now, in not giving the instruction, that's saying as a matter of law it's not, and I'm suggesting that it is a jury question.
Okay. Who wants to handle this for the Commonwealth? I'll come back to you. If there's anything else we need to cover, we can cover it, but
May I approach with a memo?
Yeah, sure.
Whoa, this guy, this prosecutor is like, he's got a PowerPoint. He's got everybody their very own copy of why they're all wrong. Okay. I'm sorry. I just thought that was kind of cute. Yeah, I'm eager to see what he says. I hope he's like, let me throw a bomb on that idea. Let me throw a bomb on this idea. Yeah, no.
Your Honor, so I think we start with the facts that have been proven in this case, and we go from there. And
Not proven, just the way most favorable to the defendant, right?
yes, so the evidence, in the world of evidence before the court, this jury could infer the following facts. That on January 10th, Friday, we start January 1st, Caitlin Avery is present during a conversation between Mr. Scanlon and Alexis Avery in which she says, I don't want to be with you anymore. That's January 1st.
Right.
On January 10th, the defendant, if you believe the text messages, acknowledges the fact that their relationship is over and says, can we just still love and raise Darla together?
Right.
So again, from the 1st to the 10th, there's no indication that this relationship was somehow rekindled or changed in any event.
I agree with you. There's nothing in between, there's no evidence between those two dates at all. It's empty. I'm not even sure there's an inference to be drawn by the fact that there's a Facebook indicating they were still in a relationship that somehow informs how she was acting toward him. I'm not sure that's...
I'm not sure it matters how Ms. Avery was acting towards the defendant. It was his state of mind that's relevant. So then we go to the evening of this incident.
Well, whether he had any reason to believe that the relationship was in some limbo status and not 100% over. That's their argument. I'm not arguing with you. Now I'm doing to you what I did to them. I want to hear you out.
And I think that it's the evidence is quite clear that this wasn't in limbo. There was a direct conversation on the 1st. That conversation was confirmed by the defendant on the 10th. And then if you recall the testimony of Caitlin Avery on the 11th, as they're getting ready to go out for their girls' night, she testified that the defendant is moping around the house saying, I can't believe my family's leaving me. So again, from the 1st to the 10th, and even on the night of this incident, all of the evidence suggests that this defendant knows his relationship is over with Alexis Avery. The fact that they may still have shared the same residence, I don't think really moves the needle. This defendant's state of mind is what is the key issue. And from January 1st to the 10th to the 11th, by his own words, he knows this relationship is over. And then we get to whether or not this was some sort of sudden revelation of infidelity. First of all, I don't think you can have infidelity if you're not together. So that's point one. But the second thing I would suggest to the court is that Mr. Scanlon didn't just happen upon these two individuals and see something alarming and shocking. He, and the evidence may suggest, sought out Alexis Avery that night to see what she was doing. And at the Maple Leaf, there was testimony from Caitlin that Scott and Alexis were making out at the bar and the defendant was there. And
you're stuck with Burns' testimony, though, that he didn't see the guy there.
He doesn't know him. But yes, but we have
the jury's free to accept that as though he wasn't there. It's thin, but it's there. So
I agree, but I would suggest that the more credible testimony is from.
Can't do credibility today.
Caitlin Avery had a conversation with this defendant at the Maple Leaf. That's what she testified to. That puts him there. So again, the fact that Scott Burns, who has never met this guy before in his life, didn't see him there is irrelevant as to what Mr. Scanlon thought. The question is,
you're gonna have to live with what Burns said. I mean, I'm viewing you can argue to the jury.
I understand. I don't think it's living with what he said. He just didn't.
No,
he said he didn't remember.
For purposes of today's discussion about where the defendant was in the light most favorable to the defendant, you have to accept that.
He said he didn't remember seeing him there, but he also said he never met him before.
Okay.
But Caitlin Avery's testimony, again, that's a credibility thing.
Yeah.
She knows Blake Scanlon. She's known him for years, and she said he was there.
Mm-hmm.
and that Alexis and Mr. Burns were being very open about their display of affection. So if a fact finder were to believe that, which I think is certainly possible, likely, then we have information that the defendant then follows somehow. He wasn't told where they were going. He then ends up at the exact same next place where, and again, the testimony was,
the best you can do is that I'm just saying in the light most favorable to the defendant,
right?
The best you can do is that he showed up at the Maple Leaf.
He did.
Not
why,
Whip,
I understand.
Whip. He showed up at Whip, not the Maple Leaf.
Correct. Caitlin Avery testified that after Blake showed up at the Maple Leaf, they paid their tabs and went someplace else.
Right. Okay.
So then they go to the Whip. And at the Whip, again, there's really not a lot of dispute about what happened at the Whip. Right. But again, I'm suggesting to the court that, assuming the time frames are all approximate here, sometime around 11 or 11:30, the defendant is present, standing in the corner, focused and watching Alexis and Scott making out at the bar. That was her testimony. There was nothing to controvert that. In fact, it became so apparent that Caitlin took the defendant outside and said to him, "What are you doing? Leave him alone." And at that point in time, there's no sudden revelation. He's potentially seen them together at two places. That would be my suggestion to the court. But certainly he's seen them together for an hour or so at the second place. But I think that there's a very strong, the fact that Scott Burns said he didn't remember seeing him, Caitlin Avery said they left because of him. He was at the Maple Leaf, he was at the Whip, he was following them around, he saw what was happening. And when he opens the car door, this evidence is uncontroverted. Scott Burns said he was oddly calm. He opened the door, he didn't raise his voice, he didn't threaten anybody. He simply said, "Get your things, let's go."
And then they argued. She told him, and then the testimony was she told him, "I want to be with him, I don't want to be with you."
Correct.
And then voices rose.
Slightly. But he didn't say anything, he didn't witness any physical violence at that time. And actually, he said that he didn't really notice raised voices. He agreed with one of defense's characterizations as, could it have been argumentative? And he said possibly. But again, this wasn't a heated verbal exchange at the scene of this sudden revelation.
Would it be a fair inference that their argument continued on the way home for the 2 or 3 minutes it took?
I don't know. Every couple's different, every situation's different. I don't think that's a fair inference.
Okay.
I mean, they drove home, however long that took. We agree it's a short ride, but they went from one place to another. I don't think we can infer what was said in that car. Right? They could have sat in silence. They could have argued. Again, that's purely, wildly speculative. All we know is that nothing happened in the parking lot and something happened at the apartment. When you add all of that up, there's no sudden revelation of infidelity. They were broken up. They'd been broken up for almost 2 weeks. He acknowledged it himself in text messages and in his statements before they went out that night without him. I think the defense has a very tough hill to climb to get to evidence that would even remotely suggest that this is a warranted instruction in light of these specific facts. And as far as the cases go, the memo that we've submitted also cites Valentin. And that's a particularly important case. In that case, and I think the site was wrong that counsel gave you, it's 474 Mass 301. But in any event, it's cited in the memo. In that case, the court found that there was no reasonable provocation where the victim and defendant's relationship had ended several hours prior to the shooting. Hours. This relationship ended weeks prior to this event. So I think that the cases are in line with the facts of this particular matter that do not warrant a manslaughter instruction under these facts for these jurors.
All right, is there anything else you want to talk to me about in terms of jury instructions other than the standard instructions?
Yes, so I think we're gonna have requests for mental impairment instruction as to first degree and second degree intent, both on voluntary.
Not mental impairment, you're talking about alcohol.
No, both mental impairment based on Mr. Scanlon's suicide attempts following the killing, and then also on intoxication.
Not giving you the mental impairment. All right. Alcohol, yes, there's some evidence of that.
So we have that, and then for your Honor's consideration in my memo, I have a involuntary manslaughter instruction, and I would cite the court to Commonwealth versus Gray, which is a 1987 case, which states that if you have a mental impairment instruction, a voluntary or a manslaughter instruction is warranted. And I think in that case, it would be an involuntary manslaughter instruction, so I would submit that to the court for your consideration.
What is the case again?
It's Commonwealth versus Gray. I can give you the site.
Greg?
Gray, as in the color, but spelled with an E. Gray is 399, Mass 469. And the pin site is 474.
What does that case say, you say? What do you tell me?
What that case says is that where a mental impairment instruction is warranted, so too is a manslaughter instruction. It's specifically about mitigating second degree intent in that case. Mental impairment mitigating
voluntary manslaughter instruction you're talking about, or a voluntary manslaughter?
So, I mean, if you look at the model instructions, there's really no accommodation for this particular problem. So I think I believe it's an involuntary manslaughter instruction at that point. None of the voluntary manslaughter instructions really go with mental impairment. And what the case says is that where you're mitigating the specific.
Like, you have someone stabbed 28 times.
Yes.
So tell me how you can get an involuntary manslaughter instruction.
Just specifically from this case, it says that it mitigates murderous intent. And I think that mitigates down to involuntary manslaughter. I guess alternatively, I would suggest to the court that you say that to the extent that the jury finds that second degree intent is impaired, they can return a verdict of manslaughter.
And if I could just be heard briefly on intoxication defense.
I had it in the draft, Mr. Green.
I understand. I just want to just state the obvious. There was only evidence that sometime before 8 o'clock that night, the defendant took a few swigs of alcohol. And then Caitlin Avery specifically said, I did not see him drink again the rest of the night. And she said that she had been with him in the past when he was intoxicated, that he was not intoxicated, in her opinion, in this case, at that later hour at the bar.
The testimony about him taking 4 or 5 swigs or gulps or sip, whatever it was,
that was at 8 o'clock at night. Before 8, we knew he left at 8. So even if, and again, we don't know when this murder occurred, but we know that the defendant encountered the victim and Mr. Burns in his truck sometime around 1 a.m. That's 5 hours later with no other evidence at all that he was drinking or impaired. It's speculative at this point to even suggest that the defendant was under the influence.
What else do you have?
Just 2 things. One, again, we're in the light most favorable to the.
I'm with you.
It's always a fair inference that people are drinking in a bar. I think that's always a fair inference in the absence of one witness, not seeing a person drink is not evidence that no alcohol consumption occurred, especially when, her testimony was, along the lines of, taking these big swigs and indicating that Mr. Scanlon was drinking that night. So I'm not suggesting that it is an enormous amount of evidence, but it is enough to justify and to require
Well, it's in there now. Anything else in particular?
No.
You want to get me whatever request you have, or whatever memo you have, in whatever shape it's in, frankly. All right. All right. So I'll see you at 9. Anything else? Word? Oh, yeah, in Word would be good. No, I don't need it in Word. I have the instruction. I don't need your memos or your instructions in Word. I have them all. I mean, I have the voluntary manslaughter in the instruction as a placeholder, just now, but I want to hear from you.
In order to, prepare closing,
How much time do you need?
as much as you can give me, right? I mean, it'll be a very dramatically different closing,
Well,
depending on the
it's a half an hour, right? You don't need more than 45 minutes, do you?
Oh, in terms of time?
Yeah.
Oh, no, I don't think I'm gonna need that much time. I meant in terms of knowing in advance whether or not we were getting the instructions.
Oh. Well, I can't tell you that right this moment, but I'll let Mr. Walsh know. He'll let you know, okay?
Okay, thank you. Just, I'll be checking my email.
He works around the clock. That's his reputation. Anything else?
No.
All right. Yeah, I'm stepping up. I'm going stepping up.
All right.
Okay, now let me run over and grab day number 3, and we will be getting to the closing arguments. Hold on. How's everybody doing in the chat? Are y'all doing okay? Anybody need a wee break? Anybody need a snack break? Anybody need gotta get up and go take the dog out to use the potty break? Now's your time. Now's your time. Now's your time. Hold on, y'all. Hold on to your horses. Live. Okay. Puppy, can you quit scratching? Dear dog. Okay, hold on just a moment. All right, so okay, hold on just a second. Let me fast forward it and get to the spot where we need to be. Okay. Hold on, hold on. All right, let me share this page. Jalyn says, yep, the dog needs a pee walk. I'll take a break. You be here in a minute whenever we get started. Okay, Spin. See you when you get back. All right, let me share this screen here. La 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 la. All right. Let me make sure that we are still. Okay, I want to go back to 1.25. All right, let's go.
Jerry Andrew, all right.
All right, welcome back, members of the jury. Thank you all for your service in this matter. So the questions, has any member of our jury had any difficulty whatsoever in following the instructions that I gave you before we broke for the day yesterday, or do you know of anybody that has had any difficulty following those instructions?
Are they going to be like this again
To see no
today?
affirmative response. Has any member of the jury heard, seen, or come across any matter or issue or fact pertaining to this case or the subject matter of this case since we were last together yesterday afternoon? I see no affirmative response. And finally, does any member of our jury have any private matter or concern regarding your continued service as a trial juror in this case that you wish to discuss with me privately before we proceed? I see no affirmative response. The jury stands indifferent. So, members of the jury, you're about to hear closing arguments by the attorneys. This is an important part of the trial because it is the final opportunity given to the lawyers to address you. It is an opportunity for the lawyers to summarize the evidence, to call to your attention certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you are about to hear is not evidence. The lawyers are not witnesses. All of the evidence in this case has been presented through the testimony of the witnesses and the exhibits, which you will have an opportunity to examine and consider during the course of your deliberations on this case. Our rules are designed to ensure that the parties receive a fair trial, and the rules therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the attorneys are not permitted to refer to facts that are not in evidence in this case. They are not permitted to suggest that you should draw inferences that are not fairly based on the evidence. If based upon your memory and understanding of the evidence, a lawyer does this, you should and must disregard that comment. The attorneys are not permitted to express their personal belief in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you, the jury, to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided solely on the basis of admissible evidence and the law that I give to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If you become conscious of any passion or prejudice as you consider the evidence or engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. If a lawyer makes such a comment, you should disregard that comment. We are now prepared and ready for the closing arguments. I'll invite Attorney Elkins to do so.
Good morning. In a few minutes after I speak and after 88 Green speaks, the judge is going to be explaining to you that in charging Blake Scanlon with first-degree murder, that the Commonwealth has taken upon itself to prove every element of murder beyond reasonable doubt. And of course, that's their burden. But the judge is also going to be explaining to you that in charging Mr. Scanlon that way, they have also taken upon themselves the burden of proving beyond a reasonable doubt that there was no mitigation. And the judge is going to explain to you what that means. And in this case, specifically what it means is that the judge is going to talk to you about how that there are some things that are so in the experience of human experience that reasonable people can experience overwhelm, anger, emotion, such that they can't control themselves. And that is something that you can consider. And what this means when you begin your deliberation, you must, for a moment, at least in your discussions, put aside the outcome, the very horrible, terrible outcome, and spend some time wrestling with what led up to this tragedy. Now, one thing is clear. Miss Avery, Mr. Scanlon, at the time of this incident, were still in a relationship. That doesn't mean that a split wasn't coming. It doesn't mean that that hadn't been communicated to Mr. Scanlon, to Blake. Were they splitting up? Yes, they were. But on this night, they had at that point been on again and off again since at least 2016. They had committed in June of 2018 to living together because a baby was on the way. They committed to living together, to making a family together, and making a home together. And Mr. Scanlon, Blake was there in August when Darla was born. He was there at Christmas, celebrating that first Christmas together. They were there. They were a family. They were a home. And he was working during that time. You'll see in some of the text messages that are before you that he was working to provide for his family, for their home. And this is where I'm asking you all to look at this circumstance, which is undoubtedly inconceivable to every one of us in here. But to say to yourself and step back from that outcome, that inconceivable, horrible outcome, and think about the fact that when you have a child and when you have a home together, even if things are coming to an end, it's not just as simple as saying out loud, I want this to be over, and that everything in your entire life changes immediately. The love and care and concern that you each have for each other doesn't just turn off like a light switch. And in that moment, on January 11th, 2019, yes, the relationship was ending. The logistics of who was moving and where they were going and when that was happening was certainly in the air. But Blake, at that moment, had every reason to hope, and I think every one of us would hope in that situation, the splitting up of a family, the breaking up of a home, that as you're charting a course for what life looks like after that split, as you're each finding what family and home looks like after you part, that you'll consider each other. And certainly the time was coming when they would need to expect to be out in the world and see each other with other people, and to even know that they were intimate with other people. Certainly that time was coming. But on that night, they were still sleeping under the same roof, in the same home. They were raising their child. They were in an adult relationship with adult considerations that don't just turn off as if you're breaking up overnight. By all appearances, the evidence in every way suggests they were both coming home to 92 White Street that night, whatever their separate plans were. And so, of course, when Blake Scanlon opened the door to that truck, he was devastated. He was distraught. Anybody would be. This is the part where you have to put aside the outcome for a moment and consider in that moment, would reasonable people be upset and overwhelmed in that moment? And I suggest to you, beyond reasonable doubt, they would be. And listen, fault Blake if you must. In fact, I'm asking you, I'm saying you should fault Blake for not turning away when he saw them in the bar and saw what he saw in the bar. And fault him if you must for going to the whip. Absolutely. He should have removed himself from the situation. I can't disagree with that. But Alexis knew he was there too. Alexis knew she was going home that night with him. And when he opened that door to the truck, it was because of what he had seen. And of course, he saw what he saw. And so you have to ask yourself for just a minute, what can you know about how Blake felt in that moment when he opened that door? Well, first of all, what can you tell about that moment from Scott Burns' testimony? Well, it was the briefest of glimpses. It was a moment that for Mr. Burns was startling too, embarrassing, perhaps. And I'd suggest it was probably confusing, given what he thought he understood about the person he was with. But what it says about how Blake felt in that moment is very little, because it was a brief glimpse. It was just a moment. And Scott was having to pull himself together as well. And how confusing is this moment for Scott, and how brief is that moment? He forgets all about who he came with, his friend in the bar, who he's supposed to give a ride home, and he immediately calls for an Uber. And we know what time that happened. It was at 1:19 a.m. You'll see that Uber receipt. But part of what you have to decide is, was Blake Scanlon in fact overwhelmed and distraught? And I would suggest to you that brief moment from Scott Burns doesn't tell us very much about that. But he did hear them arguing. He did hear that it was immediately, we need to go home. And he couldn't see them or where they went, but he heard them arguing, and then they were gone. And so if, like when you put a pot on the stove and you turn on the range, if that's the moment of provocation, if that is the moment when somebody is experiencing something that they would have overwhelm and distraught and, yes, anger and emotion about, the judge is also going to explain to you that the law says that you have to think about time to cool down. What can we expect in terms of, and what does the law require in terms of cooling down before you think about whether or not this mitigates? And I am going to suggest to you, and I say to you, that before you can answer the question of, did he cool down? Was there time for him to cool down? I ask you to think about whether or not the heat had even been turned off at that point in time. By far, the best thing for these two people to have done after that emotional, difficult moment would have been to not go home together, 100%. But I ask you to think about what Scott Burns said he heard Alexa say in that moment, because it tells you a lot about what came in the minutes afterwards. I don't want to be with you, Blake. I want to be with him. And that's not about whether or not she was wrong or terrible, and certainly it's not the case that anything about that situation justified how it ended up. But you're asked to think about the effect that that had on Blake. And you're also, I would suggest to you, tells you a lot about what happened in the minutes that followed. And here's what I mean about that. It took them just minutes to get home. You know that Scott Burns barely got himself together. He doesn't even remember getting out of the car. He immediately orders an Uber at 1:19 a.m. You'll look at those videos that we looked at yesterday, and you'll see that by 1:20 or 1:21, they're turning the corner onto their street. They're literally seconds away. It is just mere minutes from that moment of discovery until they're back to their home. And even as she's getting out of Scott's truck, this is what she's saying. And so there's every reason to infer, every reason, but that was just the first thing she said to him in an argument about what Blake had just seen. A thing that anyone in that situation would have been overwhelmed by. And you can be sure that that discussion continued on that very short car ride home. And when they get to the apartment, the heat stayed on. It's still at a boil. There's not a cooling off period in that scenario. We know that things happened very quickly after they got home, and here's how you can know that. She's still in the same top that she went out in. Nobody got into their pajamas. Nobody turned on the TV. There's no evidence of that. In the kitchen in their small apartment, steps from the door they came in on. They're in the kitchen. There's no place to sit. They're standing. The discussion is continuing. And based on what you heard about what she said when he first discovered it, you can be sure, I suggest to you, you can be sure it is a very fair inference that the nature of that conversation and what she was saying and how things were going, that was not a discussion that was turning the heat down in any way. And so they're in the kitchen. The knife is an impulse away. And I'm sure A.A. Green is going to spend a lot of time talking about the injuries and about the terrible outcome here. And of course, he should. That's his job. But I would ask you to consider one thing about the circumstances of the outcome. What is that kind of outburst, but a loss of control? What is that but irrationality, impulse, and loss of control? All of that occurred within, by any fair estimation of this evidence, within minutes of Blake opening that truck door and seeing what he saw. Now, you're going to see, you know they were home within minutes. And you're going to see that there were text messages between Alexis's phone and Caitlin's phone back and forth. And I'm going to suggest you make of those what you will, about who sent them, about what had gone on in the apartment, in the home before then. But know this, no matter what you think about who sent them and what had happened at that point, it was not even an hour since Blake saw what he saw. Less than an hour of uninterrupted overwhelm in the aftermath of an experience that anybody would find difficult and overwhelming. In the middle of an experience which anybody might react in ways that they just don't understand or know of themselves. The judge is also going to tell you about something called consciousness of guilt. There is a lot this was a very short trial for a murder trial, and a lot of what we talked about was about what happened after we know Miss Avery died. These texts back and forth, Blake answering on her phone as if he is her, and the searches. And the judge is going to tell you that you can consider all those things for consciousness of guilt. And this is what I say to you. Absolutely. Absolutely. In every way, everything about how Blake responded in that distraught and terrible aftermath showed that he was very conscious that he had done a very terrible thing. But that doesn't answer the question of what led into it when it happened. I'd also suggest that those acts, when you consider them, the first thing he does is he tries to kill himself. He tampers with the stove. He texts back in this way. Those are not the actions of someone who had any sort of plan, not even for a minute. Not for what happened, and certainly not for what would happen after he had done the terrible thing. But a point does come when he sobers up, when he awakens to know that he has not done what he set out to do when he tried to kill himself. And he finally just says it. He says he did this terrible thing. Says it to the 911 dispatcher. He says it to his mom in text. He says it to the police. And he is here today through me saying it to you. So yeah, you should consider the consciousness of guilt. But that doesn't answer the question that you're here to answer today, which is, has the Commonwealth proved what it has charged? Every element, every part of it, including the part that maybe we don't even want to allow Blake, which is to say, beyond a reasonable doubt, has the Commonwealth proved that there was no mitigation here, as the judge will explain to you it means. So I am doing something that I don't do very often in this job. I am asking you to find Blake Scanlon guilty. But I'm also asking you to follow the law, to hold the Commonwealth to its burden of proving beyond a reasonable doubt everything that it is charged. Over and over again, Judge Callan has said to you, you have to put, and we said it at sidebar when we were selecting you as a jury. Over and over again, we said you must put aside the anger, the emotion, and the sympathy. And these are all things I very much actually hope you experience when you think about the outcome of this and when you look at those pictures. I wouldn't want a jury that didn't have a reaction to that. That's not what this system is about. But I hold you to your word and the oath that you took. And after speaking to all of you, I believe that you're on this jury because you committed to doing as you said you would, just putting aside the emotion and the anger of the outcome, which is understandable, and considering everything that went into what happened. And I do want to close by saying, when you return a verdict of guilty, as I ask you to do for voluntary manslaughter, you're not saying that anything about what Blake did was okay. I want to be really clear about that. This is not the law saying that, and this is not you saying with that verdict, that anything that Blake did that night was reasonable or excusable or justifiable in any way. That is a much different thing than what I'm asking of you today and what the law demands of you today. When you return that verdict of guilty for voluntary manslaughter, you will be saying that Blake Scanlon is guilty of a terrible and serious violent crime, a crime worthy of a tremendous amount of punishment. But the Commonwealth has not proven beyond a reasonable doubt everything that it must prove for Blake Scanlon to be convicted of murder. Find him guilty. Find him guilty of voluntary manslaughter.
Attorney Green.
Good morning, ladies and gentlemen. Blake Scanlon knew that his relationship with Alexis Avery was over, but he was never going to let her leave him. On New Year's Day of 2019, Alexis told Blake it was over, and she made sure to do it in front of her close friend and cousin, Caitlin, for moral support. On Thursday, January 10th of 2019, the defendant sends a text message to Alexis acknowledging that their relationship was over. And on Friday, January 11th of 2019, before Mr. Scanlon leaves the apartment, he is once again overheard saying and acknowledging that his relationship is over as he mopes around the apartment and says things like, "My family is leaving me." Blake was not part of Alexis's plan that night. In fact, he was not a part of her plan going forward at all. Alexis created a Facebook page that said she was single. She started talking to Scott Burns from her work. Alexis and Scott made plans to go out on a date. And as they were doing so, Alexis and Caitlin were getting ready in their apartment after the defendant left. They were doing their makeup, listening to music, and getting dressed. And Caitlin told you what Alexis was wearing: a pink crop top with jeans that had holes down the sides. Alexis and Caitlin went to the Maple Leaf around 9 p.m. And Scott and his friend showed up shortly thereafter, as was the plan. And Alexis was certainly acting like she was single. Scott thought she was single. Blake knew she was single. He just couldn't accept it. Scott said Alexis was on the lookout for her ex. Caitlin went even further and told you that Alexis kept looking at her phone to see where Blake was because she wanted to avoid running into him. But she did run into him, and it was not by happenstance or coincidence. The defendant followed her to the Maple Leaf, and Caitlin noticed immediately. Alexis was now focused more on Scott, and the two of them were sitting at the bar, openly flirting, hugging, kissing. Scott was also preoccupied with Alexis at that point in time. He didn't know who Blake Scanlon was. He didn't even remember him being at the first bar, but he was. It was because Blake showed up at the first bar that Alexis and Caitlin decided to leave. Let's get out of here. Let's go over to the whip. They paid their tabs, and they told Scott and his friend where they were going. Not Blake. Scott, we're going to go over to the whip. Come meet us over there. And he did. Caitlin's best estimate is that they got to the whip around 10:30 or 11. But it didn't end there. The defendant, once again, found them. Showed up at the whip. Not long after, Alexis and Caitlin were there with Scott and his friend. Alexis and Scott were still hitting it off. They were sitting at the bar, being very open about the flirting and the hugging and the kissing. Caitlin told you that the defendant was standing in the corner by the pool tables, just staring at them and watching them like a hawk. He saw what was happening. So much so that Caitlin grabbed the defendant and took him outside and said, "What are you doing?" And Blake knew what he saw. He said, "Why the fuck are they hugging? If I see that again, I'm going to fuck him up." Caitlin went back in and told Alexis that Blake is seeing what's going on. But Alexis didn't stop. She didn't care. Blake wasn't her boyfriend. Now, the time frame on this is a little unclear, but it will become important. At some point in the night, Alexis misplaced her mother's car fob to the Mazda. And you'll remember that the defendant took Alexis's car that night, and Alexis went and borrowed her mother's car so they could go out. And at some point during that evening, Caitlin and Alexis started to look for that key fob. Now, they didn't bring purses with them. They didn't have a lot of places to look. Alexis didn't have the key fob. They looked inside the bar. They looked outside the bar. They looked everywhere. Caitlin even told you that at some point the defendant was outside helping to look for this key fob. No one found that key fob. Caitlin had to call for a ride home that night. And then at 12:30 or so, Caitlin starts to text Alexis and say, "Hey, where are you? It's getting kind of late." We know by that time that Alexis and Scott had went out into the parking lot, got into his truck, and they began to fool around. The defendant was still inside the bar with Caitlin, continually asking, where is she? Where is she? Caitlin honestly didn't know. But we know where they were because Scott told us. They were in his truck for 10 or 15 minutes, fooling around, things progressed, and they began having sex. The next thing we know is that Blake Scanlon, once again, tracked down Alexis, found them in Scott's truck, opened the door, and told her to get her things. Let's go. Mr. Burns told you that he found the defendant's reaction odd. He was calm. He didn't raise his voice. He did not confront Scott. He barely even acknowledged him. The defendant didn't struggle with Alexis. He didn't put his hands on her. Scott didn't remember the conversation between Alexis and Blake as even being heated or aggressive. On cross-exam, after some nudging by defense counsel, he acknowledged at best that maybe they were talking with raised voices. The last thing Scott remembers Alexis saying was directed at the defendant. I don't want to be with you. I want to be with him. Scott sat in his truck for a few minutes to compose himself and figure out what to do next, and then he made the very wise and responsible choice to call for an Uber. And we know that happened at about 1:19. What we don't know for sure is exactly when Alexis and the defendant left the whip, but we do know they left together, drove back to 92 White Street, very likely passing that Westfield Soup Kitchen sometime around 1:20 a.m. We know that it is a short drive. It's about 1.3 miles. But we also know that at that time of night, when the bars are letting out, there is some traffic. There are 4 stoplights. I can't tell you for sure how long that car ride was, but it was several minutes. And I'm certainly not going to ask you to guess or speculate about what was said, if anything, in that car. We don't know. That's just guesswork. I can't tell you exactly when they got back to the apartment on White Street, but I'm going to suggest some things to you that I believe will help you in deciding what the defendant did that night. And what he did was murder, to be very clear. Judge Cowan is going to instruct you on the law. That's his job and his job alone. If I say anything that doesn't jive with the law, don't listen to me. You listen to Judge Cowan. But I'm going to suggest to you that you're going to hear several legal theories that you're going to have to choose from. First-degree murder will be explained to you by Judge Cowan. And the Commonwealth meets its burden, proves its case in one of two different ways. First-degree murder can either be premeditated murder, which will be explained to you, or it can be extremely cruel and atrocious. The Commonwealth meets its burden of proof for first-degree murder if you find either one or both of those. And listen to Judge Cowan as well when he instructs you about proof beyond a reasonable doubt. It does not mean proof beyond all doubt. Listen closely to what Judge Cowan tells you about the elements of premeditated murder. There is no set time limit. The legislature and the courts didn't say 15 minutes is how long it takes to decide to kill somebody. That's preposterous. It's subjective. It's up to you. Depends on each case and every fact pattern. But what the instruction does tell you quite clearly is that premeditation can be formed over a mere matter of minutes or even seconds. Premeditation is a sequence of events set in motion by the defendant after a period of reflection and having a desire to kill and then carrying out those intentions. You can also find the defendant guilty of first-degree murder by another theory, extreme atrocity and cruelty. And again, please listen carefully to the judge when he tells.
Okay, so let me just say this. As far as premeditation, like he's saying, right, there's no set time. There's no set time for premeditation. It could be minutes or even seconds. So, would it be considered premeditation that he even looked at and saw the knife on the counter, grabbed it, and that was premeditation enough? I don't know. No idea. But now he's getting ready to talk about the atrocity and cruelty part, I think.
Tells you what that means and the factors that you need to consider when contemplating that theory of murder. There are factors that you need to consider, like the number of blows, conscious degree of suffering of the victim. Essentially, was this overkill? You will be instructed by Judge Scanlon that you can consider one other alternate theory of murder in this case called voluntary manslaughter. In fact, it's what defense counsel has asked you to find Mr. Scanlon guilty of. That is an appropriate legal charge, but you can only come to that conclusion if you find that the defendant was so overcome by emotion upon a sudden revelation of seeing his girlfriend having sex with somebody that he was overborne, lost the capacity to consider what he was doing. I'm going to spend the next few minutes telling you all of the very many reasons why this was not manslaughter. And I'm going to start with the first and most obvious. They were not together. She was not his girlfriend. Alexis broke up with Blake 11 days before this happened. The defendant acknowledges that on the 10th of January. He acknowledges that on the 11th of January. Manslaughter requires, again, some sort of sudden revelation of infidelity. The defendant had spent hours on January 11th of 2019 following Alexis around, watching her be romantic with another man. He watched them together at the Maple Leaf. He saw them together at the Whip. He even told Caitlin, "I don't like what I'm seeing." Ladies and gentlemen, not liking what you're seeing is not an excuse. It is not justification to take somebody's life.
Objection, Your Honor.
To stab them.
Go ahead, sir.
It is not a reason to stab somebody 28 times. That is something very different. That is not manslaughter. That is first-degree murder. Blake Scanlon did not confront, attack, or yell at Alexis or Scott when he saw them in that truck. He was not so overcome with emotion that he picked up a rock off the ground and started to beat both of them. That might be manslaughter, but that's not what happened. Blake calmly and coolly said to Alexis, "Get your stuff. Let's go home." Blake Scanlon was able to control himself when he saw Alexis and Scott at the Maple Leaf. Blake Scanlon was able to control himself when he saw Alexis and Scott together at the Whip. Blake Scanlon was even able to control himself when he actually saw Alexis and Scott having sex in the parking lot. Blake Scanlon was able to control himself on the ride back to 92 White Street. Remember, there was no evidence of a struggle in the car. This assault didn't take place on the ride home. The defendant wants you to believe that Blake lost control. That is exactly not what this evidence proves. Blake Scanlon decided to kill Alexis Avery. He decided to do it in the privacy of their apartment. He decided to end her life. He knew that she didn't want to be with him. He had known for weeks. He decided that if he couldn't have her, nobody else was going to have her. He decided where the assault was going to take place. In the privacy of their apartment where there'd be no witnesses or nobody to stop him, no knight in shining armor coming to her rescue. I'm going to ask you to consider this piece of evidence very carefully as well when you're thinking about the defendant's state of mind. Is that on? Check. Thank you. Remember the missing Mazda key fob? Those keys might have seemed like an insignificant detail to you when you heard testimony about them, but those keys tell their own very compelling story. The keys to Alexis's ride home went missing at the Whip. We all know that. Alexis and Caitlin spent a significant amount of time looking for those keys, scouring for those keys. The defendant even joined in the search for those keys. Those keys weren't missing. Those keys were found at 92 White Street. This is Exhibit 35. Those are the Mazda keys that Jessica told you were hers, that she went to Alexis that night to take her car. They're located in the kitchen, right above Alexis's dead body on the kitchen floor. How did those keys get there? Alexis didn't bring them there. She didn't have them. Guess who did? The only other person that went back to White Street that night, Blake Scanlon. He had those keys the whole time when he was looking for them. He was going to make sure she went back to White Street with him that night because he took her keys. The evidence in this case tells even more of a story. The evidence tells you that Blake Scanlon did not attack Alexis Avery the minute they got back to their apartment. Remember what Alexis was wearing when she went out with Scott on her date? A pink top, jeans with holes in them down the sides. This is Exhibit 18. That is Alexis Avery, dead in the kitchen, wearing leggings, no holes. Alexis did what many of us do when we get home from going out that night. She changed into her comfy pants, put on some fuzzy socks. Blake Scanlon waited for her to change. Then he went into the kitchen and got a knife. The mere act of going and getting a weapon is...
The act of going to get a weapon is... There you go. There's your premeditation. I'm going to rewind it because I missed a couple seconds. I was too busy looking up the Sebastian Rogers hashtag on Twitter to see if there was any updates. So let me rewind this back just a couple seconds.
Exhibit 18 tells you. The evidence in this case tells even more of a story. The evidence tells you that Blake Scanlon did not attack Alexis Avery the minute they got back to their apartment. Remember that she went to Alexis that night to take her car. They're located in the kitchen, right above Alexis' dead body on the kitchen floor. How did those keys get there? Alexis didn't bring them there. She didn't have them. Guess who did? The only other person that went back to White Street that night, Blake Scanlon. He had those keys the whole time when he was looking for them.
Okay, also, did we know that the keys were found? Or that the key fob, did we know that already, or is this just now being revealed? I don't remember. I know they talked about the keys being missing, but I thought that I heard someone say that they never to this day had found the keys. But anyway.
He was going to make sure she went back to White Street with him that night because he took her keys. The evidence in this case tells even more of a story. The evidence tells you that Blake Scanlon did not attack Alexis Avery the minute they got back to their apartment. Remember what Alexis was wearing when she went out with Scott on her date? A pink top, jeans with holes in them down the sides. This is Exhibit 18. That is Alexis Avery, dead in the kitchen, wearing leggings, no holes. Alexis did what many of us do when we get home from going out that night. She changed into her comfy pants, put on some fuzzy socks. Blake Scanlon waited for her to change. Then he went into the kitchen and got a knife. The mere act of going and getting a weapon is a choice. And then we know what happened next. He stabbed her 28 times. He stabbed her over and over and over again. Each stab, each thrust of that blade was a choice. It was a calculated, cold-blooded choice.
Objection, Your Honor.
To end her life. And Alexis fought for her life. We know that from the evidence as well. She had numerous, deep, penetrating defensive wounds on her hands, forearms. She had the defendant's DNA embedded in her fingernails as she desperately tried to defend herself, but she couldn't. He just kept stabbing her Stabbed her in the jugular, stabbed her in the stomach, he stabbed her in the chin, he slashed her mouth. He stabbed her in the back. Ladies and gentlemen, that is not manslaughter. That is only one thing. That is first-degree murder under either theory, under both theories. Waiting to commit a crime, choosing where to commit the crime, and then carrying through with that crime is premeditated. And stabbing somebody 28 times, by its very nature, is extremely atrocious and cruel. Any one of those wounds sustained at the hands of the defendant could have killed her, could have been fatal. But he didn't stop with one fatal injury. He kept going and going. That's overkill. That's extreme. And we know, unlike a gunshot to the head that might be quick, being stabbed over and over again 28 times and being left to bleed out on the kitchen floor, as we know did happen, that Alexis suffered. The medical examiner told you it would have taken several minutes for her to die the way she did. This was not a quick death. This was a painful and drawn-out death. That is first-degree murder based on extreme atrocity and cruelty. What happened after the defendant killed Alexis is also quite telling. We know that he killed her sometime in the early morning hours of Saturday, January 12th of 2019. We know that he then used her phone to pretend to beat her while texting Alexis's mother. He kept making excuses, buying time, trying to delay the inevitable. Look at those messages that were downloaded from the phone by Sergeant McNally. Look at how Jessa becomes increasingly worried that she had not heard her daughter's voice in 2 days, had not picked up her baby in 2 days. Look at the last message that Jessica sends to Alexis's phone at 10:49 a.m. on Sunday, January 13th. If I don't hear your voice, I am coming over there and I am calling the police. And then what did the defendant do? At 10:52 a.m., he Googled, how do I mimic a voice? It's just unbelievable. Right up to the very end, when he called 911, he was still trying to figure out a way out of what he had done. But there was no getting out of what he had done. The superficial wounds on his wrists didn't get him out of what he had done. Lighting some papers under the stove didn't get him out of what he had done. After he called 911, and only then did he text his mother to say, I'm sorry, I fucked up. I beg to differ. I fucked up is what you say when you miss your exit route on the highway. I fucked up is what you say when you back out of your garage too fast and hit a garbage can. I fucked up is not what you say when you deliberately, meticulously, and cruelly stab somebody to death 28 times. That is premeditated murder. And it is extreme atrocity and cruelty. Ladies and gentlemen, please find Blake Scanlon guilty of the crime he actually committed, which is only one thing: first-degree murder. Thank you.
All right, so we're going to take a short break because my charge to you is about 45 minutes long, and we've been going a little ways, all right? So I'm going to excuse you out. I'll have you back in about 5 or 10 minutes, all right?
Leave your notepads on the chair, please. Chair Hayden.
All right.
I mean, it's first degree in my mind. I can see where they're going with the voluntary manslaughter, like, oh, he didn't have time to cool down, and it was like a heat of, what do they call that? Crime of passion, in the heat of the moment or whatever, but no. I mean, he was cool, calm, collected, like a cucumber. And he waited until he got her in the privacy of their apartment, like he said. She changed clothes. It's not like, let's just say, for instance, okay, I could see a scenario where they get into a physical altercation in the car, right? I don't know if there was any, like, blood evidence found in the car. They didn't say anything about that. I mean, even if it was he smacks her in the face, bloodies her nose, or anything like that. But if the fight had if the fight had, like, moved from the car into the house, then yeah, you could understand. Like, but Caitlin, her cousin, said she had on blue jeans. So she's went in there. I mean, what's the first thing girls do when they get home? Most girls take their bras off and they put on some comfy pants, right? That's the first thing you do. And that's kind of what, she's went straight in the house, probably arguing. I'm sure they were probably cussing each other all to pieces, but she still felt comfortable enough to go to her bedroom, change her clothes, come back out, and then that's when he decides his attack, in my opinion. Right, like with the car key. Yep. Interesting tidbit, yeah. And they could have easily have said something about that being found at the crime scene. Maybe one of the investigators mentioned it and I missed it. That would have been an easy miss for me. But let me fast forward it and get further along here.
Where I have addressed the matter of the law issue, made a decision, and the case has moved. Assist you in your deliberations. I will provide you with a written copy of these instructions. However, the written instructions are not a substitute for these oral instructions.
Okay, so they're getting ready. They're going through the jury instructions, which is so boring. Jury instructions are super boring. It's just him reading all the things. We can hear it for a few minutes, maybe if they get to the part where, where they talk about the verdict forms. If not, hold on. Let me copy this link. Let me run over here to drop this link for my girls in case they want to come up. Here's the StreamYard link. Okay. Check the poll, check the poll, check the poll, poll. All right, let me go check the poll. Check the poll. Check the poll. Let me go open up a new tab. Find my video. My video. Let me find the video. Okay. Let me pause this video. Sorry. I get on my own dang nerves. I can't help it. Okay, let me see. Okay. Someday when I'm off. Okay, so the poll we have la 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 la. We got 23 votes. Wow. We got 23 votes so far. I'm going to end the poll now. Let me see. What time did they? I need to know. Let me go look and see. What time did they? Let me go through the jury instructions. It can take a while. Let me see what they say here.
An item that is normally used for innocent purposes can become a dangerous weapon if it is intentionally used as.
Okay. Hold on, folks. Bear with me. Bear with me.
Because of the opinion of his or her fellow jurors, or for the mere purpose of returning a verdict. Each of you must decide the case for yourselves, and you should do so only after you've considered all the evidence, discussed it fully and impartially with your fellow jurors, and listened to the views of your fellow jurors. You have all seen and heard the same evidence. You have done so with the same degree of attention. None of you are partisans. You are not advocates. You're judges of the facts of this case. I'm confident that you will discharge your duty faithfully as well as you work to reach a verdict on this case. The counsel need to see me at sidebar. All right? We now need to swear our court officers in. I suggest you pay attention to the oath that they take as well as they're taking it.
Would you all raise your right hands? Do you each solemnly swear that you will keep this jury together in some convenient place until their discharge of the court
Can be sent in.
Okay, I'm pretty sure it's been more than 5 hours. Yeah, I'm pretty sure too. If they were already deliberately when we jumped online, I think it's been more than 5 hours. Yeah. You guys, why you have to be so smart and make me over here be the bad guy that's like 1,000, 2 1,000, 3 1,000, 4 Mississippi, 5 Mississippi. Calling me out for being slow. Really, you guys? Really? Really? All right, let me scroll. I want to make sure that they don't. Hold on. Let me go click the actual live button on the actual video and make sure that I hope I'm not muted right now. Am I muted? Okay, no, I'm not muted. Ay, ay, ay. What do you mean, ma'am? What did I get into? On my break? What are you talking about? Joey, get out of that mess. What do you mean? What did who get into it on what break? Hi, baby. Do 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 do. Hold on, y'all. Okay, so they're still live. They have not come back yet. So, all right. QB's like, hi. She's waving, QB. Can you say hi? Hi. Hi. So cute. So cute. Oh, you got a sticker on your foot? Nice. All right. Let me hit the live button on this. All right. We are live now. Let me go over here. All right, I'm ending the poll. Ending the poll. All right, poll has ended, and the results are in. Ding, 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 ding. A ding, 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 ding. Dun, 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 dun. All right, here we go. Here we go. Here we go. How long do you think the jury will be deliberating the Blake Scanlon trial? So, 60% said 3 to 5 hours. Y'all are wrong. Less than 1 hour was 34%. You're wrong. Over 5 hours, 4%. The over 4 hour. It's the underdogs that are winning in this one. Underdogs. All right, starting a new poll. This one is going to be a good one. All right. Did they give a second degree on the as an option? Yeah, I'm not sure. Somebody help me out. Is second oh, sorry, I see QB backstage. Hold on. Hi, ma'am.
Hi. I have so many questions.
Well, one of my questions for you is Law and Crime has in their poll second degree as one of the options.
Huh. Is that like what they think he should be charged with or what they will come back with? Because I didn't
It
think second
says
degree. Why would they go for manslaughter? I would have pushed second degree
here it
if
says
that
of
was
which charge will the jury find Blake Scanlon guilty? First degree, second degree, or manslaughter?
hmm. I might have missed something. I didn't think second degree was on the table.
I didn't either.
I have questions.
Unless
In the jury instructions
yeah, we might have missed something there. I don't know.
that we don't listen to because they're ridiculous.
Right. Um I'll put I don't I guess I'll put second degree.
I feel like
I didn't know that that was on the table, but
me either.
Um, let me hold on. Let me scroll through this. For it to be as long as it's been though, I'm kind of makes me a little bit now knowing that it's been over 5 hours.
Yeah, it's well, you came on around noon without telling nobody. And then
It was 11:15.
was it?
Mhm.
Okay, I came in around noon.
Ah.
And they had already been deliberating before you came on. So yeah, it has to have been 5 hours. If not, it's like stupid close.
Well, I didn't even know that like I went live and we were talking about it and literally like just a few minutes after I went live is when they said, "Oh, breaking news. Blake Scanlon deliberations have
Okay,
started." And I was like, "Wait, what?"
that's only
Really?
4 hours then. No, it's 5. It's like right at 5 now. Going on 5. Close to 5. Shut up. I don't know.
Girl math. We don't girl math. We don't math.
Look, okay, speaking of math, because I have questions. Speaking of math, y'all consider me like, I mean, I won't say highly intelligent, but I mean, like, I have some level of intelligence, right?
Mhm.
Okay, why can't I count? Like,
I don't
past 20, I'm done.
I don't know. What do you mean?
Like, I'm counting items, right?
Mhm.
I'm supposed to have 30. I got 29. I got 31. I got 29 again. Now, I know I had 30 when I started.
Did somebody eat one?
No, it ain't food.
Oh. I
I
know
haven't
what
even
you're
gotten
doing.
up. I
I
haven't
know what
even
you're
moved.
doing, by the way. I know what you're doing because I'm doing the same. Sorry.
I should I
Um,
shouldn't have said the number.
yeah, that kind of I was like, I know exactly what you're doing. Um, hold on. I'm looking up. Is it like is there some states where oh, we have a verdict, says Law and Crime Network on their thing. They're saying they have a verdict. Yankees. All right, hold on. Let me get the poll. Let me do this poll. Okay. It's going to be, I'm going to put second degree, but I was in the process of looking up if it's like a lesser charge kind of thing they automatically add or something. I don't know. They have a verdict and the camera is on. All right. I'm starting the poll now. You guys go vote real quick, fast, and in a hurry. There's that poor mama. God love her heart. God love her heart. And you know what's the hardest for me would be having to quietly sit next to the family of the person who did that to my person. You know what I mean? Can you guys hear me? QB's gone. I don't know where QB went. Do you guys hear me? Somebody let me know in the chat if you can hear me.
I'm sorry.
Okay, you scared me.
Uh,
Everybody saying yes, now they can hear me. I was really worried that nobody could hear me and that you weren't talking to me. And I was like, but she's still here. She didn't drop.
I said BRB.
I'm so sorry I didn't hear you say that.
No, in the chat, I said BRB. No, I can't say. If somebody calls me, it blocks you and it takes the call.
Oh, gotcha.
Like, I don't know how to make it not do that other than put it on D&D, and I can't put it on D&D because I got people I need to talk to.
Right, right.
So I apologize. I'm so sorry. I'll get
No
my life
worries.
together.
No
Um,
worries.
uh,
Did you hear me say,
Anyways,
though, that I got a verdict?
they got a verdict?
Yes, we're waiting. They're back right now.
Oh, snap.
Yeah, you
Oh, so we
literally
slid
must
in
have
like, they slid
you
in just under the radar there.
Yeah, that's why I said I gotta hurry up and get this poll up. I slapped that poll up real quick. I was like, I'm
Oh,
gonna
wait, let
have
me go
to
vote. Everybody
hurry
vote.
up. I'm gonna have to hurry up and get the poll up. And I was in and was in the in the process of looking to see about the second degree to see if it was like an automatic lesser charge added.
Right?
Um,
I was wondering if they had a lesser included, but I didn't hear anything about it.
the only thing I saw right was the charges of first degree murder and then assault
Yeah, with intent.
with a deadly weapon.
Yeah.
And then they added this manslaughter thing, voluntary manslaughter. And so maybe they snuck in the second degree since I don't know.
I don't know. It could have been in the jury instructions, and we ain't going back to listen to them now.
No,
Yeah, Margaret. Um, yeah,
I can imagine.
I've had to come face to face with somebody like that, and it was not easy. They weren't drunk though. It was an accident, but
Mm.
we actually went so that she
Record,
wouldn't
Your
be
Honor.
charged.
So we have a verdict, so we'll get the jurors and bring them in and take the verdict.
What do y'all think? What do we think? What are we looking at? Everybody's saying a first degree. Nobody said second degree.
Yeah, 73% so far at first degree and 27% have voted for manslaughter.
Welcome home, Steph.
Oh, well, welcome
Entering,
home.
all right. Deliberating jurors remain standing. Defendant remains standing. Everyone else may be seated.
Remain quiet.
Thank you, Your Honor. Madam Foreperson, has the jury agreed upon its verdict?
What in the world? Oh my God, why does it have to do this? Really?
Would you hand the verdict slips to the court officer, please?
All right, you may record the verdicts.
All right, Madam Foreperson, ladies and gentlemen of the jury, hearken to your verdict as the court will record it. On indictment 19 CR 168, count 1 charging murder,
you upon your oath say that the defendant is guilty of murder in the first degree by reason of extreme atrocity and cruelty. So say you, Madam Foreperson? So say you, ladies and gentlemen of the jury?
Yes.
Has this verdict been unanimous? Count 2, charging assault and battery by means of a dangerous weapon, you upon your oath say that the defendant is guilty. So say you, Madam Foreperson?
Yes.
So say you, ladies and gentlemen of the jury?
Yes.
Has this verdict been unanimous?
Yes. Yes.
Thank you. You may be seated. Sir, you may be seated.
All right, members of the jury, I want to take this one final moment publicly to thank you for your service in this case. Thank you for the careful attention you gave me, the lawyers, and the parties in this case, and for your work to deliver a verdict. I told you during the course of the trial that when the trial was over, you were free to speak to anybody you'd like about this particular case. But I want to let you know that the opposite to that is also true. You are perfectly free not to speak to anybody about this case ever again. I suggest to you, given the privacy of your jury deliberations, that you consider that when you're if you choose to discuss the case with anybody outside this courtroom, that you keep in mind the sanctity and privacy of the jury deliberations and provide that to one another to keep that private. But again, your discharge as jurors, that's entirely up to you now. You're under no sanction or order of the court. So thank you very much. I will come back to talk to you and thank you privately in just a few moments. Thank you all for your service.
Jurors exiting, all right.
Mr. Green.
Thank you, Your Honor. The Commonwealth would move for sentencing, but we would ask the court for some time for the family to hear impact statements and collect themselves. I know that you're not available on Friday. Monday is the day after a holiday. The family has asked me if we could schedule sentencing on Tuesday.
Do you have any issue with Tuesday, counsel?
Yeah, just one moment.
Sure.
I'm gonna have to get sentencing first degree. Woohoo!
Tuesday at 10 o'clock then, okay?
Thank you.
Tuesday morning at 10. Thank you. Stepping off.
All right.
Tuesday, 10 o'clock. Let me put that on my calendar. Tuesday, 10 o'clock. What is that, April 2nd?
Yes.
Ay. Blake Scanlon sentencing. 10 a.m. EST. All right. So he was found guilty of first degree.
When he dropped that key nugget, he was done. He was done.
I do. I need to go back and look. It makes me want to go back and look to see if they brought up the key information. And like I said, maybe they did.
They had to have, because you can't introduce new evidence in a closing statement.
Yeah, that's true.
So it had, and she didn't. I mean, she objected like 3 times. She didn't object to that.
Yeah.
So they would have. It had to have come up. It had to have come up because you can't introduce. I mean, unless Massachusetts got some other law out there, but yeah, that most of the time you can't. You can't introduce new evidence in the closing statement. Not anything they can consider.
Mm-hmm.
I mean, you can make inferences and stuff, but you can't, like, I mean, he threw up the whole picture and everything with the key, and
Mhm. Right.
So, I'll be RB.
All right, babe. Um, Chaloon says, phew, I can breathe again. Justice has been done, right? Lauren says, bye, you evil monster. Eesh. Justice was served. Yes, thank you, jurors. Steph says, I'm going to need to come back and see the details of this case. It was pretty cut and dry. Not going to lie, pretty cut and dry. She says, yay, I get to sleep at night instead of listening to people yell, nurse, nurse, nurse all night and trying to get up and take out their IVs. Oh, no. And have nighttime sundowners. That stinks, but I am glad you're home. I'm glad you're home. Gail says, there's an Amish movie about a man who shot up a school and they embraced his wife and showed her God's love. That's
Okay.
sweet.
Sorry.
That's sweet. And whenever I say that about being able to sit, welcome back, QB. Whenever sitting next to them and not being able to contain yourself, like I can totally see and envision, a situation where his mom and her mom like can have conversations, and where it's when it's a case where, the parent of the guilty person acknowledges and admits to their child's guilt,
Yeah.
and is apologetic and shows remorse to the victim's family, and
Well,
you
and
see
you
that kind of
can,
thing all the time, right?
yeah,
Um,
and you can kind of, I mean, it's different, but you guys, they can empathize with each other because at the end of the day, they both lost their kids. It's different.
yeah, it's way different. Yeah.
It's different. I mean, I'm not saying it's the same,
Hmm.
okay?
Hmm.
But I mean, I'll be honest with you, if my kid did something like that, I wouldn't be able to get over the guilt that that's the kid I raised. You know what I'm saying? Like, and I mean, kids can go south,
Right.
but anyways.
Yeah. Steph says sometimes the parent
Yep.
has more remorse than the person who did it. That's true.
Yeah. Yeah.
That's true. And
Um,
I don't see any remorse on his face. He sat right there. I mean, he sat there and couldn't look at the pictures of what he did, right? I understand that. It would be hard to look at it. But at the same time, you owe that to her and her family.
yep.
You did it. You saw yourself do it. You didn't have your eyes closed while you were doing it. You saw it in real time, buddy. Now take a look back at the photographs of it. It always cracks me up whenever you see those like TV shows of those like detective shows and stuff like that where, they're trying to like garner some sort of emotion out of their suspect, and they like
Look at it.
slam down pictures of the victims on the table and they're
Yeah.
like, you did this to her. I always love to see that kind of stuff. Hey Kel, welcome back. Did you miss the you might want to rewind it back a little bit, Kel. They've already got a verdict and we just showed it. So
Hey,
yeah.
Kel, welcome back.
Welcome back.
And look, I didn't mean to scare nobody when I was asking about premeditation. I just, you know, you gotta meet the burden.
Yo, you're
Gotta
right,
meet,
because it was that was what made me go look it up, because I was like,
gotta get,
well, there is, they're not talking about premeditation, but
And I think there's some question as to, does grabbing a knife count as premeditation? If you're in a fit of rage and you grab a knife and you're seeing red and you're like having an out of body, is that really premeditation? I think it could be argued,
right, I think that could be argued.
and so, and we don't know. Trust me, I'm glad they got him for first degree murder. Y'all don't come for me. I'm just
Mhm,
talking. But,
mhm.
you know, she changed her clothes and stuff, but you don't know. I mean, they would have been better to go down the road of, and it's not, I'm not saying that it makes it okay. I'm just saying if they were going with the involuntary manslaughter, they would have been better to go down the road of her taunting him rather than her them victim blaming. Does that make sense?
Mhm.
Because she was definitely not. I mean, but in her mind, they were done. So I don't know. I'm gonna stop talking because you got quiet, and I always
No,
worry
I
when you
was
get
just
quiet.
looking I was just reading the chat. I was just reading the chat.
Um, she
Um,
said, "Whoa, good thing I voted first."
I know, right? No, I know what you mean, and I'm, like, envisioning the whole situation in my head,
Right.
like, how many
Because
different ways it could have gone. We weren't there, we don't know,
right.
right? It wasn't
Because
recorded, like, it was a
the
movie.
defense actually, I didn't like the one lady at all. Okay, at all. The red-haired girl, she's new. She's
Mhm,
getting her feet wet. I ain't got no issues with her. I didn't like the other lady at all. But in her closing, she didn't do a terrible job in that
mhm,
showing maybe it could have been a snap thing
mhm.
because they were on again, off again. Okay. It's, maybe he still thought that there was hope. Maybe, you know, and what
Oh, she's gone. Hold on.
is,
There you are.
oh, for the love. The thing that she said that got me was, that just because someone tells you it's over doesn't mean that everything in your life you just immediately poof stop having feelings.
Right, right.
Now me, I'm the type of person, if I'm still living with my baby daddy, I don't think I'm hooking up with somebody in their car. That's just me. Not victim blaming. Please y'all don't come for me.
No, I know what you're saying. I mean, but you're also, this is an early 20s-year-old girl.
Yeah.
I mean, the girl's in her early 20s, right?
What are you
Things are
trying to
not
say? What are you trying to say?
I'm trying to
What are you trying to
say
say? Just because my children are their age, ma'am.
you're a little longer in the tooth than she is, but so am I.
Wow.
Okay? So am I.
Wow.
So am I. I am just saying things are different
You don't
now
know
than
me.
they
Maybe I
were.
would be out there in the parking lot. I don't know. I mean, I
Mm,
wouldn't, but
I mean,
I'm
if
just
you
saying,
are, good for you.
right?
But I'm just saying, she's a young girl with a baby at home, and
Where
maybe
else are they
she.
gonna get? I mean, unless you go get a hotel, and that's, I
I
guess.
mean, sometimes a girl's got to do what a girl's got to do. I don't know.
The other thing that I thought that they could have, and again, I'm not trying to get them off. I'm just looking at this. We're just looking at it from the outside, okay? The other
Right.
thing I thought that they didn't do a good job spinning was, again, if you're going for involuntary manslaughter, that she kept checking her phone to see where he was. Okay?
Mhm. Mhm.
Two things. If you ain't in a relationship, why y'all got each other on the Life 360? But also, and more importantly, was she checking because she didn't want him to catch them?
Right. I mean, that's like my thing.
You know
Maybe
what I'm
they had
saying?
it. Maybe they were sort of toxic
Yeah,
relationship where one didn't
yeah.
trust the other, you know. Um, and then they broke up and they did, you know how it is sometimes things happen. You're like, I just hadn't even thought about taking it off there yet. Right.
Yeah, right.
And then she starts keeping an eye on the Live 360 thing to keep tracks, and maybe she was afraid of him. I don't know.
I mean, but I mean, maybe she was afraid, but do you understand what I'm saying on the flip side? Maybe there wasn't a total break. I'm saying this is what the defense could have done
Mhm.
to try to prove involuntary manslaughter is push that, well, yeah, she was checking the phone because she didn't want to get caught cheating.
Yeah.
You know what I'm saying? I mean, that's how you derail what they're trying to say. What you mean, wow, you too? What you mean, spins? Look, my brain, I know everybody's quiet. They're like, QB, shut up. I ain't
No.
saying he's not guilty. I think he's guilty. I'm glad he got first degree murder.
Yeah.
I was
Me
worried there
too.
for a while because a lot of states you premeditation is an element. The only thing that differentiates first degree and second degree murder is premeditation.
Yeah.
And so I was glad when you read that because um I was worried because I was like they didn't get premeditation.
Mhm.
And it's all well and good to say he had time to think to grab a knife and that's premeditated. Mm, Now if
Well,
you
but like
pack a
you
kni- now
said,
if you pack a knife and you bring it with you, or you set the knife on the counter so it's close by, so when she comes in you can grab it. Those things, yes, I say premeditated. You just snatch a knife because it's a weapon of convenience. Mm, I'd have to argue.
Kel
See,
says
yeah,
it was
Kel, yeah,
knowing that
yeah,
premeditation wasn't a requirement. I think that the lawyer was trying that the prosecution was trying to kind of say, even though we don't have to have premeditation, here's a little
right.
bit of premeditation,
Well,
whereas
where
the
he won me on that though, where he won me on premeditation was the key.
yeah,
If the
yeah, yeah,
key was back at the apartment and they never found it because they didn't drive the car home, they took an Uber. So they never found it. The only person that had it was him. So
yeah.
he stole it, which meant he knew she was going to have to go with him.
Mhm.
Or she wasn't leaving without talking to him at least.
Right.
I love you too, Steph. I'm a whole hot mess. I understand. Still can't
But
count.
he's thinking, "Here, let me hide this key. She ain't got no key to get home, so she's either gonna have to go home with me, or at least let me narrow down the options of how she's getting home."
Right.
And
Or she'll have to talk to me before I give her the key back. We gonna talk about it. We gonna
mm,
talk about it because I got your key. Also, I need to clean my desk because I keep losing things and it's really not a big desk.
yeah, I
Sorry.
know, Kel. Kel says it
Squirrel.
was interesting how many things weren't allowed in. Seems like there were a lot of restrictions on the lawyers and what they could ask.
You know what I think is interesting? I don't know that I've ever watched a case front I was gonna say front to back.
Mom,
Start to finish. Hi.
Dad's home.
Um,
Oh, she says Dad's home. I'll be right
Dad's
back.
home. Okay. I don't know that I've ever watched a case from start to finish where maybe I have. Let me think about that for a minute. Maybe they were trying to get
Can I preface real quick? I'm going to run for just a quick second and talk to husband now that he's home. But if QB happens to fall down in the next little bit, you guys just talk amongst yourselves in
amongst
the chat
yourself.
till I
Yes,
get back.
we'll talk in the chat. Hi, Dale.
Always front to back, QB. Always
Always,
front to back.
always, always. Wow. Facts. What was I saying? Oh, I'll say this. I can't remember the last time that I watched a trial that we already knew who did it. There was no question, and they weren't arguing that they did it. I guess maybe there was one that they were trying to get like by reason of insanity or something like that. But yeah, this was a different one. Yes, yeah, she's got to do the Vanna White arms. I just want to know if she's wearing her cape. That's what I need to know. The Georgia mom, the Georgia mom, the Georgia mom, Georgia mom. You talking about the chick with the two kids that said they hung themselves? Was that she in Georgia? Because she's still feigning she don't know. She don't know what happened. Um, but without looking at it. But
Okay, I'm
without
back.
so many I'm confused by the
Exactly,
chat.
Steph. Steph says it's time for Jolie's Vanna White moment, and
Yes,
she's not giving it up for
I
nobody.
need. I said I had questions. I need answers. Is she wearing her cape though,
Wearing her cape. What cape?
ma'am? There had better be a cape somewhere in that house, ma'am.
Um, I didn't get a cape.
Then we're missing a package.
From you, it was a book.
Yep, there's two. Says it's in here. It was left inside your mailbox.
Oh, two
Was it?
packages.
Yes.
Okay. I'll have to look. I'll have to look. Was they sent on the same day?
They came in on the same day. Yes. Both from Amazon. Dang, now you know what it is. Dag nabbit.
Oh, okay. Yeah, I was gonna say I didn't see no note. The only thing that was in a box was from you was
Did you get the funny, the
the
name of the
funny.
book? Yeah, the name of the book. What should Darla do?
Yeah, I did. I
What would
actually
Shannon do?
I thought that it was funny because I saw the "What Would Darla Do?" and then I was like, "Yeah, I thought that that was cute." And she
There's
likes
supposed to
the
be
book.
there was supposed to be a
Oh no, I came back just in time.
give up. Oh,
Hey,
come on.
there you are. You're back.
Rude.
Yeah.
Um,
Hold on a second. I was.
oh yeah, you gotta find the other package, yo.
Yeah, I'm gonna have to go find the other package. But she's all about
Knowing
the Georgia.
Amazon, knowing Amazon, oh, she's gonna be all about it then. Knowing Amazon, they probably put it in a big old 10 by 10 box.
Yeah, I know, right?
Talking about, oh, we're reducing packaging. Y'all just sent me three things in a big old
Yeah,
box, huge
they're
box.
bad. They'll take something as teeny tiny as my a fingernail and put it in a box as big as a house.
But then they'll put something that's can get crushed and put it in one of them. We're reducing, boxes. Thing. I'm like, y'all got this backwards. What are
Mhm.
you doing with your life?
Mhm.
Look, look. Check if your food is spicy before buying it.
What's
What?
Steph talking
Spicy
about?
lasagna? What you mean,
Uh,
Steph?
she says something
YouTube is.
about the Georgia mom that gave
Yeah,
her kids
that's when you
uh,
came back in and I said, I'm so confused. I don't know. What I was saying was, I can't remember the last time that I watched a trial from start to finish that had a defendant that they weren't trying to prove that he did it.
mm,
And I was like, well, maybe I remember one that they were trying to prove like um that they were trying to prove you know, by reason of insanity or something like that. But I don't, I can't. And she said the Georgia mom, and I was like, what Georgia mom? And then you came back and interrupted, and then I didn't get an answer.
Oh, her name wasn't it Teresa?
That wasn't recent though, was it?
No, it was a couple months, 2, 3 months back, wasn't it?
Oh, I don't know. I don't know which Georgia mom.
Yeah, she's the Teresa Black was her name.
Yeah,
The
90s or
one
early 2000s. What do you mean a couple months ago, ma'am?
that the video that the trial was.
Oh,
Remember?
no.
Were you not around then?
Girl, it's only been a minute. Only been a
Hold on, let
minute.
me go over here and look. It was Teresa Black. Was the
Oh, I
name.
remember. Yeah. I remember now. I remember now. Yeah, I was around. I
Yeah,
wasn't
okay.
around. I was adjacent.
Yeah, adjacent. Yeah.
Yes, I was Crime Cafe adjacent.
Yeah. And his name was William Deshaun Hamilton.
Yes,
Yeah.
yes. I remember now. I remember now. I didn't watch that one. Don't come at me.
Oh, it was so sad.
I was otherwise indisposed. I don't remember what was going on then, but I wasn't able to be on. I wasn't panel tier yet. You are correct. I was only Crime Cafe adjacent. Like, I don't know if I'm panel tier now. I don't know how this all happened. Jenny called me a dork. I
I
called
did.
her a dork.
She did.
We fell in friend love, and
We did.
yeah. And then one day she's like, "Come on up here," and I was like, "Nah, I'm good." And you're like, "Here, right now," and twisted my arm. And then I was like, "Okay." And then I left, and I was like, "That was cool."
Mm-hmm.
And
It
then
was
I never thought it would
fun.
happen again.
It was really fun. So the
My
first
initial
trial that
injury,
I
no,
ever
girl, when did she?
the
No, my, sorry, go ahead.
no, I was just gonna say the first trial I ever covered was the Hannah Payne one, I
Hannah
think.
Payne, and I saw you, but that was on the other channel.
Yeah. And then we
Not to
moved
mention,
over
we never
here.
decided on that, by the way.
Yeah, no.
Sorry,
And then we moved
squirrel.
over here and
That
let
was
me see.
the guy, the run down the parade people guy, wasn't it?
No,
That
it was
weird
Bryce
guy.
Rhodes.
Oh, Bryce Rowe. Yeah, the weird guy. Sorry, different people, both weird guys, but different people.
Yeah, the guy that
Um,
ran down the people in the parade. I didn't have a channel. I never streamed that. And that trial was already long over with before I
yeah,
ever
yeah, yeah,
recorded.
yeah. Yeah, Bryce Rhodes, and then is that how you make friends, QB, by calling them door? Well, that's how we became friends.
Mhm.
Actually, we became friends because Zabi picked my name and I won a raffle and I finally got to get some of the good stuff. And then I placed an order and I was a dork because I am. And then she called me a dork. Actually, no, she's making friends that way, Spins. Get it straight because she called me a dork first. No,
I
wait.
did.
Did you? You did. I
No,
think you
no,
did.
you called yourself a
Self a
dork.
dork. Yes. Fair. Okay, see?
Yes.
Still don't fit Spins' thing.
She gonna fix your little red wagon spins.
Yeah, yeah. Yeah, it's
She
Hannah
will.
Payne. I was in for Hannah Payne. I just wasn't in. I think I might have said a peep or so. I was still uh checking y'all out. Man, did I fall out again?
No,
Why are you laughing?
because you're just so cute.
I'm
You're just
not
so
really.
cute. You really are.
Um, I have more questions. When y'all join a group, a Facebook group, and there's questions, do y'all answer the questions?
Depends on what kind of group.
Or do you just scoot on by them thinking they ain't going to notice that you didn't answer the daggone questions? Because let me tell you, if QB's a moderator for said group, QB notices and it
Mhm.
irritates her.
Mm.
And she sends you a nice little, hey, welcome, glad to have you here. If you could just go ahead and answer those questions and agree to the rules, we'd be happy to have you.
Oh, I was confused. You didn't,
When you're joining a group, when you're
when
joining a
you're
Facebook
joining,
group,
yes, I
yes.
thought you meant if you're a moderator in a Facebook group and some
No,
random
no, no,
person
no,
has a
no.
question like, "Do you guys, can I buy a burger today and pay you for it on
For on
Tuesday?"
Tuesday.
Right.
No, I mean when you join a Facebook group and they are like, here's some questions and then here agree to the rules. Do you answer said questions or do you just slide on past them like they don't exist and the moderators are going to think because I'll tell you, QB ain't going she don't allow that. There's questions for a reason.
Who's
That was
customer
my customer
service
service.
boy?
I'm trying to get Zabi to let me do her customer service.
Oh God, Margaret says, "Oh God, I'm eating celery and I can't hear a thing. I have you on full blast." So here's the thing.
I love
My oh
celery.
God is why are you eating celery?
Celery's good with like you got to put stuff on it though.
Ranch.
Ranch, peanut butter, cream cheese. That's the thing. You got to answer. Well, okay, no, that's the thing though, Kel. Some of them are set. You have to answer them to be accepted in the group. Because see, as a moderator, I'll get the. Well, you got a group. Don't you have a group? Do you have a group?
No. I don't do
Okay.
Facebook unless I absolutely have to.
No, I know. But um, all I'm telling y'all is, don't do that. Otherwise, if you run up against QB, you go and get a nice little customer service message that says, and then don't try to come back again. Don't try to come because I know I have photographic memory. I've seen your name. I know you already tried that. I've seen you. Don't try to come back again and not answer them daggone questions.
Just don't she just can't do like Mary Lou Henner does and tell you what she did 3 days ago
No, I
or
can't. No, no, I can't. I can't.
yeah.
With me with all I got going right now. Wait a minute. What did Lee say? Flew right by. Wait a minute. Wait a minute. Wait a minute. Um, I don't see anything. That's because, oh, wait. And to this day, I still want to know why you called yourself a whole penis stork. What?
A
Sir.
whale penis. It says whale,
Well,
not
yeah.
hole.
Well, I need new glasses and whale, whatever. Either way,
I honest to God, I didn't see that comment, Lee, until
I
just
didn't
now.
either.
I
But
literally didn't see it.
can't be scared. I'm sorry. Don't be scared. Look, I'll tell you, QB's customer service will have you apologizing for something I did, and then you'll thank me for it. I mean, I, but I don't play.
I'm
Look,
laughing
look,
at Margaret.
what did Margaret say? Wait a minute. Oh, you said, why are you eating celery? Go ahead, Margaret. Can I be a mod so I can decline people? Because see, they got this thing called decline with feedback. You get some feedback from QB.
So a whale penis is called a dork.
Yes.
Okay. So next time I'm just gonna say, quit being a whale penis, QB.
Yeah, Jenny, don't be a whale penis. My night.
Mm. And
How
even
do you
if and
know?
you know what? Don't be a whole whale penis.
Right, a whole whale penis. Look, a whole penis, a whale penis, they're about the same thing. Are they not? I need you to go
Mm.
find that package, ma'am. It was
Okay,
a
let
whole
me go
thing.
look. Hold on,
No,
hold on,
not
hold
right
on.
now, ma'am.
Well,
Not
good.
right now.
You tell me to do things. I take
I
things
know. I see
literally
you
sometimes.
jumping. I see it. Jenny is spicy. Look, Steph, I don't know what she did on her break, but she came in hot. She came back from that break hot. She was singing. She was dancing. She was cahooting by herself. She didn't even have me up there to like feed into it.
Hmm. I had a chicken roll up with mustard.
Ooh. Ew. You ruined it.
I'm
With
sorry.
mustard?
I need to lose weight.
Y'all. Y'all. The buffalo chicken pizza egg rolls.
See, this is what I do not need. I do not need. You are the weakest link. Goodbye.
Cahootin.
She's
I
like,
made
am I
that
still
up.
here? Am I
No,
still
I got
here?
quiet. I didn't want to talk in case you cut me off. Don't smack the whole the whale penis. Did y'all see that thing I sent y'all yesterday about I'd be smacking that pickle? Hey, rude, rude.
I was wondering when you was gonna notice I was gone.
Oh, I thought I was going. I was being loud. Y'all heard that?
No, no,
Sorry, you were gone.
I was gone. I threw myself out.
You threw yourself. Don't do that. Jenny has left the chat.
I
Okay,
left the chat.
chat. I still can't count. I don't understand. And then it all ends up working out. Like I count it and count it and count it and get mad, and then I do them, and then they all work out.
I think you need to go back to school.
It's a thing with me. I think it's the ADHD. I think anything past 20 just totally like my brain just turns off and goes nope.
Well, here, you know what you need to do? You need to put them in piles of
Of
10.
20. Yeah, no, piles of okay, so I usually do like piles of 10 or 20. But it's only 30. Like you think I could get 10 more. Like I mean, that's why I started the whole thing with y'all think I have even a modicum of intelligence because why can't I count to 30?
No, what I'm saying is take all of the ones you got done, whatever it is that you're doing, which I know what you're doing, because I'm doing it too. But you take, and what we're talking about is things for zombies.
Nah, can't do that. I didn't know what you were going to say, so I just preemptively struck.
No, I just, it's
It's
not a
things that have to
secret.
be counted. It is a secret.
Okay.
They are a secret.
But they don't know when and where and what time and who and all that.
Don't matter. Can't do
Okay.
it. No,
Okay.
ma'am. No, ma'am. No turkey. No, ma'am. Oh, JB ain't in here. JP got me to get that banana nut bread bake be sending. Girl, ma'am, ma'am.
Okay. So, what I was going to say is you need to make a pile of 10, make another pile of 10, and then one more pile of 10.
Well, I'll do that when we stop talking because I can't. She did shift me. She shifted me long too. Yeah, she sprung a leak, Morgana. Secrets are not lies.
Oh, Lord, Mickey coming hot saying she's going to intervene me. If I say penis one more time,
Oh,
penis,
there it
penis.
is. We have. I mean, there was a time when we would have said penis, and I would have heard you blush.
No, I don't care to say that word. Now Steph made it weird.
Yeah, she did. Nope.
I don't care to say that word, but I mean, that's what it is. It is what it is,
It is what
right?
it is, right?
Ay, 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 ay,
But you'll
ay.
never be able to call me a dork the same. Now that Lee told you.
Right, Margaret. Margaret says, I'm not old enough to be in this room.
Facts. Facts. That's why she
So that's
TMI
why
Steph.
Spins, we call Steph TMI Steph.
Yeah, and note that the time has passed where she could have changed her name back, and yet here we are.
Mm-hmm.
Court TV, you late. You fired. They fired.
They're always late.
They're fired. They just came out and said, oh, they found him guilty. That was like 4 hours ago, Court TV.
All right, let's go over here and close the poll. Let's end this
Jenny,
poll.
Morgana said she's too old to be in this room.
I'm
Now I
too
want to
old.
count these things again. I have
Steph does
questions.
not stay in this. She's like, I want to keep it TMI, Steph.
Oh,
Okay,
it
so
absolutely should be.
the poll is, what did you think Blake Scanlon will be found guilty of? And we had 15 votes.
Jenny's on the poll.
And
Morgana just dropped back down to the age level that she can be in this room.
what?
She said she was too old to be in this room, and then she came back with Jenny's on the poll now. And so I said she just dropped back below the age limit for this room.
Mm-hmm.
Y'all,
Mm-hmm.
I'm so excited about my Happy Meal that's coming. I hope this works.
Well, hold on. I'm gonna wait. The
What?
poll, before I forget.
Okay, the poll. You're on the poll.
First degree. 60% said first degree. So you guys, 60% were right. 26% said manslaughter, and 13% said second degree.
Said second degree. That wasn't even up. Long crime was wrong.
Well, I mean, I don't know. Maybe they. God.
What, ma'am?
Sorry. My phone is like super loud and annoying. I don't know that second degree wasn't one of the things like we talked about, right?
I guess. I think long crime got it wrong.
Steph, that's true, but we were
But
talking about
you,
pop. We were talking about pop.
yeah, it was pop. I don't accept. That is so funny. Spence, can I tell them what you just said to me? I'm gonna dox you. Never mind. I'm not gonna say nothing. I hope my kid has my box. Yay! Thank you. Appreciate you. Oh, and a recipient.
Huh?
I said and a recipient.
What?
A receipt.
For what?
Um, for me to scan into my fetch.
Oh, I forget to do that all the time. And then when I run out of space on my phone, I have to go through and delete all the apps that I'm not really using.
Y'all. I hope this works. I hope this works. So I ordered some little uh wheelie doodles
I
to
don't know
put on
what
my
that is.
little wheels to put on the bottom of my they might be too big. Little casters to put on the
Oh,
bottom of
yeah.
my folding table
Mm-hmm.
that sits in front of my recliner that I push back and forth when I get up and down out of my recliner that I work off of.
Mm-hmm.
And I had like this, wait a minute. I had like this bright idea that why don't you put casters on the bottom so that it'll just roll instead of having to slide it, right?
Mm-hmm.
They came in. I hope they work. They might be too big. Spins, that's gonna dox you though, ma'am. I mean, I won't say the whole thing.
Yeah, don't dox her,
I'm not
please.
gonna dox her. She said I could do it.
But no.
Oh, you're not. Okay, well, Steph just threw me under the bus. I don't screenshot all of our conversations, Spins, just when you say something nice about the chat or about the group. I'm just gonna quit. I quit. I'm leaving. I'm leaving. I'm done. Spins. Spence, your secrets are safe with me, Spence.
Spins, just so you know, the only time she's ever shown us
Ever. Ever.
ever. Yeah, the only time she's ever shown Steph is over there right now going, "Oh my god."
Well, that's like, okay, let's talk about Steph and outing people. Okay. Before
Well,
I even really,
wait. Let's preface this with the only time Steph has or QB has ever shared anything with the like little panel girl chat is whenever and that's only been like twice, and it's been when you've said something like um
I really like it here or something like that.
yeah, it was something really cute, right?
Yeah. I take
Okay,
that very seriously. I take it because I'm like the vault. Like I don't repeat stuff, and so I'm like freaking out right now. Um, anyways. I know, but I freak out, Steph, because that's something that's very I take very seriously is confidence. Anyway, no, talk about people outing people, not outing people, but did I drop off?
that's exactly where no, you're there. Um
Yes, that's where I was going with this. That is where I was going with this. I didn't even know Jenny for a second, not for a second, and Jenny didn't know me to be fair, and
uh-uh.
I'm scarier than Jenny is. And Steph's like, here, let me start a whole group chat with both y'all's phone numbers in it, and I don't ask nobody.
So
Which,
funny.
and to this day, we don't conversate over there. We're in the Discord. We only use that when you ain't paying attention. We're like, Jenny! Or when I
Yeah,
fall
I know.
asleep. Or when I fall asleep, we all are chatting on the phone and I fall asleep and y'all text me. I'm so glad y'all they could have got me good. They could have recorded me and apparently I was snoring the other day. Bye, have a good shift. Love you. Be careful.
She was totally snoring.
I did need to see
It was
that sounded
out.
bad. I did need to see I was out. But I warned y'all. I warned y'all on numerous occasions. I'm like, I'm gonna have to tap out. I'm gonna have to tap and y'all just kept involving me and then I fell asleep.
It's so funny though, because we literally said her government name. She's like, "What?
He said
I'm
my
here to
whole
make
government.
money."
I was like, wait, what? Somebody call me? Yeah.
That was funny.
No, I don't lie about it. I know I snore. I don't snore a lot, but I do snore. Look, I don't need to lie about it. Ain't nobody sleeping with me with my dog, and he snores too.
My dog snores and
Anyway, Spins, I
farts.
love you. You can tell me things, I promise. You'll never say another nice thing about y'all again. Like QB
Oh,
gonna run over there and y'all got me with the government. Y'all got me. I sure did. I sat straight up. I was like, somebody say my name. Wait,
uh,
what? All right, y'all. So they send me these big old caster things, right? And they're heavy. There's four casters in here.
they're still talking about you snoring.
No, I didn't lie about it. I said I'm awake. I'm awake because I was awake. Y'all woke me up because you said my government. Y'all got me. Said my government.
Okay, tell us about the casters.
Oh, these casters, this whole bag, there's four casters, four little casters in here, but this bag weighs like a good pound and a half, 2 pounds, right? How about they sent me these little tiny panel nails to put in the side of it to, I guess, hold it on to the. No, homie, we gonna put some. If it works, we gonna put some super glue in there.
Mm.
This is what we do. I will just say when I'm conversing with someone who has my same name. Okay. So I'm all set. Okay. So Spins' name, not full name, not full government, is Steph. And so when she yells at Steph, she feels like she's yelling at herself.
Oh, gotcha.
Yeah.
Gotcha,
Anyway.
gotcha.
Ooh, what they doing? Dude, right? Like she can be mad at me for keeping her for 45 minutes extra because y'all kept me for 4 hours extra because at midnight I was like, I'm out, y'all. Actually, at 8 o'clock, I was like, yeah, see, Steph. Anyways, Finn said I could say it.
Mm.
I hope this works.
Y'all keep me up too late, but I don't want to leave. I've learned not to take meds until after the call is done.
Well, I have to tell you, see, that's we have this whole thing. Uh-oh, what's she doing now? I mean, she said a snoring thing. I bet it's a snoring thing. What's she saying?
Mm.
I did not say I didn't snore. I never said I didn't snore. When y'all said you were snoring, I was like, oh, was I? Yeah, because I know. Look, send me Mr. Bean. Don't look like Mr. Bean. I did shake awake like that though.
I love Mr. Bean so
I do
much.
too. I do too. I like the thing when he's the meme where he's waiting. He's like looking at his clock and he's sitting in the field with the flowers and then you know what I'm talking about?
Mm-hmm. I
Yeah.
love every single one of his. I love everything he does. Looks for a chainsaw sound, says Lee.
Oh, the squirrels are bad today.
What did you say?
I said the squirrels are bad today. Um, it made me think of it because
That is not what I thought you said.
what, Mickey Jor, come get your sister.
Thought
She
for
did
sure.
something on her break.
No, I thought you had diarrhea because I thought she said the squirts are bad.
You're nasty. I would never. Oh crap. Steph heard it too. I said squirrels. Yo,
Oh my
look,
God.
Nightbot. Nightbot. Look at Nightbot.
Oh,
Nightbot came in hot. You're right. Trigger warning. Squirrels.
oh
Squirrels.
God. Lauren said same. She thought it too.
Okay. I'm southern-ish, southern adjacent, and I don't always enunciate my my words. Now what she that is
Oh Lord.
true.
Margaret says, "What are y'all turling us today? This became a poop fest." Turling you that Miss
Telling you.
QB has not. She's got squirrels, not squirts.
Yep. I got squirrels, not squirts. Anyways, no, I because
Guys.
I started to tell y'all earlier that JB got me to get that not proud Mary, whatever Mary thing.
Mary
Um from
Comforter.
Burn, right? Okay. Anyways,
Rolling,
then rolling on a river.
rolling now.
Um so Kel, put those away. Um right? Like on the internet and everything. Lost Mary, thank you. Lost Mary. Uh the banana cake, y'all. Y'all, that vape ain't no joke.
She's got squirrels.
Girl,
They're
they multiply
multiplying
every day, every
and
day.
they're
Losing
losing
control.
control.
So I just want y'all to know that I'm QB everywhere, not just with y'all. So I'm at PT yesterday, and they were talking about a client that had a rescue squirrel, and I was like, "Squirrels? I have squirrels." And they were like, "You have squirrels?" I was like, "Yeah, lots of them," and they're at a rave. And they're like, "I'm sorry, what?" I was like, "Never mind. It's scary in here. Just spins. I love you. They
You're so
multiplying every day.
they're multiplying like rabbits though, right? Not squirrels.
Yep, not squirrels or squirts.
Mm.
It's
Oh,
electrifying."
it's electrifying.
Um. Anyway, I'm sure that QB be QBing facts every day. I'm Popeye. I am who I am. Always. See, now I want to try to put these casters on here, but I'm afraid I'm gonna dump everything off my table and then I'll curse and then y'all will hear me.
Do you eat your spinach though?
I do. I like
Mhm.
spinach.
I do too.
Spinach is good for you.
Hmm.
So yes, I put anything I can put spinach on, I put it on because I have trouble with anemia, and raw spinach is the best way to fix that.
Oh, what are you thinking about changing it to,
Wait a
Steph? And
minute.
what's wrong with Calla?
Um, Probably because she's always yelling at her. I'm thinking, does she has she learned it yet? Greens are good. Greens are good with some pepper vinegar, but I won't eat raw greens. And see, greens, raw spinach is the best way to get your iron.
Yeah, I don't mind raw spinach.
Well, I put it on sandwiches and stuff, and I'll put it in salads because lettuce is like, don't get me wrong, I like a good lettuce salad. All right, I like the crunch. Um, and Mercury, that might fit her. But I like the crunch of the lettuce, but lettuce has no nutritional value at all.
Mm-mm, mm-mm,
So, like on sandwiches and stuff, especially my pub subs,
mhm.
because they have spinach, I'll throw my um. You can name her Sour Patch. She is a Sour Patch. She's sweet and she's sour. Anyway,
She's a cutie, I know that.
she is cute.
Yeah, I
I
don't
have one
mind
that looks just like her.
any kind of lettuce, but they do say that if you're going to eat lettuce, like don't just go for the iceberg,
Darker,
go for
yeah,
the like darker leaf lettuces
yeah.
because there's more nutrients
I
in
like
that.
the mix. I like the mix. I like the crunch of the iceberg. Romaine is my favorite, and then I try to
Yeah,
throw some of them other leafy greens in there. I
yeah.
like the DQ.
I like the romaine and the the like spinach mix with like some of the
Yeah,
romaine with a little bit of spinach in it.
yeah. Poor
But
TV be doing the most.
and as far as greens, do y'all like prefer like mustard, collard?
I like collard, mustard. mm, I can't say that I know well enough when I've had mustard to differentiate.
I don't know if there's a big difference
I
between
don't
the
think
2.
there's a huge difference between the two. Yeah.
I think mustard is more like finer, but Spin says, haha, QB just randomly throwing in court TV be doing the most. Well, they be doing the most, the latest. Like
Right. Like I mean, they come in hot doing it twice. Like they telling you something when Jenny breaking news it like as it was happening. Then court TV comes in an hour later, be like, "Oh, they found Blake guilty. They
right.
deliberated for more than 4 hours."
Mhm.
Thanks, Core TV. That was like 4 hours ago, but thanks. Hmm. Anyways,
Ditto, Gail and Morgana. Oh, about the mixed screens.
I like the mixed greens. You get the pail of them at the in the grocery store already cut and stuff because you know I ain't cutting nothing. That's real close to cooking.
Hold on, I'm gonna look up.
I got oh.
Here it says collard greens and mustard greens are quite different from one another. Mustard greens are much lighter green than collards. They're thinner and more tender and shrink to a much smaller amount during cooking than collard greens do. That's what I thought when I said that I thought they were finer. Like collard greens are bigger and than mustard greens are. Mustard greens, like, I don't know. I like mustard greens though. They're
I
yummy.
like greens, but I gotta have pepper sauce.
Yeah.
Um, I got a dongle.
Morgan says, you don't want advice from me, Steph. Our cat's name is Stink.
Eh. Yeah, so we have cats named like Mr. Sophie and the cat formerly known as Prince because we're terrible at sexing kittens when they're little. So you
Mm-hmm.
know their no-nos don't drop till late.
Mm-hmm.
And so we're like, oh look, it's a Sophie. No, it's not, it's a Mr. Sophie. It's a boy.
Right.
So then that's how I got Maxie Cat because we named her Max because then we figured either way, and she turned out to be a girl too. So
Well, and I've heard, Steph, I've heard you say, I think I pronounce it the way I think Steph and I pronounce that name differently. I think she says Kala and I say Kala, like Kala Lily.
yeah, I say Calla Lily.
But I think Steph says Kala, like, and either way is right. I mean, to me, it just depends on where you're from. But as far as what you say it, Steph, is when you like if you're not you apparently don't love the name or you would be sticking with it. The fact that you're trying
Questioning,
to
yeah.
question the fact that you're questioning it tells me that you're not sold on the name. Um,
See, that's my Nene is named after Shanae.
mhm.
And Morgana's is named Felicia, like by Felicia.
Do you know that my one of my sisters, not Mickey, but one of my other sister, she nicknamed me Shanae forever. Well, back when Shanae was a big deal, because my name is Jenny,
Right.
and she'd be like, Janae, Shanae. She always called me Shanae.
Janae. See, I do Janae from Forrest Gump.
Mm-hmm.
Sorry, not like you've never heard that before.
Mm-hmm. Love that. I think it's Mercury. It suits her personality. Well, there you go.
All right, well then it's Mercury.
Oh,
Most
look,
animals have like,
Spin says she would have pronounced Kala like Kaya. Kaya.
oh, because it's the double L.
Yeah, I didn't think of that.
Oh,
See, that's cool though. I think it's cool. And if you like Mercury, then do Mercury. I
Mercury,
mean,
yeah.
what I do is like I go through like try it out, try it on for size and see what you think. You know, I mean, you can call her anything in
Maybe
the
she
world.
doesn't. Maybe she doesn't answer to Calla because she didn't like it. Maybe she'll
Yeah.
answer to Mercury.
She's moody and I don't even know what mercurial means, but
Take a hit off this bait. Let me tell you what else. The scent on this thing, on this banana cake thing, lingers for days.
oh yeah.
Yeah, it's like it tastes like banana nut bread. And I don't. Okay, Lee, close your ears. I don't like nuts in my vapes,
Oh my lord.
but I don't like the nutty flavor in my vapes. But on that one, mm, they hit that. I mean, it is flat straight on. But I did it. I hit it, and then I went back in my room, and I was like, "Who's making banana cake or banana nut bread?" Anyways,
Yum.
yum. So, tomorrow,
Yeah, need to
tomorrow,
be figured out tomorrow.
um, I didn't say my dates. I said my vapes.
Mhm.
Um,
Spins don't like crunchy in her baked goods.
yeah, but
Sometimes
these
I
taste
do.
like
It just depends.
these taste like it tastes walnutty. It's very mild. Y'all totally missed it earlier when I said I got a dongle.
Oh, I didn't hear that.
I got my dongle.
You got your daggone dongle?
I got my dongle. This one's cool too. It's got the lightning cord that goes into the bottom of my phone and it splits off and it takes my headphones and it'll let me charge it at the same time.
So does your daggone dangle
My
wait,
dongle.
does your daggone dongle dangle?
It does dangle. Mickey Jar?
Listen at that. Her doggone dongle dangles.
Yep, it dangles. And it splits.
Splits. That sounds painful.
What the what?
Oh, Lord.
Y'all don't use like, oh well, Steph uses a mod. Um, I am forever turning this thing either way up or way down.
Mhm.
And I tend not to check it like and I do it when I change the batteries and I tend not to check it. And I burned the snot out of my throat and my coil and everything. It was like on 250 or something. It's supposed to be at like 55.
Mm,
And I hit it. Yeah, it was bad.
not good. Not good at all. Oh, she left again. There she is.
Rude, rude. Oh,
Um, weekly
uh,
estimated net usage. What is that?
that's on your phone, ain't it?
Summary system. What is she talking about?
What, you, what do you mean? Steph,
Are you okay, ma'am?
do you need a nap? Um,
Oh, Chandler on Friends. Gotcha.
Oh, okay, okay. I got it.
Weenus.
Yeah, I got
I
it.
got
I
you.
got it. I got it.
The hot girl at work that he asked her about the weenus, and then he had to fire her and faked she was crazy. I forgot about that.
Mm,
Oh Lord. I
Chandler
need to go
Bing.
back. I need to go back and watch that over.
From the
You know, it's
beginning.
like I've watched all those episodes so many years ago, and then I've like seen like watched them all, every one of
Right,
them, right? But then that I watched the vast majority of them years ago and then watched the rest of them as reruns because I missed a season here or there. You know what I mean?
right,
And so now it's like when you binge a lot, for me, it's like water into an already soaking wet sponge. You know what I'm saying? It's like my brain don't absorb a lot of it. So I
right.
need to go back through and rewatch all those episodes all
I
over
just,
again.
I don't have time because I'm too busy watching true crime stuff,
I know, right?
trying to stay on top of things.
I know. Hmm.
Don't yawn, ma'am. All right. Steph had a my boys love saying weenus and vagina. Sorry.
Mm. All right.
Um,
So plans for tomorrow. Tomorrow is
it's
um
Thursday.
yeah, I'm gonna
Oh,
wait until both you and JB are available because I don't want to go on to the deep dive stuff without
right.
JB. Um,
Well, and I am going to see Zabi tomorrow.
okay.
Um, um, sorry. So I will be on the road,
Okay.
but
On the road again.
on the road again. Did you see that they said that no, Chad Daybell's wife, what's her name? Lori might be testifying.
I did see that. It popped on my Twitter earlier. Yep.
I will, Steph.
Mm.
She's not. She's only hanging with me for a minute. She's not gonna hang with me very long. We're not even
Oh,
getting
really?
lunch.
How
No.
come?
Eh, life.
Oh,
Yeah.
life. Hmm.
But I'll get to hug her next. So
Well, that's good.
yeah. So
My daughter just told me what flagina is. Okay, so flagina is apparently the skin between your thumb and first finger.
yeah.
Yeah. Hmm.
Hmm. Okay. Are you
Well,
gonna be a minute, or are you leaving? What? Because if you're gonna be a
yeah,
minute, I'm gonna BRB. If you're not, then I'm not
yeah.
gonna BRB.
I'm gonna go ahead and close it up. Um, it's almost 5:30. I'm
I
gonna go in
am
there
not.
for dinner. What?
Steph is. I think Steph needs a nap. She needs a nap, Steph.
She's gonna fart for sure. That's weird. What's
I think
weird,
those are
Steph?
two. I think those are two separate sentences.
Mm-hmm.
Totally different thoughts. That's weird. I think for the vagina, ma'am.
Oh,
Why are
Zabi is
you?
gonna fart, not you.
Oh yeah, zombie always farts.
Tell Zabi I miss her. Zabi threatens to fart every time she gets squished. She does. She does.
Yeah. So
And
I'm gonna give her
sometimes
a
you don't
hug
even
and
have
she'll
to.
fart.
Sometimes you don't even have to squeeze her. You can just look at her sideways and she'll fart. So.
Can sleep in the bed next door or the chair
Mhm.
next door.
Mhm. Mhm. You're not telling
Oh,
why.
Spins. That's Elizabeth. I call her Zombie. Like Elizabeth. Elizabeth. It makes sense in my head. Don't, you know.
Yeah. But I'm going to go ahead and get out of here. You guys, we got a verdict today. I did not anticipate starting day 2 trial on a catch-up day, on a like speed watch day, and
Getting a verdict.
end up with a whole verdict.
A whole verdict. Not just a partial verdict, a whole
Right.
verdict.
And not even a well verdict, a whole verdict. Right? Right.
Right. Right.
Yeah, I'm gonna get out of here and go figure out what we're having for dinner. And then I need to do laundry and I need to get some
Oh,
other work
yeah.
done.
I gotta do
And
laundry too. You gotta go look for a package.
I do need to go look for a cape.
I can't believe they sent them separate. I ordered them together. I said same box.
Well, I didn't get it in.
Mickey Jor. Yes, there was a verdict.
Yes, there was a verdict. But we'll be back tomorrow. I'm not sure what the topic will be, but we'll
Oh, what
find one.
time? Because it's spring
Or
break.
yeah, and I'm not sure on time because we're on spring break. So I'm just kind of taking the mornings as they come. So but Mickey, do you want to
You want to
know? Do you
rewind
want to
or do you want
spoiler
us
or
to
do you
tell
want to
you?
rewind? Right. Do you want to rewind and watch it or do you want to be told?
Holt.
Mm-hmm. Mm-hmm.
Holt. It's different than turlt.
Do you want to be turled or told?
Holt. Ma'am,
Turled.
what did you eat?
Turled. Mickey said, heck no, I ain't rewinding. Only she didn't say heck. So Blake Scanlon was found guilty of first-degree murder. And he was also found guilty on the, what do you call it?
Aggravated.
Aggravated assault with a deadly weapon. So.
I love when you say, I wish she didn't say heck. She literally didn't say heck. I'm just saying.
No, she said, hell no, I ain't rewinding. That's what she said.
Wow. Wow.
I mean, that's what she said.
I mean, I'm just gonna say again, I don't know what you got into on your break, but they were out between 4 and 5 hours.
Yeah.
Yeah.
Ish. What do you mean, Lee? First degree stupid.
He's guilty of being first degree stupid.
Oh, okay. I was confused. Spin says Jenny's letting loose on spring break.
She is. She went to Daytona or something.
Yeah. Yeah.
Well,
All right, you guys, I'm out. QB, thank you for joining me. I am tired.
bye.
I'm ready to end this stream and
I see that.
go. Yeah, I want to go eat.
Yeah, I'm gonna go
And I
find something
know
to
that
eat.
I've got bags of groceries in there too on the counter that's waiting on me to go put up because
Mm.
husband will bring them home, but he's like, I ain't putting them up. So I got to go put groceries up and check on laundry and all that kind of stuff. So,
All right. I'm gonna jump down so you can do your thing.
all right. I love
I
you.
love you. See you
Thank
later. Bye.
you. Bye. All right, you guys, we'll be back tomorrow, late morning ish. So just make sure to have your notifications on if you don't already. Yeah, Mickey, we're on spring break this week. So, let me see. All right, I think I got everybody. Yeah, make sure that you hit the thumbs up button if you haven't yet. I would appreciate that. And if you are new and you've made it this far and you want to continue to hang out with us, then hit the subscribe button and ring the all notification bell. And then also, if you've made it this far, make sure to, if you're watching on the replay, that's what I meant to say. If you're watching on the replay and you've made it this far to hear these words, please put a hashtag replay in the comment section down below. And I will see you all tomorrow. I love ya. Bye.